Grunberg and Wade.
David Trappin, yes, that's looks like an email Kimmy sent him.
Okay, on January 22nd, 2020.
Yeah, we were in the middle of setting up a new arrangement where it was going to be Wood, Wilson, Grunberg, and Wade. And so with everybody's knowledge and consent, Kimmy was going to have letterhead done, business cards done. That was in fact done, and each of the individuals, Taylor, Nicole, and Jonathan, paid their 25% share of those costs.
All right. So then Exhibit 23, is that Kimmy transmitting the new logo for the new signage of the new firm?
Looks like it.
And then on the third page, it's the actual logo.
Yeah. And again, that sign was actually installed in the suite, and Jonathan, Taylor, and Nicole paid their 25% share of that new signage. And that was in January of 2020.
All right, let's look at Exhibit 55. At the bottom of the page is your email of Saturday, February 29th to Todd McMurtry. And it says, if you care about your campaign, take 10 minutes and call your best supporter, your best financial supporter, your best strategic supporter. 10 minutes, Todd. If you don't want to sue all 5 of them, I bet you we can sue. It says C, but I think you mean sue the New York Times. I see you around the corners, Todd. How about show me enough respect to give me a call? I'll pull out of the case. That'll hurt the same as I pull out of your campaign. That'll hurt you. I'm not going to do either one of those things, but damn it, you owe me enough respect to call me this morning for 5 or 10 minutes. Thank you.
And I don't know why, Todd, I don't know why I was upset with Todd about him not returning my call. Because I had been very good to Todd in trying to help him with his campaign. And I had been very good to Todd in trying to help him, whether it had occurred at this point in time, I think it had, where I had agreed to help him resolve an issue with his partner in his firm. And obviously I thought I'd been doing a good job for him and his client, Nicholas Salmon. So I don't know why. I don't recall why I was upset with him that he hadn't called me back.
Do you believe that you were the best financial supporter of his campaign?
Well, listen, that could be hyperbole, but if I gave the maximum amount as an individual, that would put me at the top of the list, wouldn't it? And then I had made the contributions to the PAC that was supporting his campaign. So I was a significant supporter of his campaign.
And in fact, probably the most significant.
Now the records would show that.
But you felt it at the time you said it.
PAC, well, I thought that I had gone above and beyond to help him. Whether I was the best, I know that I maxed out the individual contribution. I know that he had the PAC contact me, and it was my understanding that they would be supplying help to him along with other conservative candidates in the area in which Todd was running. I don't know what that area was. So I don't know how they took the $150,000 and how much of it was spent on Todd, how much was not, but I was trying to help him.
Let's look over at Exhibit 50. Deposition of defendant Lynn Wood, taken pursuant to notice and agreement of counsel. In Exhibit 7, you wrote this on February 22nd, 2020. Is that correct?
2:40 a.m. Yeah, it looks like I wrote it that morning.
Okay, so that's 5 days after you entered into the February 17th agreement with Taylor about fee splits. Is that correct?
It was
a yes or no, and then you can explain whatever you'd like to.
All right, well, let me go back.
This email was written 5 days.
That's clearly yes.
Okay.
You can do the math.
Good.
So the answer is yes, but go back and understand. I was extorted when I gave them that agreement on the 17th. And I was kind of playing with them. when I said, well, tell me what you think is fair. 35%, same thing we got in Ramsey. I said, well, I'll tell you what, I'll give you 50%. You think that's fair? I was not actually of the mind to give them a dime at that time. I was playing with them a little bit to see what they would do. And they went, oh, yeah, we'll take the 50 because they're greedy.
Would it be fair to say that the three plaintiffs were performed the majority of work on creating pleadings and correspondence and responding to correspondence and pleadings in the CNN versus Sandman case?
I don't know that I can quantitate it that way. Did they do what they had always done for me in terms of drafting pleadings, doing legal research, preparing motions? They had also looked into all of the body of what was said about Nicholas, not just related to CNN. And then Todd cut that off because he got a firm to do it. So they did what they did. I appreciate their efforts. I acknowledge what they did. And then we got into this dispute, which I settled with them on March the 17th of 2020.
Can you name any pleadings that you drafted completely on your own?
I wouldn't do that. I didn't. I've been practicing law for how long? I don't go out and have not, since they worked with me, I do not generate the first iteration of a brief or a pleading. That's what they're getting paid to do.
And did you ever tell the plaintiffs that you felt that the Washington Post case had significant value, approximately equal to the Sandman versus CNN case?
I can't remember the specific statement to that effect, but it wouldn't surprise me that somewhere along the way, when they were working with me, that I could have said we ought to maybe do as well in Washington Post as we did in CNN.
All right. Anything further on the part of the plaintiffs with this deposition designation?
We're done with this, Your Honor.
All right, then plaintiff may proceed.
These excerpts, ladies and gentlemen, are from the deposition of Nicholas Sandman. And I'll play myself. Ms. Brown will play Nicholas Sandman. And Mr. Glossop will play opposing counsel, Sandman's lawyer.
Your Honor, a little distracting, but could we take off the video behind the witness? I think they turned it on for purposes of my deposition excerpts.
Sure.
That's what it's, yeah, that's perfect.
There we go.
Thank you.
All right.
Andrew's a handsome man, but I can't take front and using their views.
Mr. Sandman, my name is Drew Beal. I'm counsel for Nicole Wade, Jonathan Grunberg, and Taylor Wilson, and the law firm of Wade, Grunberg, and Wilson, LLC. Thank you very much for your attendance here today. I've got a few follow-up questions for you. What's your current age, sir?
I'm currently 22 years of age.
Did you ever instruct Todd to tell WGW that it was never your intention to review any documentation of work performed by WGW?
Objection, attorney-client privilege. Mr. Sandman is not waiving the privilege.
Okay. Are you aware that Todd said that to members of WGW?
Again, objection, same objection. Attorney-client privilege. Mr. Sandman is not waiving that privilege, and this is outside of the scope of his agreed deposition notice.
Okay.
Excuse me, Honor. Just for the record, to be clear, the objections he's reading are objections posed by Mr. Sandman's lawyer.
That's what I said.
All right, so noted.
Let me ask you a hypothetical. If Todd had said that, that communication would have prevented you from seeing any documentation of work performed by WGW, wouldn't it?
Objection, same objection, attorney-client privilege and outside the scope of Mr. Sandman's brief deposition, way outside the affidavit.
Do you recall a visit to Lynn's property in South Carolina in the summer of 2020, either June or July?
You know, I'm going to let him answer that. I think that is outside the scope, but I'm hoping we will move on. Go ahead and answer that, Mr. Sandman.
Yes, I am not sure of the exact date, but I recall that visit.
Okay, and Todd was not with you in that visit,
That's correct.
but your parents were.
Correct.
How long were you there with Mr. Wood? Was it overnight?
No, I believe, under 12 hours. It was a daytime trip at most.
Okay, and you stayed there at that plantation called Tomotley Plantation in South Carolina.
Yes, for a couple hours during the day.
Okay, but you were there most of the day, like you said, about 12 hours.
Something like that, yes.
Okay, did Lynn ever tell you that he did not want you to consent to fee sharing with WGW?
Again, I'm going to object. It's attorney-client privilege and it's outside of the scope of the deposition.
Last question. Did Todd ever tell you, and I know there's going to be an objection, but I've got to get this on the record. Did Todd ever tell you that Lynn did not want you to consent to the sharing of fees?
Objection, privileged.
Can we go off the record and communicate for 1 second? Just mop up. See, there may be one or two more questions and then we'll be all done.
That's fine.
Thanks. I'll be just a minute. Just a few follow-up questions. I believe your affidavit is clear on this, but it is your testimony that after consultation with Todd, you executed your affidavit. Is that right?
That's correct.
And you consulted with him, relied upon his consultation, and executed the affidavit.
That's correct.
Okay, but you are invoking privilege as to what you discussed with Todd.
That's correct. He is here to testify about the affidavit. The affidavit clearly states he consulted with his attorney. He is not getting into the exact terms of that consultation.
Last follow-up question. Were you aware of any offers by WGW to provide documentation of the work that he had performed on your file in the CNN claim?
Honestly, I had no knowledge of any offer, no offer one way or the other.
Did you have an opportunity to review a thumb drive from WGW containing work that they performed?
I don't believe so, to the best of my knowledge.
Did you ever have an opportunity to review a chronology of the work that they performed on your claim against CNN?
I don't believe I ever saw one.
Were you aware of any phone conversation with Lynn Wood in which, let's put it this way, are you aware that Todd McMurtry testified that he had multiple conversations with Lynn Wood about Lynn's desire to blow up the deal, blow up the settlement with WGW?
By Mr. Reyes. Objection, form.
Do I still answer?
Yeah, go ahead.
Honestly, I was not privy or paid any attention to the conversations between Todd and Lynn. I honestly didn't really care.
Who drafted the affidavit?
I did, I believe the firm did, or Todd's firm did, and I reviewed it and attested to it.
Okay, is it possible, did you have any communications with Alston and Bird, the law firm representing Mr. Wood?
No, I don't ever remember communicating with them.
Okay, who explained the doctrine of proportionality to you, if anybody?
Objection. You are asking questions which you are assuming the answers to. And I think that's outside of
All right.
the scope as well.
As you sit here today, what's your understanding of the phrase quantum meruit?
I'm going to allow Mr. Sandman to answer if he understands, but really we are not so much coloring outside the lines. We are outside the coloring book now, Mr. Beal.
All right, if you know.
I could give you a guess, but my honest answer is I couldn't tell you what that means.
Thanks, that's all I've got.
Mr. Reyes, thank you then.
I think we're all done. Thank you, Mr. Sandman. I appreciate it. Huh? missing from this. So hold on, we didn't read the complete part. I'm sorry. We missed that part, so let's just pull it up. Just be 1 second, Your Honor, we skipped a page. Yes. Sorry, Your Honor. We skipped something and I think we got it now. We are on page 7, line 16, my question. Okay, later he brought in Linwood to assist in various lawsuits regarding that event that happened back when you were in high school. But Todd was always your central guy, right?
That's correct.
Nope.
I would say that in some ways, they both took on a kind of like a dual consultationship. I relied on Todd for very specific things, and we relied on Lynn for very specific things. But yes, Todd was a primary part of that.
Objection, Your Honor. There are 2 different transcripts. One, the later corrected version, which we have, and I believe, with all due respect, Mr. Thiel, he's reading from an earlier version. I have the up-to-date one.
Does it relate to this portion of the testimony?
Yeah, it's the same lines, but on a different page. I just want to make sure that we're all on the same.
Okay.
So other than the pagination, is there any difference?
So if you found me on that, that page number, because I'm not jumping around. So as soon as you find me, you'll be right with me.
Thank you.
All right, so it's not that there's a difference in substance, you're just,
Correct, Your
okay,
Honor.
understood. All right.
John, it's
Thank you. And then I'm going to refer to the plaintiffs, Nicole, Jonathan, and Taylor, and their firm as WGW collectively, okay?
okay.
It's a lot easier that way.
Okay.
You met WGW, Nicole, Jonathan, and Taylor with your parents through Lynn Wood. Is that correct?
Yes,
And, he introduced them to you as lawyers of his firm.
yes, or at least in my impression, it was that.
Okay. And so you knew that they would be working on your case in some capacity.
Yes,
All right. And you never objected to their working on your case in whatever capacity.
that's correct. I never objected.
All right. It would be fair to say that Todd McMurtry knew everything about your case against CNN and the other media outlets that you hired him to pursue for you.
As far as he knew his stuff, yes.
And you believe that he was a repository or a central location for all the pleadings and evidence and documents that had been generated in those cases.
Yes,
Is that correct? And when you had questions about the case, you and or your parents went to Todd and asked him, and you relied on his advice.
yes,
Okay. So the affidavit that you just testified about, it doesn't say anything about overall fee that you paid in the CNN claim. It talks mainly about the sharing of that fee with WGW. Is that correct?
I believe so, yes.
Okay, so you never objected to the overall fee paid to your lawyers, Todd and Lynn. You never disputed that that fee was reasonable, did you?
Correct, correct.
At some point, someone told you that your consent to this fee sharing was required. Is that correct?
To the best of my knowledge, yes.
Okay, so the issue that you addressed in this affidavit was your consent to fees being shared with WGW.
Yes,
Is that correct?
yes,
And you stated that you wanted to see documentation of the work WGW performed before you gave your consent to that fee sharing. Is that correct?
yes,
So you didn't object to WGW getting paid out of Lynn's share of fees, but you insisted to see records of the work before you consented. Is that correct?
that's correct.
Okay. So the issue really is more of your consent, not objection.
Objection, form.
You can still answer.
Could you please restate the question for me?
That's all right. I'll withdraw that one. It wasn't my best question. It's late and I want to keep moving. All right. Did you ever have an opportunity to review the time or work or documents that Lynn Wood created in this case?
I'm unclear what you mean by opportunity.
Yeah. Okay. Did you ever review Lynn's total time working in this case?
I can't recall, but to the best of my knowledge, no.
Okay. Did you ever review Todd's total time working on this file?
Not formally.
Okay. Did you ever develop an idea in your head of the total number of hours that were worked on this claim that you had against CNN?
No,
Were you ever asked that you needed to consent to a fee division in your claims against Washington Post?
could you explain what you mean by fee division?
Sharing of fees between Lynn and WGW in claims that you had against the Washington Post.
To the best of my knowledge, I don't think I ever was involved in any fee splitting between Lynn and WGW.
All right. Did you ever ask Todd to break down the pleadings in his file that he believed WGW had created and the ones that he had created, or was that just something that never came up?
Can you ask that again?
Did you ever ask Todd to review all the pleadings that had been created in this case to see the ones that he had created and the ones WGW had created?
I don't believe I ever asked Todd to do that, no.
Okay, thanks. Did Todd ever tell you that he believed that WGW's fee was reasonable based on the work that they had performed?
I'm going to object. That is attorney-client privilege. He is not waiving his privilege per my letter.
Just 1 second, Your Honor. That's the end. I think that's the end, Your Honor. It was a little unclear, sorry.
All right.
Mr. Sandman, come off.
For sure now. And Ms. Brown, you can step down. I'll ask the plaintiffs if they have any other evidence to present.
before they do that, Your Honor? We would request that now that it's been discussed in his deposition by the plaintiffs, we would ask that the affidavit of Nicholas Sandman in its entirety be tendered in and accepted in evidence.
All right, I do believe the affidavit was referenced in the
Your Honor,
designation.
he's got to have a witness, put it in. It'll come in his case.
It's been authenticated. He's testifying to it.
It absolutely has not been.
I'm sure they would
authenticated
want the whole
in our
affidavit in.
court.
Well, let's not interrupt each other. All right, why don't we have, just council approach so I can put this on the record here. Understood. Oh. No, but I mean, what I'm hearing is this objection. Essentially saying that the affidavit is referenced in his testimony. And so
He's got.
in fairness, it should be. And you could authenticate it through the deposition itself because it's true and accurate, right? And he's saying in context and fairness, things really look at this. But it should be done now. And again, I don't think it makes much of a difference. When, but he's actually pointed out, I think we'll get that. Ability. Unless you think that. Don't relate to the affidavit.
Well, sorry. There's no foundation of it, and they're going to offer it in evidence. So he didn't match your truth by itself.
And again, this is the weird incorporation aspect of it, but the fact is, I guess you say, feel free to jump in. But they take that is a true and accurate copy of the affidavit.
You like a cocktail of ginger, apple cider vinegar, and honey, and drink it warm like eating tea. By itself, it help.
You drain on it.
Yeah. Helps. I got this concoction. In the morning, see when go in, that smell like a garlic close.
At this point, if you want to read that line of the deposition that says it's true and accurate copy, then read in the affidavit. In line with what I've already said about the hearsay notification, everything.
Yeah. I'll do that.
Over plaintiff's objection. All right.
Now.
You want it now, then do it.
Yeah, just don't have it. I'm just saying magic. It doesn't plug in. He's got it.
It has to be from that line.
And you want to put it in there. That's fine.
Well, I think he's entitled to it under the rules.
Yeah.
Both that line and the affidavit.
Gotta read that.
Yeah, okay.
Yeah, but he doesn't. It's not read in the evidence. He did not read it. He has to do exactly. Nothing less.
Well, so, and I know that the position was that it shouldn't be an exhibit. I think it does get to be an exhibit because it's incorporated. So if it is getting.
Yes, yes, Your Honor. That's fine as long as it's not, that it's clear that I still have the right. Make a record verdict or close to it. Sure. That I'm not waiving that by putting this.
Well, let's
And I'm
proceed.
going to read the testimony and read the affidavit. But he's put it right in issue.
That's it.
Yeah.
Why so?
Well, because no. Have read it, he had the opportunity. Have read it, they've authenticated when he comes in as a document.
Then there's a document.
He can memorize it, say it, or he can read off it.
Yeah, at some point you will get to read it from start to finish to the jury.
Well, I just do it now. I'm not going to.
Well, Mr. Mr.
Tendered it. You've already said it doesn't go out.
Well, there's a difference between putting it down and this work.
But they brought up is direct the contents of the act. So I should be allowed to read the affidavits.
All right, members of the jury, the defense has asked that other portions of the deposition by Mr. Sandman also be introduced for your consideration to give the context of the testimony, and I'm allowing it at this time. So, Mr. Wood.
Yes, Your Honor. May I proceed, Your Honor?
You may.
And I'm going to read some excerpts from Nicholas's deposition, very brief, but I'll play the lawyer and him, so we'll save time. And I'll make it clear who's speaking. This is at page 5, line 15. Good afternoon, Mr. Salmon. My name is Ibrahim Reyes. I'm an attorney and I represent Lynn Wood and his law firm, L. Linwood PC. Thank you for being here. Mr. Salmon, thank you. Question. I'm going to ask you a few questions regarding the affidavit that you provided in the past. And then it was marked for an exhibit. Do you have it with you, Mr. Salmon? Answer, I have a copy of it. Yes. Great. Okay, we will be referring to your affidavit. Do you have it with you now? Yes. Would you check page 4 of your affidavit, please, and tell me if it is correct that you signed it on February the 8th of 2021? Answer, that's correct. Question, and that is your signature at the top right. Answer, it is. Question, did the affidavit accurately describe the events of July 24, 2020? Answer, yes. Question, now your affidavit has 13 paragraphs. Is that correct? 13 numbered paragraphs. Answer, yes. Are paragraphs 1 through 13 of your affidavit accurate and truthful? Answer, yes. Now to read the affidavit of Nicholas Salmon.
All right, why don't you give that a defense exhibit number, and this will be over plaintiff's objection for the reasons previously stated, unless you've got some new things to add.
And it would be my defendant's exhibit 6.
All right, Mr. Beal?
Objection, Your Honor. And yeah, do you think
We can. All right, Mr.
I can express that.
No. Read the jury. Because it wasn't. It was an act. Notice of deposition. So different copies, so I don't know if it's been authenticated. But does he have the right to testify to in this case, say, I looked at it, not relied on it or something? Makes it clear, you know, that it's even in the same.
This is the arguments in your motion.
Your Honor, it's the notice of deposition is called an affidavit. It's an exhibit to this deposition.
Well, okay.
Yeah.
Motion, but we probably rest.
It was it.
And at this point. So I do figure out, we cross everything inside.
So we've covered that bridge. I think now what he's saying is another aspect.
May I proceed, Your Honor?
Yeah.
Affidavit of Nicholas Sandman. I, Nicholas Sandman, being duly sworn, depose and state as follows. My name is Nicholas Sandman. I am 18 years of age and of sound mind, and I am capable of making this affidavit. In January 2019, my parents engaged L. Lynn Wood, PC, LLWPC, and Hemmer, DeFrank, and Wessels, PLLC, Hemmer, to represent them both individually and in their capacities as my parents and natural guardians with regard to potential tort claims against entities and individuals who had published false and defamatory statements about me. At the time, I was a minor. I turned 18 years old in July 2020. My parents signed a letter from attorney L. Lynn Wood, dated January 28, 2019, confirming the engagement. The letter did not mention attorneys Nicole Wade, Jonathan Grunberg, or Taylor Wilson, or indicate that they would be working on my case. I did not have a separate engagement agreement with any of those three lawyers. After investigating potential claims, LLWPC and Hemmer filed a number of lawsuits on my behalf. I viewed Mr. Wood as my lead counsel in those lawsuits. Mr. Todd McMurtry from Hemmer was my primary contact. Although I met attorneys Nicole Wade, Jonathan Grunberg, and Taylor Wilson, and knew they were working with Mr. Wood on my cases, I did not know exactly what roles they were playing or the precise relationship with them, LLWPC, and Mr. Wood.
All right, Mr. Wood, if you could pause. Mr. Wood, do you want to
Yeah.
clear it out?
Thank you, Ron. Steve?
You may.
I had just finished saying I did not know exactly what roles they were playing or the precise relationship between. I'm just picking back up where,
Then pick up where you left off.
between LLWPC and Mr. Wood.
Objection.
All right, just pick up where you left off, Mr.
The
Wood.
sole reason we retained LLWPC was to have Mr. Wood handle the case. We chose him for his experience and success in handling defamation cases. With all due respect to Ms. Wade, Mr. Grunberg, and Mr. Wilson, we had never heard of them, and they were not the reason we hired Mr. Wood's law firm. In early 2020, one of the cases in which LLWPC and Hemmer were representing me settled, and then refers to it as the settled case.
Objection, Your Honor.
Yeah, we're not going to go beyond the text of the affidavit itself, Mr. Wood.
I was just explaining that it was in quotes. I mean, in other words, he said, we're representing me settled, and then paren the quote-unquote settled case.
Okay,
End
all right,
quote.
just stick to the text. Thank you, sir.
Mr. McMurtry did not receive the settlement funds from the settled case until late July 2020. On July 24th, 2020, I met with my legal counsel from Hemmer, Todd McMurtry. This was an independent consultation with Mr. McMurtry. Mr. Wood played no part in it. At that point, I was 18 years old. Mr. McMurtry showed me a copy of a document entitled Settlement Agreement and Mutual Releases, dated March 17th, 2020, and between LLWPC and Mr. Wood on the one hand, and Wade, Grunberg, and Wilson, LLC, WGW, Nicole Wade, Wade Law, LLC, Jonathan Grunberg, J.D. Grunberg, LLC, Taylor Wilson, G. Taylor Wilson, LLC, and Grunberg and Wilson, LLC, on the other hand, quote, settlement agreement, end quote. The settlement agreement indicated that LLWPC would pay to WGW $843,750 from the fee that LLW received in the settled case. Mr. McMurtry also provided me with a document attached hereto as Exhibit A. Among other things, the document stated, quote, L. Lynn Wood requests that I consent to the agreement, end quote, and included a place for me to sign, including my consent. I understood during the meeting that Mr. Wood was asking me to authorize him to use the fees he earned from the settled case to pay $843,750 to WGW under the settlement agreement. After consulting with Mr. McMurtry and receiving his independent advice, I declined to sign the document attached hereto as Exhibit A. I decided that before I could make a decision about giving consent to the agreement, including the $843,000 payment described in that document, I needed to review time records or other documents showing the work that attorneys Nicole Wade, Jonathan Grunberg, and Taylor Wilson had performed on my case. $843,000 is a lot of money. I requested that information so I could assess whether the portion of LLW's fee in the settled case that was paid to WGW under the settlement agreement was in proportion to the services that Ms. Wade and Mr. Grunberg and Wilson had performed on my case. Mr. Wood did not do or say anything to discourage me from giving my consent to the payment he wanted to make under his settlement agreement with other lawyers. I made the decision to request documentation from them on my own after consulting.
All right.
It's an acting class. I mean, you just need to read the words.
All right. Overruled.
After consulting with I made the decision to request documentation from them on my own after consulting with Mr. McMurtry and receiving his independent advice. I understand that my request for documentation was communicated to Nicole Wade, Jonathan Grunberg, and Taylor Wilson and/or their attorney. However, to date, and for reasons that I do not understand, I have not received any information or documentation from Nicole Wade, Jonathan Grunberg, or Taylor Wilson reflecting the work that they performed on my case. Accordingly, at this point, I am still not willing to consent to the payment from LLWPC to WGW that is called for in their settlement agreement until such time as they provide documentation of their work. As of the date that I am signing this affidavit, I am no longer represented by Mr. Wood or LLWPC. Further affiant saith not, Nicholas Salmon, notarized, and attached Exhibit A, which reads, consent of Nicholas Salmon. I have reviewed,
Yeah, well, there's a further statement in there. All right.
I have reviewed the settlement agreement and mutual release between L. Lynn Wood PC and L. Lynn Wood on the one hand, and Wade Grunberg and Wilson LLC, Nicole Wade, Wade Law LLC, Jonathan Grunberg, JD, Grunberg, JD Grunberg LLC, Taylor Wilson, G Taylor Wilson LLC, and Grunberg and Wilson LLC on the other hand. Todd McMurtry, my legal counsel, has indicated that L. Lynn Wood requests that I consent to this agreement.
Which is,
We're acting it out.
I'm not acting it out.
I can't regulate a Southern accent, Mr. Beal, so.
May I finish?
You can finish.
Accordingly, I agree. Accordingly, I hereby consent to this agreement. Then there is a signature line from Nicholas Salmon, and it is unsigned.
All right, so that publication and its tendering of Defense Exhibit 6 is over plaintiff's objection. Any further evidence on behalf of the plaintiff?
Just ask Mr. Wood to read the signature block that has the date.
The date, and I believe that is, should be included as well, Mr. Wood?
Only at the beginning, not at the end.
Sworn to on the signature line, Exhibit A.
No.
Exhibit A is not signed.
The affidavit.
The affidavit is signed, Nicholas Salmon, sworn to and subscribed before me this 8th day of February, 2021, Ashley Combs, Notary Public.
All right, and with that, any further evidence by the plaintiff?
Nothing, Your Honor.
All right, so members of the jury, this time the plaintiff rests. There's now some things I have to take up outside of your presence. I'm hoping I can limit that to around 15 to 20 minutes, and we'll be back with you then. All right, if you could step out, please.
All right, the jury.
Your Honor,
All right, the jurors have stepped out. Mr. Wood?
apologize. I need to run down to the restroom. It won't take a minute or two.
Okay, let me check with you first on one thing. You said you had a witness potentially you were going to call first on deck when it's defense case. Is that witness here? You said you might have one or two witnesses other than yourself who are going to testify. Are those witnesses here en route? Are they available?
We had asked them to be here at 11 o'clock.
11.
I told you all we needed to have them on deck around 10 though, so we can't burn an hour.
We'll talk with Dan Diffley while I go to the bathroom.
Okay. Can they present their motion while you step out?
Sorry,
Can they present their motion while you step out here?
motion on what?
I don't know if the plaintiffs have any motions.
Yeah, you're
They have some
I would need-
motions.
I would need to be present for their motion. I need to hear what their motion is to respond.
Okay.
I won't be gone but a second. And we'll get Mr. Diffley to see if he can get Jordan.
All right. Why don't you go ahead and reach out to those witnesses now, and we'll be back at 10:05 to hear motions.
And I assume, Judge, incorrectly, that the argument on the motions for directed verdict would probably take something at or close to an hour. That's why I told them 11 o'clock. I didn't want them cooling their heels.
Okay. Well, I don't think we're going to have an hour. I referenced in Friday that you can incorporate arguments, you can describe them, you can preserve them, but I don't think we need an hour. And you can go to so we'll be back at 10:05. All right, and we'll take it up.
Thanks very much.
On the left, it's like moving on. It was all, you can feel it now. Yeah. Feel the air.
See, I'm trying to sneak shit in when you say something.
So fine. Yeah. Get yourself. What's their exhibit number of the contract?
102, I believe.
Check that. It's in the second floor.
Or come to order, remain seated.
Thank you all. Please be seated. Can we get Mr. Beal back?
May I advise the court of something?
Well, we don't have counsel here, but
Kirby is here.
oh, great. Okay, glad to hear it.
Can you confirm 102? Give him a chance.
Yes, confirmed.
All right, we're back on the record. Plaintiffs have any motions at this time?
Yes, Your Honor. At this point, plaintiffs move for directed verdict. on the issue of the breach of contract claim, insofar as no evidence has been presented that they were not members of the firm, and that any rule or restriction regarding Rule 1.5 would apply. Furthermore, the defendants renew their motion in limine on that issue for two reasons. One, there is no evidence that Rule 1.5 would apply, as comment 8 holds, and the evidence has been uncontroverted that they were previously associated in a firm. Furthermore, there is, as we cited in our brief, an abundance of case law that says Rule 1.5 should not be a defense to a claim for fees, and the judge is not required to charge the jury on the issue of Rule 1.5. And this follows basically a long line of Georgia law that Your Honor cannot have the jury decide the law and the applicability of the law. So while we're moving for a directed verdict on the contract claim, we're also moving again in limine to limit the testimony regarding the applicability of Rule 1.5. And I believe that that is not only in line with all the evidence that we've got in this case, but the law that ultimately we can't really charge the jury on 1.5. And so if we can't charge the jury on, we are driving straight toward that wall of what are we going to do when we get there? And the evidence is undisputed. In the alternative, well, that's the substance of our motion. Your Honor has seen it in the motion in limine and in the motion for summary judgment and in the renewed motion for summary judgment. So we had the two mega giant motions out there, and then we had supplemental motion in limine filed on February 27th of this year. Plaintiff's brief in support of supplemental motion in limine that contends that defendants' defense of Rule 1.5 should be the subject of Your Honor's motion in limine, striking reference to 1.5 as a defense to the claim. Certainly, Mr. Wood may use it as a state of mind defense, but it should not be a defense to the underlying claim. And all the evidence has been uncontroverted on that issue.
May I respond?
Any questions that I need to field?
On that point, Mr. Beal, I know we've looked at the case law pretty deeply on Georgia rules of professional conduct as applied to contracts. Have you ever looked beyond that and found anything about public policy contracts and whether public policy had an issue of fact that a jury had to decide? I mean, has it even ever reached that point outside of the Georgia rules? Have you seen other essentially public policy defenses ever reach a jury or not, or said that they shouldn't reach a jury?
Well, Your Honor, we've all done extensive research, and Mr. Wood hired Alston and Bird, and they did this mega document summary of the law, and then they edited it and did another one, and they searched the nation, and there are two cases outside this jurisdiction that say this is how you determine whether somebody's a member of a firm for fee splitting, and they look at how you hold yourself out to the public. And they are cited in the brief in the report to Mr. Wood as a problem for him, saying, hey, this can be an issue for you. These other jurisdictions have determined. But it did not refer
Your
to
Honor,
comment
excuse me.
8.
He's just
Secondly-
there's no testimony from Mr. Burby.
He's just making an argument, Mr. Wood. I don't think we need to be.
Yeah, but he's arguing what Mr. Burby did, and Mr. Burby's here and is
Okay.
prepared to testify to it.
All right. Well, we don't need to be interrupting argument.
And secondly, the issue in other jurisdictions does not refer to comment 8, which holds that previously associated in a firm negates the applicability of Rule 1.5. And I think there are other cases that say, in fact, the Eichelkamp case that we've talked about a lot talks about that the purpose of the rule is to protect consumers when they hire a lawyer and protect their confidences. It should not be used as a defense to a claim. And it cites the public policy as to why the rule was created. And as we talked about the innovative images case in our motion in limine, that they that the ethical rules cannot void agreements unless they were void at the time of signing. And clearly there was nothing void or voidable about this contract at the time of signing. We're not getting into fraud. Obviously, that's an ultimate issue of fact for the jury. And the reason I bring this up is not just to burden Your Honor with one more legal argument, but because this is an issue we are going to have to resolve before we charge the jury. Because we're not really in a position where we can charge the jury on the law and on the applicability of Rule 1.5 and whether it could potentially void a contract. But the innovative images case is kind of directly in response to what Your Honor just asked, that it cannot void the agreement. And so there is no evidence that they were not previously associated with the firm. And so we would ask for, we would renew our motion in limine and we would move for directed verdict on the contract claim.
All right. Mr. Wood, I don't need a response at this time. I'm going to defer ruling on that. We can talk about it again at the charge conference if we need to, or if it's necessary for briefing during a J&OV point.
I might just briefly comment on one aspect, very briefly, but it's important. I think it'll cut to the chase of what you've got to do here.
I'll give you a minute, Mr. Wood, but I'm telling you, I'm not really, at this point, I don't really need the full.
I've never heard of a plaintiff move for a directed verdict after the close of his evidence. Now, he may move for a directed verdict at the close of all of the evidence, but our evidence hasn't been put up yet. So it's totally procedurally improper. And to allow it at this stage would be error. He can make his motion for directed verdict at the close of all the evidence. So it's improper at this time, and that's the point I wanted to make, and I think I'm right. All right?
All right.
I know I'm right.
I know that came up at our civil trial last month, so I've seen it before, but as I mentioned, it's a moot point here because I'm not planning to grant it at this time. Any other motions on behalf of the plaintiffs?
No, Your Honor. We'll give Your Honor some additional case law about public policy concerns not being as not being appropriate for jury determination as they are issues of law be decided by the court.
All right. So, Mr. Wood, as I kind of indicated on Friday, I'll give you 10 minutes to make all your necessary motions here. I would say you preserve them by having the conclusion, kind of mentioned, but in terms of an hour's worth of supporting argument and any other things you're wanting to say in support, I'll be deferring final ruling, and so I don't need to hear all that at this time.
Thank you for giving me the opportunity to briefly respond, make my motion. And I don't intend to talk for an hour at all. It's a very simple motion, at least the first part. So, Your Honor, at this time, the defendant, Lynn Wood, moves for a directed verdict on the claim that L. Lynn Wood is liable for the payment to WGW of the attorney's fees share. It is undisputed in this case, based on Plaintiff's Exhibit 102, which is the March 17th, 2020 settlement agreement, that the only entity that was responsible under that agreement for paying or sharing a fee was L. Lynn Wood PC, not L. Lynn Wood. And that's referenced clearly in paragraph 1 of the agreement and its subparts, paragraph B, paragraph D. So when you look at it, the contract between the parties with respect to the division of fees, that contract was only between the plaintiffs and L. Lynn Wood PC. So L. Lynn Wood individually cannot, as a matter of law, be held liable by verdict or otherwise for the non-payment of the fees. That was not L. Lynn Wood's obligation under the agreement. It was solely the obligation of L. Lynn Wood PC. We've been through, and Your Honor has heard, the extent that these lawyers were aware of that fact. They consulted with Mr. Beal, and they made that agreement. Now, they may not like it now, but as I believe somebody pointed out, that's a card played. They can't rewrite the agreement. So on behalf of L. Lynn Wood, individually, I move for a directed verdict because there is no evidence and the contract refutes the idea that L. Lynn Wood could be responsible individually for any division of the fees. And I have one other, but I'll stop there unless you.
Let's just do them in bulk. So I'll note that first one. And now second motion that you might have.
And this, Your Honor, I understand your position and I agree with you. This is really a motion that's more fulsome at the close of all the evidence. But just to make the record now, so that it's not claimed that I waived it in any way, I'd move for directed verdict on behalf of the defendants for the claim that there was evidence of fraud in the execution. The evidence presented by the plaintiffs is totally void of any evidence of fraud in the execution. I recognize fully that they talk about things I said in February. I'm not going to pay you anything more than quantum merit. I'm not going to pay you a damn dime, I think. That's fine. I changed my mind. That testimony will come out during my examination, but here's what's undisputed. That the statements that they rely on by me were known to every one of them before they signed the agreement of March 17th of 2020. There was no failure to disclose. I told them exactly what I was thinking. I told them exactly what I might do. There was absolutely no fraud in what you can't be guilty of fraud if you disclose what you're doing. So I don't believe, and I've said it for a long time in this case, Judge, I don't believe there's one act of fraud that they are able to prove. They rely solely on the fact that the payment was not made. And that's a breach of contract. Under their theory, you could take any breach of contract and turn it into a fraud case. That's not the law. So I move for directed verdict on and importantly, the fraud in the execution claim. That's what it is. It's not fraud in the inducement. But to the extent they rely on evidence of my statements prior to the signing of the agreement, my statements were fully disclosed, fully known to them, and they entered into this agreement with me anyway. So we moved the directed verdict on that point also, Your Honor.
All right, thank you, Mr. Wood. As indicated on that second motion of fraud, I'll defer ruling on that. Mr. Beal, do you have any response to the first aspect of it, of whether Mr. Wood can be held liable personally solely as it relates to the lawyer fee that was supposed to be transferred?
Yes, Your Honor. The evidence is uncontroverted that it's a single member LLC, and Lynn Wood fraudulently and in violation of bar rules and in violation of the contract took the money secretly that nobody, including his own lawyers at Alston and Bird, knew about and transferred it over. So he procures the breach of contract by taking the money from a single member LLC solely by his own act. There was no one else involved on the board of directors. Furthermore, where does the money go? It goes in his pocket. So,
I mean, to that extent, I'm hearing you making essentially a corporate veil piercing argument. Is that an accurate label?
you could call it that, Your Honor, but you don't have to when it's a single member LLC and there's no one else involved. As to the failure to disclose, we've heard evidence.
I'm not. I already said I'm deferring on that.
Okay.
I'll get back to that, Mr. Wood. So, do you have the site handy on that single member LLC point?
I get it for you, Your Honor.
Okay. All right. Mr. Woody, I'll give you a minute here.
Under the contract's terms, there cannot be a verdict against L. Lynn Wood for failure to pay the fees. Now, if he's successful and gets a verdict against L. Lynn Wood PC, then he would be able to deal with the question of whether the corporate veil was pierced. This is not a corporate veil case. This is a breach of contract case. The contract is clear. It's unequivocal. L. Lynn Wood cannot be held liable for breach of that contract. If he's successful, I pray that he's not. But if L. Lynn Wood PC is found liable, then his judgment and verdict and judgment is against L. Lynn Wood PC. Then he can proceed to exercise whatever rights he has, if the case is affirmed on appeal, to exercise his rights to pierce the corporate veil to get to whatever L. Lynn Wood has in terms of financial ability to pay it. So he can't jump ahead and use that now to change the terms of an unequivocal, undisputed contract. Thank you.
And I'll just say, Mr. Bill, before maybe you've got this site now, but my main concern here is that I think I disagree with Mr. Wood in that these don't have to be sequential actions. I think you can decide whether the veil is pierced at the same time as you decide whether the corporation itself is liable. But the question I'm now having is occurring to me is whether this is an issue of fact, if this is something the jury needs to be charged on, and just how that's decided in this case that we can get beyond the PC all at once. So
And we did, I'd remind Your Honor, two things on the breach of contract. We have allegations in the complaint that he is liable because of his actions for breach of contract. And number two, we also have breach of contract claim against him for the non-disparagement because, as Your Honor remembers,
he hasn't moved. That's not form or included in this directive verdict. So I know it's in your complaint. I know it's part of, but I'm just saying I didn't see it in anyone's jury instructions, and so it's questioning for me whether this is an issue of fact or just something I'd have to find as a matter of law.
We'll brief all that for you, Your Honor.
Okay, so we'll put a pin in it.
And Your Honor is correct. The motion I made only goes to the payment of fees, not to, I signed on as responsible.
It's right there it's in the contract. I think that's clear.
And I don't think there's an issue of fact as to who under the contract was liable for the payment of the fees. It was not L. Lynn Wood. It's undisputed, and that's why I moved for directed verdict.
All right, so at this time, having deferred on all those, it would be time for the defense to present some evidence if they want to. I've heard that Mr. Burby is here. Is that who you intend to call as your first witness?
Yes, Your Honor.
All right, well, let's go ahead and Mr. Burby, come on in and take the stand. If we could clear any of the materials here that perhaps the plaintiffs may have left behind.
Yes, Your Honor.
You're gonna have to go out and call for him, Mr. Exum.
I'm going to go in the hall.
Or just and call him to bring him in.
If we ask the monitor to be cut off, it flashes different screensavers and it's distracting. And the jury's having to see it while they're looking at the witness. So it just seems like we could turn that monitor off.
Affect,
You also want to keep it up there, Your Honor, because it prevents the images of the jury to be brought.
I can't hear.
if you could, I understand your point. Now we'll turn it off and you can let us know if you need any multimedia during your direct. So Deputy Scott, if you happen to have the remote there, if we could turn that off.
We don't have any multimedia, I don't think.
Understood. I'll keep it simple.
I love the idea.
Michael has them.
All right, Deputy Scott, if you could go ahead and start rallying the jury, give me a thumbs up when they're ready to come out. Is Mr. Exum conducting this direct?
He is, Your Honor.
All right.
I'll let Burby off the hook.
Yes.
All right, I think we're ready. You can approach. You do what you gotta do.
Most of it'll be in here for your convenience.
Your Honor, maybe my apologies. I need to slip out and go to the bathroom.
It's fine.
And I will, if I ask for the proceeding to stop, I'll just slip out and come back and go.
Understood.
Thank you.
Thank you, Deputy Scott. Please be seated, everyone. All right, members of the jury, thank you for your patience. And at this point, as I'd mentioned, the plaintiffs have rested. And so now the defendants, should they choose to do so, may present evidence. And so at this time, does the defense have any witnesses or evidence to call?
Yes, Your Honor. The defense calls Mr. Joey Burby, who is seated.
You can swear the witness.
Swear affirm that the testimony should get a closer vote connected with the truth of the God.
I do.
Committee seat. Could you please state your name for the court while speaking to the mic?
Yes. My name is Raymond Joseph Burby, B-U-R-B-Y. I go by Joey.
Judge, could I ask Mr. Burby to pull that microphone a little bit closer?
Thank you, sir.
Mr. Burby, thank you for being here today. Could you please tell the jury what kind of work you do and where you practice, please, sir?
Sure. I'm an attorney. My practice focuses on civil and criminal litigation. I'm a partner at the law firm of Austin and Bird. That's where I practice at.
Now, not to get ahead of ourselves, but do you have a partnership agreement with Austin and Bird?
Yes.
Okay. Now, how long have you been a partner?
Just over 5 years at
All right.
that firm.
And how many years have you been practicing law?
I passed the bar and became a licensed attorney in Georgia in 1996, so just shy of 30 years.
Okay.
My math is right.
Now, just for the jury's benefit, were you or had you ever practiced at another firm before Austin and Bird?
Yes,
And were you a partner at that firm?
I was.
What was the name of that firm?
Well, there are two firms. The firm I was at immediately before Austin and Bird was called Bryan Cave. And then before that, I was at a firm called Powell Goldstein, and I was a partner at both of those firms.
Is that where you met Mr. Wood?
Yes, I believe first at Powell Goldstein.
So the two of you practiced together?
We were both partners in the firm. I don't recall us ever working together on a matter, but we knew each other by virtue of both being partners there.
Were there any of the plaintiffs who were also partners of that firm?
Nicole Wade was a partner, I believe, at Powell Goldstein as well.
Okay. And how many years did you practice in the same law firm as Mr. Wood? About.
I'd have to just give you an estimate. I believe I was at Powell Goldstein before him. I think he became a partner there a couple of years before we merged with Bryan Cave, a bigger law firm. And then he stayed at Bryan Cave for a few years after that merger. So I would guess 5 or 6 years maybe, but it could be more, it could be less, but around that.
Okay. Now, shifting gears, you were formerly in counsel of record on this case, correct? With your partner?
That's correct. Yeah.
Mr. Marquardt?
Yes, Chris Marquardt and I and the firm and others at the firm were counsel of record for Mr. Wood and his law firm in this case initially.
And how did that come about?
Well, after the plaintiffs filed the lawsuit, I believe in August of 2020, Mr. Wood asked us to represent him in the lawsuit, this proceeding, him and his firm, and we agreed to do that. We had been representing him and his firm for 6 months or so, maybe longer, in connection with sort of the dispute with the plaintiffs before there was, a lawsuit filed.
Let me ask a better question, Mr. Kirby. How did your representation of the defendants come about?
Mr. Wood contacted me in early March of 2020 and asked if I could help him with a matter.
And that would have been about, well, you said early March. Bear with me. So I believe it's, you can refer to Defense Exhibit 95, 96.
Yeah.
Does that look? Does that look like an invoice from Austin and Bird?
It does.
Yeah, excuse me. This is in the big defendant's binder, number 595.
Thank you, sorry.
No, excuse me. So page 2, does that look like the intake conversation on March the 4th?
There's a notation by Chris Marquardt on March 4th that he talked, looks like, with me and did other things on that day. So, and that's the first date or first service that's identified in March. So if where you're going is that's an indicator of when we began representing Mr. Wood and his law firm, I think that's about right.
Defendant's tender exhibit 95 into evidence.
Any objection to D95?
None, Your Honor.
D95 is admitted.
And if I can direct your attention to Exhibit 15. Big binder. I think it's that one.
Okay.
Does this look like the engagement letter Austin and Bird signed with Mr. Wood and the LM1PC?
Yes, this is the letter that we wrote to Mr. Wood, confirming his engagement of our firm to represent him and his law firm in this matter, dated March 6, 2020.
Okay. Now, in this time period, what was what do you recall was the purpose in your being engaged by Mr. Wood and LM1PC, by defendants?
I mean, to the best of my memory, Mr. Wood explained to us that he was in a dispute with the plaintiffs, Nicole, Jonathan, and Taylor, related to sort of the separation of their practice. They had been practicing together. They were no longer going to practice together, and there was disputes about expenses and fees. And I believe they had hired an attorney, and maybe there was a threat of a lawsuit or litigation. And Mr. Wood did not have counsel at the time and wanted help dealing with the situation and advising him on how to handle the situation.
Would it be fair to say that he wanted you to help settle that dispute?
To the best of my memory, this was 5 years ago. I don't think it was clear initially that he wanted us to help settle the case. That is ultimately what happened within a matter of weeks. But I mean, to the best of my memory, initially it was he just wanted help and advice on how to deal with the situation.
But as we know from evidence that's already been admitted, and I refer you to P102, the March 17th agreement, that there ultimately was a settlement.
There was.
There was.
Correct.
Didn't mean to talk over you. Now, during that time, did Mr. Wood ever say or do anything that gave you an indication that he didn't intend to honor those terms?
He did not.
He never at any time said, Mr. Burby, I want you to help me pull the wool over my former colleagues?
He did not say that or indicate anything to that effect.
And is it fair to say that, to the best of your recollection, once the decision was made to settle, he had every intention of doing so?
Objection.
Yeah, I think
Mountain calls for
I think
speculation.
you could rephrase.
Testimony.
I will rephrase, Your Honor. I apologize if I'm repeating myself, but did he ever say or do anything that indicated he did not intend to live up to it?
He did not. I would say everything Lynn said to us and did indicated that he intended to comply with the settlement agreement, that he was pleased with the settlement agreement. We had no reason to think that he was not going to comply with the terms.
And did you help with Mr. Marquardt? Did you help draft the settlement agreement?
Short answer is yes. To the best of my memory, Chris, my partner, took the lead on drafting the settlement agreement and had communications with the plaintiff's attorney, Mr. Beal, about the agreement and with Mr. Wood. But I would have seen drafts and was copied on emails. I don't remember if I had comments or changes. So I was involved, but I would say Chris was the primary author from our side.
And is that a normal practice?
For there to,
I'll clarify.
yeah.
is it typical for lawyers working together drafting an agreement to have an exchange of ideas, share documents, analysis, that sort of thing?
I think so.
And you believe that was done in this case?
Yeah, what was done was what I mentioned, in terms of talking with each other, Chris and I, Chris talking, or both of us maybe talking to Mr. Wood, and then there were discussions with the plaintiff's attorney as well.
Okay. Thank you. Now, shifting gears to the next topic, client consent. When, during your representation of the defendants, did that issue arise? When did it come to your attention?
Well, if you mean the clients whose cases are identified in the settlement agreement and whose fees were being split, and the issue of whether consent needed to be obtained from those clients, that did not become an issue or a subject of discussion until, I believe, May or April, May of 2020. The issue of consent more broadly came up in, I believe, late April, related to another case that Mr. Wood asked us to evaluate. I'm sorry if that's confusing. I can try to explain more, but
I think I got it, but I'm going to ask another question to make sure the jury understands. So were any of the plaintiffs involved in that other case?
to the best of, so the first case, I believe in late April of 2020, Mr. Wood asked us to assess a fee split in another case. I believe it was the Sharon Lindsay case. Well, she was the client and there were multiple cases related to her. And he asked us to evaluate one particular case. I don't believe the plaintiffs were involved in that case, but I honestly don't remember at this point. But he asked us to evaluate the fee that he paid to a different attorney, not the plaintiffs.
Okay. Thank you. So if I can direct your attention to Exhibit 96.
Do you know if that's in the big binder? It's like,
Your invoice, Austin Bird's invoice.
okay.
So on April 27th, does this read accurately? 04/27/2020. One of your associates, Rachel Bimmerly, or Austin and Bird partners, I don't know. But she spent 5.2 hours, or he spent 5.2 hours researching issues regarding propriety of attorney's fee splitting agreement under the Georgia Rules of Professional Conduct and communication with Joey Burby regarding the same.
I'm sorry, your question. I see that.
Yeah, did I read that accurately?
You did. Yeah.
Okay. And flipping back to Exhibit 95. First, Your Honor, defendants moved to tender Exhibit 96 into evidence.
Any objection?
No objection.
96 is admitted.
Going back to 95, do you see indication on this invoice of any type of fee split?
Like a research or analysis of, no, I don't. I mean, let me look more closely, but I'm confident there was not.
I'll give you a minute if you need a minute.
No, I'm fine. This is consistent with my memory that it was around April 24th or 5th that Mr. Wood asked us to look at this fee split in another case involving a different lawyer.
So 5 weeks after the March 17 agreement.
I think that sounds right.
I'm not going to quiz you your math, but
That sounds about right. Yeah.
okay. But when you discovered the issue of client consent, the potential issue of client consent about this other matter, I believe you did raise it with Lynn?
The way I remember it, again, 5 years later, was when we were talking about our research on this other case, this other fee split paid to a different lawyer, not the plaintiffs, and talking about whether that fee split was valid under the rules of professional conduct or not, and the effect of, if it was invalid, what that might mean. It was during that discussion, which I think was a phone call, that Lynn raised the question of what that might mean for the fee splits in the settlement agreement. I don't recall raising it myself. I thought to the best of my memory, he raised it, and then I agreed it was an issue that we should consider.
Okay. Thank you. And you, in fact, did research, or you and your colleagues.
Sorry, can I maybe just correct what I just said? I agreed it was an issue or potential issue. I want to make clear, I didn't say we needed to look into it or investigate it or anything. That was all Lynn's decision. But I acknowledge that our research on this other case might hold implications for the settlement agreement fee splits.
Thank
Sorry,
you.
I just want to clarify that.
Much appreciated. So you did, if I'm not mistaken, by you, I mean the firm in this context, do several memos, correct?
What I recall was we began to research the issue. I believe it was in research. Let me be clear. We began to research the question of consent and the validity of the fee splits in the settlement agreement. We began to research that in, I believe, early May. We researched that up until, I think, mid-June sometime, and we were putting together a formal memo, a written document reflecting our legal analysis, research, advice to Mr. Wood. We ultimately provided Mr. Wood with a draft of that memo. It was not complete, and we made it clear to him that we were still researching and considering the issue, but he was eager to talk about it. And so we agreed to share a draft, an early draft of the memo. I believe that was in mid-June. And then we ultimately provided him with a final version of the memo in, I believe, early August, mid-August. No, July, sorry, early mid-July. So there's one memo there was a draft and a final version. And then we ultimately also provided him with another memo, maybe in the form of an email. It was an email, but it was a long email that had additional research we had done and additional analysis after the plaintiffs provided us with a draft complaint that they were threatening to file. So I don't know if you count that as a memo, but it was it had our legal analysis and advice to the client.
Fair enough. So there was a draft on June 22nd, if I recall, and that's in plaintiff's exhibits. And that's the incomplete one.
Correct.
And your final memo, what is July 13th? And I'm going to direct your attention to that one. Which is defense exhibit. That would be Defense Exhibit 20 and the big binder.
Okay, I recognize it.
Okay. Your Honor, defendants tender Defense Exhibit 20 in evidence.
Any objection to D20?
No, Your Honor.
D20 is admitted.
Yeah. So in the middle of, if I can direct your attention to the middle of page 12.
Okay.
As an initial matter, we believe that Rule 1.5E likely applies to the fee split provisions in the agreement because when the agreement was executed on March 17, 2020, Lynn, Jonathan, Taylor, and Nicole were not, quote, in the same firm, end quote. Although Jonathan and Taylor began working on the Carboni and Lindsay cases as associates of Ellenwood PC at the time the agreement was executed, they had been off of Ellenwood PC's payroll and operating their own firms for nearly 2 years. Nicole, for her part, was never an employee of Ellenwood PC. While Jonathan and Taylor shared space and worked on cases with Ellenwood PC, they each paid a portion of the overhead expenses and had their own separate firms. Nicole, Jonathan, and Taylor had also secretly formed a firm together. In parentheses, close parentheses. Likewise, despite the fact that they each signed the lease agreement for Suite 2040 at Regents Plaza on behalf of Ellenwood PC and were listed on the pleadings for the Washington Post, CNN, and NBC Universal cases as members of Ellenwood PC, Nicole, Jonathan, and Taylor were never, in fact, members of Ellenwood PC. Is that correct? Accurately
That's
read?
Yes, that's what's written here.
Yeah. Turning next to the requirements of Rule 1.5E, we are not aware of any written agreement with the Salmons pursuant to which Ellenwood PC, LLWPC, and WGW assumed joint responsibility for the representation. Rather, the Salmons only engaged LLWPC and Himmer DeFrank Wessels P. LLC to represent them. They never had any agreement with WGW. And while WGW certainly worked on the Salmon cases, there is no evidence of any agreement between WGW and LLWPC to be jointly responsible for the cases. Although the proportion of the services performed by each lawyer will be disputed, we need not reach this issue or whether the total fee is reasonable, parentheses, because the fee splits in the agreement do not currently satisfy the second requirement of Rule 1.5E, that the client is advised of the share of the fee that each lawyer is to receive and does not object to the participation of all lawyers involved. The engagement letter, excuse me, did I read that paragraph correct?
You did. I guess just to clarify one thing, the first paragraph you read, there was a footnote
Sure.
that was omitted. Obviously it all should be read together ultimately. And there's also a footnote at the end of the second paragraph you just read.
I'll read the footnote.
You don't have to. I just wanted you to know that that's part of what was written here. It's
All
up
right.
to you.
Fair enough. I'll keep on.
Your Honor,
But
we would respectfully request that he finish his testimony and read the footnote as part of the
Okay, so at this time, I think,
thought it should be included. Go ahead.
all right, so Mr. Exum, if you can publish that portion as well.
Absolutely. Footnote 10, as previously mentioned, however, at least one commentator has observed that lawyers who were otherwise independent contractors may be deemed to be in the same firm if they hold themselves out to clients as having such a relationship or practice together as a single collective business entity. Here, because LLWPC and WGW shared office space, worked on cases together, and occasionally held themselves out as members of the same firm, and the agreement was reached as part of a, quote, breakup, end quote, of their prior association, there is at least the possibility that a Georgia or,
We need the acting lesson. Just
Excuse me.
Yeah, I've overruled that. Mr. Exum, you can continue
These
publishing.
accusations of acting are inappropriate and unprofessional.
All right, I've addressed them. Mr. Exum, you can continue publishing.
possibility that a Georgia or Kentucky court could find that they were effectively, quote, in the same firm, end quote, and that Rule 1.5E therefore does not apply, rendering the fee splits in the agreement enforceable as is. Did I get that right?
You read it correctly.
Read it correctly, yes. Now, onto the final paragraph of the fee split provisions, page 13. The engagement letter with the Salmons indicated that other unidentified attorneys may work on the case, and they would be compensated by LLWPC out of its fee, but did not indicate that they would receive a percentage of LLWPC's contingent fee. Specifically, the letter provides that LLWPC may, quote, select and/or associate with additional attorneys as necessary with prior approval, quote, and there's a bracket between the with and prior to acknowledge maybe a missing word, from the clients and, quote, compensate such counsel out of the contingency fee earned, ellipsis, under the terms of this engagement agreement, end quote. Ellenwood PC did not expressly obtain the Salmon's approval before associating WGW and did not advise the Salmons of the agreement or the share of Ellenwood's PC that Jonathan, Taylor, and Nicole would each receive pursuant to the agreement. Nevertheless, it seems that the Salmons did not object to the participation of Nicole, Taylor, and Jonathan since at various times they attended client meetings and appeared in court as counsel for plaintiff. Next section.
objection, Your Honor. We'd also request that Mr. Burby read in footnote 11 as he's indicated that he thought that should be read with it at the same time.
I overlooked that, excuse me.
Okay, all right, you can proceed.
Do you want to read that, Mr. Burby, or you want me to?
You're doing a great job.
All right. So footnote 11 at the bottom of the half paragraph at the top of the page reads as follows. The fee split provisions in the agreement relating to the Carboni and Lindsay cases arguably comply with the notice requirement in Rule 1.5E2 as those clients have signed settlement statements which authorize Ellenwood PC to split its fee in its sole discretion. However, it should be noted that the clients were not advised of the specific lawyers with whom the fee would be divided or the share of the fee that each lawyer would receive, which raises at least some question of whether the settlement statements comply with the rule. Is that accurately read?
Yes.
Yeah. Now, C, duty of good faith and fair dealing. While the fee splits, I'm back in the middle of the page, everyone. While the fee splits for the salmon cases in the agreement do not currently comply with Rule 1.5E2, that requirement can still be satisfied by obtaining the client's approval of the proposed fee splits in writing prior to the actual division of the fees, none of which have been received yet. Further, it is likely that a court would find that LLWPC has an obligation under the agreement to so inform the client and seek its approval of the proposed splits. Indeed, to recommend that the client approve them. Quote, "It is a well-recognized principle of contract law that both parties are under an implied duty of good faith in carrying out the mutual promises of their contract. A duty of good faith and fair dealing is implied in all contracts in this state." End quote. Wisnant v. Fulton Fed Savings and Loan Association, 200 Georgia Court of Appeals, pen cited at page 33 from 1991. See also Brack v. Brownlee, 246 Georgia Supreme Court, 818, pen cited at 819, case from 1980, holding that the purchaser has an implied duty to diligently seek to satisfy the financing contingency in a contract for the sale of real property. Also McGowan v. Progressive Preferred Insurance Company, 274 Georgia Court of Appeals, 483, pen cited pages 495 and 96 from 2005, quoting plaintiffs, bracketed, thus were, in bracket, thus were entitled to expect that, bracket, defendants, close bracket, would exercise good faith in carrying out their obligations under their policies. And in this context, that means that the insurers would pay the fair retail replacement value or the actual cash value of their vehicles in accordance with their policies and not resort to some stratagem or conspiracy to undervalue their vehicles. And it also cites Jackson Electric Membership Corporation v. Georgia Power Company, another Georgia Supreme Court case, pen cited at page 774, and the case is from 1988. So in the very next paragraph, well, first of all, how'd I do on that one?
You read it correctly.
I thought so. Now, the next one. Because the salmon cases are ongoing and LLWPC promised in the agreement to divide its fees with WGW, we believe a court would find that LLWPC has a duty to let me back up. LLWPC has a duty to take whatever action is reasonably necessary to enable it to fulfill that promise, namely seeking the client's written consent to the fee splits with WGW so that the splits comply with Rule 1.5. Citing the Melvin v. Preston, looks like a Kentucky appellate unpublished opinion, and it has and core, I don't really understand.
All right, is there any objection to just skipping the cites, the legal citations here?
I'll happily
All right,
do
let's
that.
continue.
I'll just say cited by what court, but not the weeds. Okay. Turning to the argument regarding SCR 3130, parentheses 1.5, parentheses E, close parentheses, we disagree that the rule is applicable in such a way as to render the agreement void. It is clearly the responsibility of both Melvin and Preston to notify the clients, and neither did so. Melvin's own failure to comply with the rule should not absolve her of any obligations under this agreement. Finally, as the circuit court noted, there is no indication that the client's rights were violated, and any speculation the clients might have objected to Preston's receipt of part of the fee for this litigation is unavailing. Clients were fully advised that Preston was representing them in the litigation, and they raised no objection at that time. Melvin's speculation regarding any objection their clients might have had to Preston's association with another attorney that the clients had rejected carries no weight here. And that quotes a Texas case. In fact, they appear to be cases outside Georgia. But in one of these cases, Pollen v. Cook, at the end, it says here, the issue of informing the client arose before the litigation was terminated when the clients could have been asked for their consent. And lastly, so is everything okay about that paragraph?
Uh,
Accurately read.
Yeah, well, yes.
Yeah, that's what I mean. So in section D, if the client in the salmon cases is advised of proposed fee splits with WGW and consents to them, then the fee splits will comply with Rule 1.5E2 and be enforceable, assuming the other requirements are met. On the other hand, if the client objects to the fee splits, then the fee splits would likely be void and unenforceable as contrary to public policy. In that event, we think a court would likely conclude that the entire agreement is unenforceable because the fee split provisions are not severable. Did I read that accurately?
Yes.
All right. Now, did your opinion while representing Mr. Wood as to the applicability of Rule 1.5, to the best of your recollection, did that ever change?
I would say that between the time of this memo, which was on July 13th of 2020, and the email I referenced earlier, which we sent to Mr. Wood with additional analysis, discussing additional cases and discussing additional facts that had been alleged. I don't know if they were true facts, but facts that were alleged in the draft complaint that the plaintiffs were threatening to file. We did continue to form a view of this situation, and I would say it changed somewhat in the sense that let me say first, the email speaks for itself in terms of exactly what we said. I'm trying to remember it from 5 years ago, but I think we described the issue as a much closer call with the benefit of the additional research we had found and the additional facts which we were not aware of. But our advice to Mr. Wood to get consent, although by the time of that email, he had already tried to get consent, was the same. But we thought it was prudent to ask for consent under the circumstances, since it was unclear to us how the rule would be interpreted. The prudent thing seemed to be to get consent from the client.
Okay. And to clarify, let me see how to ask this. What exactly do you mean by prudent? Prudent with regard to ensuring the client would consent or avoiding the agreement from becoming void?
I mean prudent in the sense that if the rule applied and consent from the client to the fee split was required, then you would have it. Or the idea was you would request it and get it. If it turned out that a court found that the rule didn't apply and there was no need to get consent, you'd still have it. So it would just sort of be a moot point. And so the safest course of action, that's kind of what I mean by prudent, was to get consent, and that way you're covered either way.
Okay. Thank you. I now want to direct your attention to fence exhibit. Defense Exhibit 102. It was, it used to be Deposition Exhibit 10. That's what the,
Is it the settlement agreement?
no, it's the January 28, 2021 letter that you, well, you can confirm it, but
Sure.
appear to have written Mr. Beal.
You said 102?
Yes, and look in the small binder. It would be in the middle of the smaller binder.
Might be fastest for you to come just show me what I'm sorry, I just
Approach,
don't.
Your Honor.
Yeah.
Let's see.
Ah, 10, okay.
Your Honor, at this time, we would interpose an objection to this exhibit as it contains settlement negotiations. And it asserts positions which were never pursued in this case.
Okay, let me, I'm trying to make sure I'm actually looking at the
This
exhibit.
January 28th, 2021 letter from Joey to me.
Okay, is this one that's in the Dropbox, Mr. Exum?
I added it last night, Your Honor. I inadvertently did not include it. But it's no surprise on anyone.
And is it your objection, Mr. Beal, to all of it or just a portion of it?
To all of it, Your Honor.
For the same reason?
Yeah, I mean, I could object to timeliness, but that's not what I'm doing. I'm objecting instead to yeah, you're probably right.
All right, Mr. Exum, I think because the letter is dated and occurs after the filing of the lawsuit, it's not relevant to some of the claims relating to bad faith that all are about what happens before the filing of the lawsuit. And it does appear to contain 408 material. So I think this letter as presented and moved for admission here would not be admissible. That's not to say that perhaps some of the subject matter in here could be phrased differently, but for now, I would note the objection, but I don't believe 102 would be admissible as presented. You can proceed.
May I respond?
Sure, but without going into the substance of it.
Okay, so this may postdate the filing of the suit, but it shows the consistency of his opinion about the agreement being void. Yes.
Okay.
Let's do that.
This one. Let me really cut to the chase because we raised the issue. He offered us to finding arbitration before the suit was filed. I can see that being relevant, whether attorney's fees are justified. Sure. And so, as your point, this is just showing that he again offered it after the suit was already filed.
So this is a response letter to basically an abusive litigation notice, which is predicated on supposedly frivolous notions of Rule 1.5E.
Yeah.
And he is writing here affirming he made a closer call and as he said on the staff. Okay, so I
The
can,
move for the objection, please.
I can ask questions from the things, some things in it.
Your position was your findings.
Sure.
Were, okay. Well, we have to take it, we have to take it question by question.
All right. So the objection is sustained to 102 and exception preserved. Mr. Exum, you can proceed.
Thank you, Your Honor. So, Mr. Purby, generally, do you recall it being your opinion expressed in writing that plaintiffs, months later, months after the suit, that plaintiffs had not complied with Rule 1.5E and that, and do you recall also believing or that Mr. Wood, for him to have paid them, really violated the client's express protest that he do so, or
Objection, Your
objection?
Honor. His opinion is not relevant because he's not an expert or has ruled on that. But as to what he told me or what he told Lynn,
Yeah.
I think that's all fair game.
Okay.
Well, that's all I'm asking. I'm
All right.
asking what he recalls, and
I want you maybe add on a little bit extra to that question if you need to, or you can rephrase it.
yeah, I'm not asking for you to opine, just I'm asking you to recall as best you can. So, do you recall it being your opinion, even as far out as January the 28th of 2021?
Objection, Your Honor. I did the exact same thing here.
That's a recollection question, Your Honor. It's not, I'm asking about a fact in time. I'm not asking him to give me an opinion right now.
Okay. Overruled. You can ask it.
You recall, as a matter of fact, saying that the defendant's payment to plaintiffs out of the salmon fee would have been over.
Objection, Your Honor. I think he's leading them now.
And leading, just to get through it, I don't have as much of a problem with, but I will just give the jury this instruction. Again, members of the jury, as we talked about through this trial, ultimately whether the ultimate issue here on whether the fee should have been paid or not paid is going to be for your determination. And so his opinion is relevant for any other issues should you find it to be so. You can continue, Mr. Exum.
Yeah. Do you recall having the opinion that a provision in the settlement agreement that would have required the defendants to pay the plaintiffs without the client's consent would be void? Let me clarify that. Void and unenforceable because it would have required Mr. Wood to violate Rule 1.5?
Objection, Your Honor. Same objection. He's still testifying about his opinion.
No,
All right.
recollection, not opinion.
All right, but again, it's his opinion that may play into relevant issues here in this trial. So,
Ask him if he told me that position.
right, I think that could be the very second question that comes out. So I think I've instructed the jury of that distinction, and so let's note it overruled. Let's continue.
Thank you, Your Honor.
So
Do you remember the question?
I think I,
Then if you
Yeah.
can answer, you can answer it.
yeah, I mean, I would answer it this way. Between the filing of the lawsuit and early 2021, Chris Marquardt and I continued to convey to Mr. Wood and have occasion to convey to Mr. Beal our view that Rule 1.5 arguably applied or could be found to apply to the fee splits in the settlement agreement. And therefore, there were 3 conditions that had to be met. One of them was client consent. And of course, at that point, during that time period I just identified, the client had been asked for consent. The client had declined to consent without evidence of work performed by the plaintiffs on his case, which had not been provided. And so we continued to discuss with Mr. Wood what to do in that event. And we thought it was ultimately his decision, but we thought, he could not overrule the client or go against the client's express direction, or that there would be risks in doing so. But I want to be clear, it was his decision what to do or not do. We were simply talking with him about the risks of paying money that a client had said could not be paid.
Thank you. But on that note, he was confronted with the risk of violating an ethical rule. If he decided to say, well, whatever, I'm just going to pay him and get this out of the way, even though the clients objected, you did identify a risk that he could be found in violation of an ethical rule. Is that correct? You can correct me if I got that wrong.
Objection, Your Honor. He's leading them. And he's calling for expert opinion. It's just
Okay, again, it's
what
not.
detail when.
Sure.
Move on.
Well, first, I think he's breaking it up. So he's establishing whether he has opinion, and then you need to follow up. And the only reason that would be relevant is if he then conveyed that opinion.
Okay. All right. Are you able to answer the question that's asked, or I need to rephrase?
No, I mean, I think I can answer, which was that the risk we identified and discussed with Mr. Wood was that if the rule applied and he did not get consent or paid the fee without consent, he would arguably be violating the rules of professional conduct. And
Okay.
Mr. Wood was adamant throughout this process, do anything to violate the rules.
And to clarify, he never said anything about not wanting to pay plaintiffs.
Objection, Your Honor.
I withdraw that.
Okay.
I withdraw that. Shifting gears to the repeated requests for documentation from plaintiffs. Did you or Mr. Marquardt make requests for plaintiffs to provide their documentation?
We did through their counsel, Mr. Beal.
When was that first done?
I'd be speculating. I mean, I think in the summer of 2020, but when exactly, I don't recall. It was done in writing though, I believe.
Yeah, I should help you with that one. It has been a while. Does the July 24th letter from Mr. Marquardt, which I believe is already in evidence, I don't remember which exhibit though.
106.
106, that's right. P 106.
Is that the letter informing Mr. Beal that Mr. Sandman had?
Yeah.
I mean, I can look at it. I assume in that letter, he also conveyed that Mr. Salmon had requested proof of the work performed. But maybe I should look at it and confirm that. I assume it was all in the same letter, but what was the number again, please?
106.
106, P
But you gotta
106.
look in these binders, sorry.
Do you happen to know which binder that?
Oh, I think it might be the,
It's in the plaintiff's binders.
yeah, that's the one on the floor.
He's already got it. He's already got one.
What's that?
I think that's the wrong thought again. We
Oh.
wanted to make this as difficult as possible, had we did.
I think give me another table to put things.
Well, if you've got, it's right here.
It's 106. Oh, was I going, am I upside down? It's not.
Yeah,
That looks like it's here.
that's it.
Okay, thank you, Mr. Beal. Okay, sorry, let me, yeah, this letter, which was Mr. Marquardt's letter to Mr. Beal on July 24th, informing him that Mr. Sandman would not consent to the fee split without proof of the work that was performed, and includes a request for Mr. Beal's clients to provide documentation of the services they rendered.
Thank you. Now, I'd like to turn your attention to, well, first, who was working toward getting that consent in terms of on both sides? Well, scratch that. Were you working with the McMurtry, Todd McMurtry and his firm? Were you and Chris working with them?
Short answer is with him. I didn't ever speak to anybody else at Mr. McMurtry's firm, but we had decided that the request for consent should come from Mr. McMurtry, who represented Mr. Sandman. And so we had spoken to Mr. McMurtry around this, maybe earlier in July, and conveyed the ask from us and Mr. Wood for him to present the issue of consent to Mr. Sandman.
Did Mr. Wood have anything to do with that process?
To my knowledge, no. In fact, we had specifically instructed him not to be involved.
Okay. Thank you. Now, were there other requests that were made for documentation?
To the best of my memory, we requested documentation from the plaintiffs reflecting their work on the Sandman cases a number of times in writing. I don't remember how many times or over what time period, but I think there were a couple of letters, I believe, at least, maybe emails as well. All to Mr. Beal, to be clear.
Would one of those letters be the August 10th letter from 2020? Let's see if I can find the exhibit number for you. I believe it's it's Defense Exhibit 9, but it's also in the small binder as well, so you don't have to use the big thing.
It's Exhibit 9. The defense exhibit has like multiple numbers on each tab,
Yeah,
so I'm
well,
not sure which one's the one I should
Look,
be looking at.
14 might also, because that was the number it was used in Mr. Marquardt's deposition. That's,
Okay.
I didn't have
Yeah,
time to
I see
change
that.
that.
That's all right. Didn't mean to chastise you. I just said it was hard for me to find.
Oh, I
This is-
understand.
This is August 10th, 2020 letter from me to Mr. Beal.
That's right.
Okay, I see it.
So in the bottom paragraph, it reads, in my July 24 letter, we asked your clients to provide documentation.
Objection, Your Honor. I think he's got to put it in evidence first.
All right. So
Yes.
I
this
don't have
is,
an objection to it.
okay, what exhibit number is this, just so we have it?
Defense tender exhibit D9 into evidence.
This is going to be D9, without objection submitted. You may proceed.
All right. In my July 24 letter, we asked your clients to provide documentation demonstrating the work they did on the salmon cases so that they can be compensated, was redacted in my copy here, but so they can be compensated for their services under the doctrine of quantum merit. We have not received anything in response. In case you have overlooked this important issue, we repeat that request here. That is a crucial step in determining that the fee demanded is reasonable and in proportion to the services performed. To other requirements of the applicable rule of professional conduct. Did I read that correctly?
You did. And just to clarify, this is a letter from Mr. Marquardt, not from me personally, but I recognize it and you did read it correctly.
Okay, but within the broader question, requests were made for documents.
Yeah, some requests came from Mr. Marquardt, some came from me in different correspondence.
Okay, well, now we are going to go to the road.
Okay.
Let's turn to Defense Exhibit D12. It might also be 10, and it's the very back one in the small binder.
Okay.
Defendants move the tender Exhibit D12 into evidence.
All right, objection to D12.
Good, no objection, Your Honor.
D12 is admitted.
Thank you, Your Honor. So if we turn to the bottom paragraph of the first page, let's go to the second paragraph. If your client's refusal to provide the documentation is because the request for it is coming from this firm as counsel to Ellenwood and Ellenwood PC, that position obviously undercuts your argument that your clients were associated with Ellenwood PC during their work on these cases for purposes of the ethical rule that Lynn has endeavored to comply with. Certainly, Lynn, as the owner and president of Ellenwood PC, has a right to see time and billing records and other work product created and maintained by your clients in connection with jointly representing a client of Ellenwood PC. And if your clients were really part of Lynn's firm, as they now contend, wouldn't they have a duty to act in good faith and show records of work they did as members of his firm for a client of his firm? Question mark. It is curious that your clients would go to such lengths to hide their records. Did I read that correctly?
You did.
Regardless, we wish to make clear this request for documentation of the work your clients performed on the Salmon cases is coming directly from their former client, Nicholas Salmon. I believe you already knew this because Todd McMurtry, who also represents Nicholas and has been communicating with him about Lynn's request for Nicholas to consent to the fee split, told you so when you spoke to him on August the 6th. To avoid any claimed confusion on your client's part, we're copying Todd on this letter and the email to you transmitting it, and he can confirm that indeed Nicholas has made this request of your clients because he wants to understand the basis for their claimed fee to which Lynn has asked him to consent. To sum up, the former client has requested these records. Ellenwood PC has requested these records. We believe your clients have an ethical and legal obligation to provide them. We look forward to receiving the requested records immediately. Please also send copies directly to Nicholas, copying Todd, C/O Todd, so that he may review them too. Sincerely yours, R. Joseph Burby. Did I read that correctly?
You did. We had also, I think, made the request for an affidavit if they couldn't provide the documentation. That's in the first paragraph, I think.
Absolutely. And that's my next question. If that is the case, this is the bottom of that paragraph, can they not prepare an affidavit describing their work, estimating the number of hours involved, and proposing a total fee based on an hourly rate, akin to what would be included in a fee petition to a court? Did I read that part correctly?
You did.
Okay. So if I read, am I also correct not to see any specifications? You don't put any type of specifications. I strike that. All right. In your experience, and I'm not asking you as an expert, I'm asking in your personal experience, what has been your experience with affidavits?
It's pretty.
What are they? What are they?
Yeah.
What is it?
Sworn statements, sworn testimony in writing. Same thing I'm doing here, but in a written document.
Do they have to be any particular length?
No.
Could they be a page even?
It's whatever the testimony is. It can be as short or as long as whoever's preparing it wants it to be.
So is it fair that someone could estimate the hours of their work within a page or two?
Yeah, I think you can rephrase that. That's sustained.
All right. Moving on. Did you ever get an affidavit from plaintiffs?
No, I did not.
No affidavit attesting to their work on salmon?
No,
You know if Mr. Marquardt got one?
I do not believe he did.
Okay. Your Honor, can we take a few minutes?
If you just need to confer with counsel to see if you've got anything else to cover, feel free to take a minute, but otherwise, I think we need to keep moving. So feel free to take a minute.
Okay, thank you. Mr. Burby, if I can redirect your attention to the engagement agreement.
What exhibit number?
Coming up.
Okay.
Believe it was. Let's see. Exhibit 15.
Do you know which binder?
I believe it would be
Oh,
the defendant's
this
big binder,
sorry. Okay.
but toward the front of it.
Okay, I see it.
I just want to direct your attention to paragraph 4. Retainer.
Yes.
Before we begin work on your behalf, will we require a retainer in the amount of $100,000? The retainer will be placed in our trust account and will serve as a source of payment for all or part of our account or accounts when rendered. Any unused portion will be returned to you upon completion or termination of our services. Do I have that correctly read?
I think you may have transposed we and will, but
Okay,
we will require a retainer is what it says.
thank you.
Yeah.
Uh, Going back to your memos for a minute. Is it fair to say that the opinions you rendered at the time on Rule 1.5 were honest opinions?
Yes, 100%.
So anyone saying you took a dishonest legal
Objection.
opinion,
Yeah, all right, I think,
I'll withdraw.
okay, we move to the next question. Anything further?
One final thing, Your Honor. Direct your attention to Exhibit D22. Big one, but I tried to make it, and that one, it was D5 and the small one, so it's in both places. You're welcome. If I can direct your attention to the second, excuse me, does this look like the termination letter you sent to the defendants?
Yes, it does.
Yeah. Your Honor, defendants like the tender.
Any objection to defendant's 22?
None, Your Honor.
It's admitted.
All right. I'd like to turn your attention to page 2, the bottom of the second full paragraph, where it starts with "we want," and it reads, "We want you to win your case with plaintiffs because we have believed and still believe that your position in this case is true and right." Did I
Close.
state that correctly?
Close enough.
Okay.
And Your Honor, we request that he read the next sentence too, because it holds it in context.
All right, if you could read the next sentence.
No, he would be allowed to do that on.
We've gone round and round on this objection. I think on this one, I'll take a look at 22.
Yes, sir. Your Honor, for context.
No, for this one, I think you can be taken up on cross. It doesn't need to be placed in context at this exact moment. All right, overruled. You can take it up on cross on this one.
Sure.
Anything further, Mr. Exon?
Mr. Burby, could you please read the entire paragraph? That entire bottom paragraph, starting with "we discussed," or I can.
No, let him.
All right.
Okay. We discussed early on that we litigate our cases in the courtroom and in our court papers, not in the press. We know that you have a different perspective on that, and we respect that you have been very successful over the course of your career as a result. However, your comments in the press and on social media over the last several months have been viewed by many as false and inflammatory. They have made it extremely difficult for us to do our jobs with success. We believe that some of your public accusations, such as those against the Chief Justice of the United States Supreme Court, have been damaging to your case and our ability to advocate effectively and credibly on your behalf. Another example I mentioned to you was the call you had with Chris late last week. He shared with you that the General Counsel of the State Bar of Georgia had called him regarding grievances filed against you at the State Bar. We learned the next day that you posted on Telegram the substance of that conversation with Chris. We do not practice law by social media, and it greatly concerns us that you would post about a confidential conversation with your counsel. We want you to win your case against the plaintiffs because we have believed and still believe that your position in the case is true and right. But we also believe that you deserve to have lawyers representing you whose loyalties you do not question and whose philosophy of litigation you share.
Nothing further, Your Honor.
Fine. Mr. Beal, this is a time estimate. Roughly speaking, how much time do you think you need for cross?
Well, I've got a short bit that we could do right before lunch and then a longer bit afterwards.
All right, you can proceed.
Is that any estimate as to total bit?
We'll take that up after the bits are done.
Get our bits added up and see what the total bit is.
Mr. Burke, is it okay if I call you Joey and you call me Drew?
That's fine.
Thank you very much. Known each other a while. We saw the retainer agreement was $100,000. We also saw defendants exhibit 95, 15, and 22 talking about your relationship and the bills with them. Overall, would it be fair to say that Alston and Bird billed Mr. Wood about $900,000 for its representation and received about $700,000 of that?
So I don't remember exactly how much was billed between March of 2020 and February of 2021. What I do remember is how much we were not paid.
And that was about how much? 260,000 in that last exhibit?
I think it's more than that. I think there was another bill maybe after that.
Okay.
I think it was over $300,000 that we were not paid for our services.
Okay. And so it was Alston and Bird's decision to terminate Mr. Wood.
That's right.
Okay, I got it. Thanks. Sorry. Now, I hate to do this, but I think I've got to, in the interest of completeness.
Your Honor, excuse me, that's not a proper question. What he hates to do or not do, just ask the question. So
Mr. Beal, if you could just focus on the question.
Your Honor, if
I have to
Mr.
try
Exum-
and apply the rule.
if Mr. Exum is,
Well, that is true,
Correct.
Mr. Wood.
Should be Mr. Exum.
Mr. Exum should be making the objections here. But for the purpose of this objection, it's noted, I've directed Mr. Beal accordingly, but going forward, this was Mr. Exum's witness, so I think he should be making the objections.
Voted, Your Honor.
All right.
we talked about Alston and Bird's reputation before you got here. And in addition to the things that were said about Alston and Bird, then you're aware that Alston Bird's been sued for malpractice a number of times over the years.
I'm not aware of that, to be honest.
The reported decisions at the Court of Appeals for Hatcher Management versus Alston and Bird, Matsura versus Alston and Bird, Kawama Farms, all of those are reported decisions regarding malpractice claims that were brought against Alston and Bird. Is that correct?
I'm not familiar with any of those cases. I know I was not personally involved in them.
And are you familiar with the fact that Alston and Bird regularly, easy for me to say, represented DuPont Dumurs, the famous chemical company out of Delaware?
I'm not aware of that representation.
Are you aware of the Bush Ranch versus DuPont litigation in the federal court of the Southern District of Georgia?
I am not.
Are you aware that Liz Price of your firm and your firm was sanctioned by the federal judge for $108 million for concealing evidence in that case?
I have no knowledge of that case.
And at that time, that was the highest sanction, certainly in the state of Georgia.
I don't know that to be true.
And that case ultimately, I'm sorry, Middle District, was ultimately resolved by Judge Hugh Lawson, which involved a modified order of sanctions.
I have no knowledge of that.
Okay. So even big firms can have problems from time to time, just like every other firm. Fair?
I don't know how to answer that, really.
All right. I believe you said that your opinion changed in this case, or the firm's position to Mr. Wood changed over time as you learned new facts.
Objection, mischaracterization testimony.
Jury will recall the evidence. Overruled. You can proceed if you answer the question if you can.
I agree with that.
Thank you. Why don't we go to Exhibit 62? Thanks. Can I use this one?
Is that
Did I take his?
This is yours.
I may have yours, Joey. I'm sorry. Do you have a volume note up there of plaintiffs?
yes?
You do. You're all set. 62. Does this appear to be Chris's email communication with me, sort of starting this whole process, if you will, in early March 13th of 2020?
So it's an email from Chris to you, copying me, dated March 13th, 2020. Looks like it follows a phone call that you and Chris had the night before, which may have been the initial call after we were engaged, but I don't know for sure.
Okay. And so this was where you and Chris, through Chris's email, were sending a term sheet to me. And a term sheet is basically a list of all the essential parts of a settlement agreement. Is that right?
I would agree with that.
Okay. Um, and Chris says in here in the second paragraph, to that end, attached is a final settlement term sheet. It has been approved by our client. Lynn has instructed us to make clear that this is non-negotiable, last and final settlement offer. You and I have both been doing this for a long time. I note for what it's worth that I do not agree to characterize an offer in that way unless it's 100% certain that my client will not negotiate any additional items. That's where we are in this dispute. I read that correctly?
You did.
So Lynn was final and convinced that this was it. This was all he was going to offer. Is that fair to say?
I really don't. I mean, it says what it says.
Yeah.
I don't remember the conversation with Lynn that preceded this or what Lynn's state of mind was at the time, but this is what Chris wrote.
And we're able to ask you about what Lynn told you because Lynn has waived the attorney-client privilege with regard to Alston Bird's representation of him, correct?
That's my understanding.
Thank you. The next paragraph says Lynn also instructed us to make clear that this offer will expire at 5 p.m. tomorrow, Saturday, March 14th, if not accepted by your clients at that time. Did I read that correctly?
You did.
Okay. Any idea why there was such an amazing urgency that the deal had to be accepted on a Saturday?
I don't recall.
Unusual to get a demand that has to be done on a Saturday, isn't it?
I guess I would agree with that.
Okay. And this came in at 4:40 on a Friday afternoon. Is that right?
Yes.
Okay. But you didn't question Lynn. Hey, where's the fire? Why does this have to be done immediately?
I really don't remember the conversation 5 years ago.
All right, let's turn over to Exhibit 67. Do you remember receiving this email? First of all, before we do that, Exhibit 62 is in evidence, right? What? At this time, we would move Exhibit 62 into evidence on the chance that it's not already in.
Plaintiff 62?
Plaintiff 62,
Okay,
the one we just,
yeah, I don't see that as already having been admitted, so
sorry,
any objection to P 62?
it's the term sheet transmittal letter, email.
Is it not in evidence yet, Your Honor?
No, it is not. I thought it was.
At least by my notes.
Sorry. Do you have it in?
Not by my notes, but this isn't the official record. So regardless, is there any objection to plaintiff 62?
Let's just have a moment to look.
It's already in evidence as Exhibit 101. It's the exact
There we
same
go.
document as
Okay.
101. But
If it's in evidence.
Okay, so if let's just refer to this as plaintiff's 101 then and
All
move
right.
forward. Okay.
All right, let's turn over to Exhibit 67. And this one's already in evidence, so that's going to be easier. Do you remember this March 16th email from Lynn to you and Chris?
I recognize it. I don't specifically remember it, but it looks familiar.
And is Lynn emailing to you on the 16th some edits to the agreement that he wants you to make?
Yes, he is.
Okay, now let's turn over to page 3, Bates number 3131. Michael, can you blow up the first two red line, the first two big paragraph red lines? There we go. Okay, the first one says, whereas he's edited and typed this in. This red stuff is stuff that Lynn typed in and sent to you, right?
I believe so.
Whereas Nicole Wade, Jonathan Grunberg, and Taylor Wilson, hereinafter WGW, have never been law partners in L. Lynn Wood PC, paren hereinafter, quote, LLWPC, end quote, but have worked with L. Lynn Wood PC by agreement on a case-by-case basis while sharing office space since 2018. Did I read that correctly?
You did?
Did you think it was odd that Lynn wanted to make that change?
I honestly don't remember. Chris was primarily handling the settlement agreement and communicating with Lynn about it. I just don't remember having a reaction to this one way or the other.
Did it fit with your understanding of the facts at that time?
I believe Lynn had shared with us sort of the nature of his relationship with the plaintiffs in our initial meeting and conversations with him. And this does generally appear consistent with what he had told us.
Based on the evidence that you have seen from the verified complaint, do you still believe that that is completely accurate, his edits there?
Well, with the caveat that I don't know if what's alleged in the complaint is true, but there are factual allegations in the complaint. And I would say they're inconsistent with this. And that's
Okay.
Okay.
Okay. And this language never made it into the final agreement, did it?
I really don't remember. Could you show me the final and I'll confirm?
We're going to get to it in a minute, but if I break my thing, we'll be here for a month.
I'll trust you, but I don't.
I want to keep it moving.
Yeah,
So at the bottom of the page, under fee split for legal work, we've got A, and he's edited and said LLWPC shall pay to WGW a portion of its fees for the following cases as set forth here, subject to the offset for lease expenses described in section 2 below, colon. Did you ever ask Lynn why he drafted in L. Lynn Wood PC instead of the Wood defendants?
I don't recall.
Were you at all concerned that this change could create a situation where a PC would not have the money to pay certain things?
I didn't have that concern.
As you sit here today, do you have that concern?
No, I mean, I did not have that concern then. I don't understand quite the question, I guess, but I don't have a concern one way or the other about
Well,
that.
by adding this language in, if the PC is broke, it won't pay. But Lynn personally certainly could.
Objection, Your Honor.
I really don't.
Mr. Exum.
Sorry.
I'm sorry.
Yeah.
Supposed to be
Mr.
Mr. Exum.
Objection on grounds that it's speculation and it's not timely at this point, and it shouldn't go into financial records.
All right, just on those grounds, it's noted, overrule the objection.
Thank you.
Question, or he already answered the question, didn't
All right, let's look over at Exhibit 102.
Well, I don't think I don't. Did I answer, Judge? I thought I mean, I was going
he? Mr. Beal,
Um,
it seems like it's withdrawn then.
Okay.
All right.
the- Oh, he did answer it.
He didn't answer.
Okay. Can you please reread it?
Question.
Yes.
I added this language in, if the PC is broke, it won't pay, but Lynn personally certainly could.
Thank you.
Renew my objection. Same grounds.
All right, noted, overruled.
So let me be clear. I don't recall having any reaction or memory of this edit or why it was made at the time in 2020. If you're asking me today, my reaction to this and whether I see the point you're making, I do. Although to the best of my memory, Lynn was the 100% owner of the PC. I would assume he would have potential liability if the PC itself couldn't pay, potential personal liability. But that's just me telling you today as I sit here what I think. But
And he would have personal liability if the PC didn't pay, is your opinion.
potentially, you can
Approach the bench, Your Honor.
You could.
well, you can pierce the corporate veil.
Well, no,
You
if
can-
they've objected to the
I was gonna
question
say.
as improper, then they can lodge their objection.
Sorry.
Mr. Exum, yeah, if you want to approach.
Okay. Mr. Burby, can you, or Joey, can you, answer that for us? You were in the process of answering that.
Well, I think I was explaining that it seems to me there could be circumstances where the owner of the PC, which here was Lynn, could be responsible for debts or obligations of the PC. But I mean, the more I look at this, I think the reason it didn't jump out to me was that the fees were being paid to the law firm on these cases, as I understood it. So it made sense to me that the law firm would be paying its portion of the fees to your clients.
All right, let's look over at Exhibit 102. And is this the settlement agreement and release document that we've called settlement agreement, in this case dated March 17th, 2020?
Yes, it is.
Okay. So, and do you remember that being delivered to you at about 5 p.m. in the lobby of y'all's building, the Alstenberg building, on March 17th?
The way I remember it is I met Jonathan, Nicole, and Taylor in the lobby, and they signed the agreement in the lobby, as I recall, and gave it to me. And maybe I even brought blank copies for them to sign. I can't remember.
And that was approximately 5 p.m. on the 17th. It was late afternoon, right?
That sounds about right. I don't remember
Okay.
it precisely.
Now, nowhere in this document did you put in any reference to Nicholas Sandman or any other clients signing off on this, did you?
You mean like consenting to the splits?
Yes.
That does not appear in the document.
And you didn't suggest that to Lynn in the drafting and editing of this document, did you?
Did not.
And that's because you thought it wasn't necessary at that time, right?
No, I wouldn't agree with that. I would say I was unaware of the rule 1.5 at the time of the settlement agreement. I hadn't personally encountered it or was not familiar with it. Nobody raised the issue on either side about consent or Rule 1.5, so it just didn't come up.
And so it certainly didn't occur to you.
That's right.
And it didn't occur to Chris.
I'd rather him answer that, but I'm not. He certainly didn't mention to me any concern or issue with Rule 1.5 or even knowledge of it.
And you thought the contract was fully enforceable
This settlement,
as you wrote it, the settlement agreement, once it got signed by everybody, right?
yes, I agree with that.
If somebody signed the contract, if one of the parties had signed it, knowing that they felt they could not comply under it, that would be concerning to you, wouldn't it?
Objection, calls for expertise.
But I don't think it's beyond the scope of his testimony based on his direct. I'll overrule the objection. If you recall the question, you can answer it.
So you're saying if I had known that a party to this agreement, whoever it was, could not comply with it, perform as the agreement said at the time it was being signed, would that have concerned me?
Yes.
Yes, it would have.
Because that can be evidence of a lack of bad faith or lack of good faith in entering into the contract.
No, I would just say why would you enter an agreement that can't be performed? And if it was your clients who couldn't perform, I'd want Lynn to know that. And I'm sure you'd want to know if Lynn couldn't perform. Why the lawyers are trying to, negotiate an agreement that both parties will perform.
And if somebody has a secret reason why something cannot be performed and they enter into the contract, that could be evidence of a lack of good faith, right?
Objection, speculation.
I think we're getting further afield here.
Okay, let's look over at 102 in the first whereas paragraph. Whereas Nicole Wade, Jonathan Grunberg, Taylor Wilson, and Wood are lawyers who practice law and share office space together for several years. Is that correct?
That's what it says.
And you believe that to be true, correct?
Yes.
And then the second paragraph says, whereas WGW never held any ownership interest in L. Lynn Wood PC, hereinafter LLWPC, but have worked as lawyers of L. Lynn Wood PC on cases since 2018. Did I read that correctly?
You did.
What did that mean to you when you wrote in there that they were lawyers of L. Lynn Wood PC?
I don't believe that I drafted that language. At this point, I don't know who did, whether it was you or Chris or Mr. Wood. But I don't recall having an understanding at that time of what that phrase means. As I sit here today, I don't know what it means exactly.
But at that time, you believed that WGW folks were actually Lynn's partners. Is that right?
Partners in the colloquial sense or non-legal sense. I knew they worked together on cases. I knew they shared space together. But whether they were partners in a legal partnership, I think I knew that because I think Lynn from the beginning said that they were not.
Let's look over at Exhibit 80. And let's look in at page 1, 2, 3, 4, 5, page 6 of Exhibit 80. Yes.
Do you know what the date of the email you're?
Yeah. It is Friday, March 20th, 2020 at 2:17 p.m.
Yes. Okay. I see it.
So if you look over Exhibit 80, it appears to be an email chain between you and Jeremy Brunello, who was a lawyer out in Texas who represented the building that L. Lynn Wood PC had office space in, right?
Yes.
Okay. And you had a variety of communications back and forth with him wrapping up the lease of the L. Lynn Wood office space. Is that right?
Yes. I communicated with him on behalf of Lynn and Lynn's firm about the lease that they were party to.
And at this time, Your Honor, we would move multi-part Exhibit 80 into evidence.
All right, any objection to Plaintiff's Exhibit 80?
No, Your Honor.
And if we look over,
Well, Mr. Beal, let me interject here. I do need to find a stopping point.
Okay, right
where
after
are we at? After this?
this exhibit,
Okay, here we go.
and if we look over at page 5, the March 20th, 2020 email, you say, Jeremy, in case you haven't heard, the parties were able to resolve their dispute and the move out on Tuesday evening went smoothly. Next step, as we discussed, is to amend the lease to remove the names of Lynn's ex-partners. Did I read that correctly?
You did.
So you thought they were partners at that point?
In the way that I just previously described it to you, partners as in they worked together, they shared space. I didn't know, or I was under the understanding they were not partners in a legal partnership.
And then let's look over at page 1 on Exhibit 80. And at the very top of the page where it says, "Hi, Jeremy." The attached red line shows our requested changes to the amendment. I think you'll find them all to be non-substantive, except for the deletion of the fee provision, which of course you already agreed to. Note that the new whereas clauses were lifted from the settlement agreement between Lynn and his former associates, Wade, Grunberg, Wilson, and Perrin. I read that correctly?
You did.
So in the time period since March, the first email we saw on Exhibit 80, and May 11th, Wade, Grunberg, and Wilson, in your mind, had gone from partner to associate. Is that correct?
I disagree.
But you referred to them as partner, and then 2 months later, in May, you were calling them associates.
I think throughout my correspondence with Mr. Granello, I referred to them in different ways. I had to call them something. Former partners, associates, lawyers working together. It wasn't, I can assure you it was not with any sort of thinking of Rule 1.5 and how they should be characterized.
Okay. But Rule 1.5 turns on the facts, right? And the facts, as you understood them, were that they were partners or associates of L. Lynn Wood PC.
No, the facts, as I understood them, are reflected in our memo, and I don't think we refer to them as associates or partners in the memo. This correspondence is just me referring to the people that are no longer going to be on the lease, and I had to refer to them somehow.
And the reason you were communicating with Jeremy in Exhibit 80, all these emails, was because part of the settlement agreement said that WGW would be released from obligation under the lease in exchange for a payment. Is that a fair characterization?
Yeah, I mean, I would defer to the language of the agreement, but the idea was they would be paying Lynn or his firm a certain amount of money to no longer have any obligations under the lease, which was a multi-year lease that was still going on.
And you were getting them off that lease?
Yeah, I think
With
that's
this amendment, you called it a lease amendment.
I think that's right.
Okay.
To the best of my memory. at this
Last
point.
thing before we break, Your Honor, look over at Exhibit 53. And 4 pages in, page number 2955, does that appear to be the office lease in question? And it's a monster exhibit. It's about.
It does appear to be.
Okay. And at this time, Your Honor, we would move to admit into evidence. It's already in evidence. Never mind. Sorry.
All right. Just to confirm, is there any objection to plaintiff 53, just in case it has not already been admitted into evidence?
No, Your Honor.
All right, submitted.
And let's look over real briefly before we break
He keeps promises we're done, but
at page
Yeah,
2996.
I'm mindful, Mr. Beal. We've only got about 3 more minutes, okay?
Yes, Your Honor. At page 2996, the Bates number.
Okay, I see that.
I'm just letting the video catch up to
Sure.
you. You're a faster read than he. There we go. Okay. So how did the 3 WGW plaintiffs sign the lease?
Each of them indicated their title was partner.
Thank you. I got nothing further.
All right, members of the jury, thank you for your attention. We're going to break for lunch here. Please don't discuss the case with anyone, including amongst yourselves, and don't do any research about the case. Time's now about 12:25. Let's do 45 minutes and put that us back here about on or about 1:15. All right, we'll see you then. All right, Mr. Burby, you can step down if we could have you back here at 1:15, and please don't discuss your case with any other potential witnesses here. All right, thank you. How much time would you estimate you have remaining, Mr. Beal? Thereabouts, ballpark figure.
1 hour. But then Chris will be real short because I'm not gonna ask him the exact same questions. I've only got a handful for Chris because he took the lead on most of this. Chris did the first letter and the last letter, so he's gonna be real short.
All right, and you still got Mr. Marquardt on standby here.
Here.
Okay. All right. Well, you can advise him accordingly that we may not need him till closer to 2 o'clock, I would imagine, just so you can provide that notice to him. And then for direct on Mr. Marquardt, any idea of a time estimate there? Again, I'm just trying to game out the rest of today.
Time estimate on what?
The direct of Mr. Marquardt.
I don't have one right now.
Okay. All right. Just the way it's shaken loose, there's a chance that we have Burby and Marquardt off the stand before the end of the day and still have an hour to fill. Did you have any deposition designations you were going to do? Because if not, I would say we go ahead and start with Mr. Wood's testimony. If he, since again, I presume that's the only other witness.
We have
Time at
time at
Mercury's.
Mercury.
Okay. Then the choice is yours, but I would want to fill that time so we can plan accordingly.
I may also have some redirect from Mr. Burby.
Understood. Yeah. All right. Then with that, we'll see you back unless there's anything else. Seeing none,
1:15?
we'll see you at 1:15.
Enjoy your lunch, Judge.
All right. Take care.
Yeah, you were about to say no more questions. You're always saying.
No, you're not getting off that fast. Thank you.
Super traveler.
Thank you.
I'm Liz Marquardt.
I hate to do this to you, but I need somebody to take the other binder, because I
fine.
kind of,
Where are they?
there he is.
We can carry this. This is not a big deal.
I do. Yeah, it's,
Do you need this?
yes, I do. Probably not.
Do you need your iPad for any of this? Or? Do you want me to go grab you something?
No. Can you do me a huge favor? Just put this across the hall for me, because I got another pile of stuff I can take.
Oh, here, then
You what?
I can.
Yes, absolutely. Anything else?
So, there. You let us back in.
I'm gonna be in that room.
You let us in.
I will.
That's coming. So you got your binder.
I've got it right here.
Grab it. Janine.
It's not for.
John,
Yes, sir.
you gonna be in here?
Yeah, I will be.
Let me go let them know you here.
Okay. Yeah, they know, they put me in the break spot.
Okay, they did, all right, yeah.
Okay, Mr. Turner, I'm sorry about that. So, or I'm not Mr. Turner, Mr. Lewis. They just got Turner on the screen. Um, so what's going on in Turner County?
Probation from, I was on probation in that
Okay.
I should have never been moved if it's gonna be probation violation.
Was the conviction from Turner County?
The initial conviction
Yeah.
for the probation.
Yeah. Okay, yeah. That's why they moved you up there, because even if you're on supervision in Atlanta, Atlanta's not gonna resolve any violations. It's gonna be resolved by the original county. Because technically Fulton County doesn't have authority over those probation violations because the conviction didn't originate there.
Mike's is still loud. We still on YouTube.
Oh,
Yeah, Vestlin, I can hear you too.
okay. Okay,
I can log off and log back on.
that's okay. I'm gonna relocate again, Mr. Turner, or Mr. Lewis. Keep saying Mr. Turner.
That Turner.
He's at Turner. It says Turner on the screen, so I want to say Turner so bad. Okay, let me get my plug and I'll
Okay.
give him the back.
He's coming out in about 5 minutes. Yeah, I'll call this.
Everything's taken out.
Yeah.
Almost as keep going. Jesus Christ.
Judge McAfee will be available shortly. He got called into an impromptu meeting.
All right, anyone on Zoom, can you hear me?
Yes, Judge.
All right, great. Thank you for your patience. Hold on a second while we get the screens working in here so I can see y'all, and then we'll kick it off.
Okay.
Hello,
Is that Mr. Isa?
that's me, Mark. Yes, sir.
All right, welcome, sir.
Thank
Give me
you.
a second. We're still getting the view set up here, and we got our court reporter. Kamisha, you with us?
Yes, Judge.
All right, excellent.
I didn't realize how much higher this was.
Okay, and then you got Mr. McMack right beside you. Perfect.
I do, and his mother's in the room as well, Judge.
Okay. All right, well, I think we're ready here. So let's go ahead and go on the record. So this is 24 SC 006450, State versus Deontay McNack. And was scheduled to begin a trial at some point this week. And I'm informed the parties have reached a resolution. So we've got Ms. Potter joining through Zoom by the state. We've also have Defense Counsel and Mr. McNack joining by Zoom as well. Let me start first. Defense Counsel, any objections or concerns to proceeding in this mixed remote capacity?
None whatsoever, Judge. Thank you.
All right. And do we have permission to sign the indictment on your behalf indicating the change of plea?
We do. Yes, you do, Judge.
Same question for you, Ms. Potter.
Yes, Your Honor, and you may sign on the state's behalf.
All right. Fantastic. Ms. Potter, if you could swear in Mr. McNack.
So yes, Mr. McNack, can you please raise your right hand? Do you swear or affirm that the testimony you shall give in the matter currently before the court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay, thank you.
Make
And
sure.
you want me to go forward with the plea now, Judge?
You may.
Okay. Mr. McNack, I've got about 5 minutes of questions to ask you, and I just need a verbal response so the court reporter can take it down, okay? Can you please state your correct legal name for the record?
Deontay McNack.
And can you spell that?
DEANTE. Last name MCNAC.
And at this time, are you taking or under the influence of any alcohol, drugs, or medication?
No, ma'am.
Okay, is there any medication that you normally take that you haven't taken today?
No, ma'am.
Okay, and how old are you?
28.
And how far have you gone in school?
I went to college.
Okay, so you graduated high school?
Yes, ma'am.
And then how much college did you complete?
I got a certificate.
Okay. All right, so are you able to read, write, and understand the English language?
Yes, ma'am.
Okay. An indictment 24 SC 006450. You're charged with 1 count of cruelty to children in the first degree. As part of this negotiation, the state is going to be reducing that to cruelty in the children to children in the second degree, which is OCGA 16-5-70 subsection C as in Charlie. And that carries a sentence of 1 to 10 years in custody. Do you understand that charge and that sentence range?
Yes, ma'am.
Okay. Do you understand that you have the right to either plead guilty or not guilty to these charges? And if you plead not guilty or remain silent, you will receive a jury trial?
Yes, ma'am.
Have you had enough time to speak with your attorney, Mr. Issa, about all the facts and circumstances known to you regarding this charge?
Yes, ma'am.
Okay, and have you guys gone over any and all defenses?
Yes, ma'am.
And do you, are you satisfied with his services?
Yes, ma'am.
And do you need any more time to discuss the case with him?
No, ma'am.
Okay, and Mr. Issa, do you waive formal reading of the indictment and waive any and all defects?
We do.
Mr. McNack, this is a negotiated plea that the state and your counsel have worked on, and we are gonna recommend to the court that a sentence of 5 years probation, that you have no violent contact with the victim, and that you get evaluated, a mental health evaluation, and follow any and all recommendations. And that this will be under the First Offender Act. Is that your understanding?
Yes, ma'am.
Okay, and you wish to go forward with this charge or with this guilty plea?
Yes, ma'am.
Okay. Are you a United States citizen?
Yes, ma'am.
Okay. Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm or use a firearm during a crime, you will be guilty of an additional felony, which may carry a sentence of up to 15 years in custody?
Yes, ma'am.
And you are asking to be treated as a first offender?
Yes, ma'am.
And has Mr. Issa gone over all of the first offender provisions of the First Offender Act with you?
Yes, ma'am.
Have you ever pled nolo contendere or ever been convicted of a felony in the state of Georgia?
No, ma'am.
Have you ever pled guilty or nolo contendere or ever been convicted of a felony in another state?
No, ma'am.
Okay. Have you ever been sentenced for any crime, felony, or misdemeanor under the First Offender Act?
No, ma'am.
Do you have any questions about the First Offender Act?
No, ma'am.
Okay, so do you understand that if you violate the terms of your first offender probation, or commit a new offense while on first offender probation, your first offender status could be revoked. You'd be brought back into court. You could be adjudicated guilty and resentenced up to the maximum on this charge. So you
Yes, ma'am.
understand that?
Yes, ma'am.
Okay. Do you understand that you waive any and all defenses, including any mental health defenses, by entering this guilty plea?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up certain rights? They're called your Boykin rights, and I'll read those out to you. That's the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to assistance of counsel hired by you or court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial. So those are the rights that you're giving up or you're waiving by entering this guilty plea. Do you understand that?
Yes, ma'am.
Okay. Has anyone forced, threatened, or promised you anything to get you to enter this guilty plea?
No, ma'am.
Okay. And Mr. East, I'm not sure if we talked about this, but is he pleading under Alford?
Yes, ma'am.
Okay. So, Mr. McNack, is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Under Alfred, yes.
Okay, so you're deciding that it's in your best interest to plead guilty.
Yes.
Okay, so are you aware that even though you're not admitting guilt, this is still a guilty plea and it places you in the same position as if you were found guilty after a jury trial?
Yes.
Okay. So how do you plead to one count of cruelty in the second degree in 24 SC 006450?
Guilty.
And is this guilty plea freely and voluntarily given with full knowledge of the charge against you?
Is given.
And do you understand you've got, for this felony, you've got 4 years from today to file a habeas corpus petition, and that challenges the constitutionality of what's going on today with this plea. Do you understand that time limit?
Yes, ma'am.
Okay. All right, that's all I need from you, Mr. Mayor. Thank you. Judge, this case is really about I guess just not understanding too much punishment. This occurred, let me get my facts up. The victim in this case is Zayden McNack, Mr. McNack's child. He had been acting up in school for at least over a week. He had been in trouble in school, and Mr. McNack and his wife, Miss Kelsey, the victim's mother, decided they were going to punish him in the evenings because of what happened at school that day. Each day that week in school, his behavior was getting worse. And so in the evenings, his punishment would get worse. The police report, I talked with Miss Kelsey last week, and the police report seems to be inconsistent with the statements that she gave police. Because she does not, in the police report, it argued that, or it stated that Miss Kelsey told Mr. McNack to stop at one point because the punishment was getting excessive. She indicated that that did not happen, but they were both at least on board with this physical punishment that they were giving Zayden. Mr. McNack did admit to whooping Zayden with his clothes on, hitting him on his butt several times. Zayden would move, and then he would end up hitting his back. The child did have marks on his lower back and his legs, which in my opinion looked like both old and new bruises or injuries. In his forensic interview, Zayden did indicate that he had fallen down at his grandmother's the weekend before. And so it's unclear what injuries did happen because of that fall and what injuries did occur because of Mr. McNack's whoopings. Both parents admit that they understand this punishment was too much and that they know how to better parent going forward. Mr. McNack does not have a criminal history as far as the state's knowledge. None of this or nothing like this had happened before. But just looking at the pictures and not knowing the story, the pictures were pretty bad. So the state's recommendation, we've reduced it to negligence in the second degree, or to cruelty in the second, with the understanding that he would get evaluated and follow any and all recommendations. And his wife, Ms. Kelsey, I don't know if she's there as well, but indicated that they would take parenting classes together and get Zayden treated, medically in another way instead of this type of punishment going forward. And I guess just for the record, this happened at Polar Fox Court, which is located in Fulton County, on August 23rd of 2024.
All right, thank you. Thank you, Ms. Potter. And do you have a recommendation on a behavioral incentive date?
No, Your Honor.
Okay. Mr. Issa?
Yes, Judge. As you can imagine, in this short period of time, we've done quite a bit of work and a lot of communication with Ms. Potter. I give her a lot of commendation for being available as much as I was bothering her, either via telephone, text, or email. Also appreciate the prior defense attorney's efforts and work on this case. He called me and communicated with me and caught me up quite a bit. I don't think without either of them, I would have been able to get ready for this at this point, nor to get my client ready for this resolution at this point either. Judge, you were absolutely right. When I met you in the courtroom last week, there had been a lot of work done on this case. This wasn't a matter that was just sitting dormant. So I was very fortunate to have those two involved as well. I'm also very fortunate to have such a strong support system for Mr. McNack, aside from just his family, also his coworkers, his direct supervisors and managers are all very, very involved in his progress in this case, throughout this case. And I think, setting all those things aside, because we know that a support system is incredibly important when someone's on probation, especially first offender probation. But Mr. McNack himself has come to the realization that the lack of a father figure in his life has led him to fend through raising children on his own in the only ways he knows how. And so he wants to gain his own education, find alternative ways to discipline his children, and make sure that he's a father that leaves the kind of mark of a positive change and not the kind of marks that lead him into a courtroom, such as the ones that the state and the court are having to see today. So I would just urge the court to please allow us to resolve this case in this manner. A behavioral incentive date of maybe 2 or 3 years, if he's able to complete everything and obviously not have any issues with defects or have any issues with the court, to allow him to move forward.
All right. Well, thank you, counsel. And thank you for sharing that with me as well. I'm glad to hear that so much work was put into the case and a tight deadline, and I appreciate that. So, Mr. McNack, there's just a few things I need to confirm with you, which is that you understand the nature of this charge is reduced.
Yes.
And you still wish to waive your rights and go forward with this change of plea?
Yes, sir.
You're doing that because you believe it's in your best interests?
Yes, ma'am.
And
Yes,
that's a free and voluntary decision on your part?
yes, sir.
Do you have a weapons carry license of any kind?
No, sir.
And defense counsel, you satisfied your client is competent that this plea is knowing and voluntary and that there is a sufficient factual basis?
I am, Judge.
All right, well, I'll agree finding a sufficient factual basis and that this plea of guilty is entered knowingly, voluntarily, and intelligently, and I'll accept the plea. And I'll approve your request for first offender treatment, so I'll withhold adjudication, and I'll send to you as recommended by the parties, which on the sole count of cruelty in the second degree will be 5 years probation. You get credit for the 26 days that you served in pretrial confinement. The special conditions here are that you're to have no violent contact with the listed victim in this case. You're to complete a mental health evaluation and follow any recommended treatment. For any technical violations of your probation, like failure to report, those will be handled under the sentencing options system directly by your probation officer with a sanctions cap of PDC or RSAT. I'll impose a behavioral incentive date of 3 years. And are you requesting automatic sealing, counsel?
Yes, Judge, absolutely.
All right. Any objection by the state?
No objection, Your Honor.
All right, then I'll have that reflected as well in the final disposition, finding that your privacy interests outweigh any public concern here. And what this means, Mr. McNack, is if you stick with your probation, the case and the sentence would be discharged. Right now, you can say you haven't been convicted of a felony, and in 3 years, if there are no issues, then it'll automatically terminate. But should there be any issues, then you could come back and potentially be resentenced to the remaining time. And so with that, Mr. McNack, do you have any questions about anything we've covered here today?
No, sir.
All right. Did we have anyone from probation that needs to speak with him?
Yes, Your Honor. I'm here. I'll email Attorney Issa and get Mr. McNack's contact info.
All right. Thank you, Ms. Kuzu. And if there's nothing else, then at this point, thank you all for your time, and we'll be off the record.
Thank you, Judge. May I disconnect?
All right. Take care.
Yes, Judge. Thank you.
All right. I think we also still had Mr. Simonoff perhaps in a breakout room, or
No,
where
I'm
there
here,
he
Judge.
is. What's happening, Mr. Simonoff? What do we have?
We're just gonna maintain our not guilty plea on Mr. Lewis, Judge. He's in Turner County. Um, he's told me that he's going to Turner County on Wednesday to court to see what the resolution of that's going to be. That results in him getting out. He said that he has some evidence that he wants to show me related to the case. I'm not sure what that is yet. So I'd ask for another court date, and I'll defer to the court to what kind of court date the court wants that to be.
Okay. All right. Well, we'll reset it for a final plea maybe sometime in June, and it'll likely end up on our June trial calendar.
Understood. Thank you.
Or sorry,
Judge.
not June. I meant July.
Okay.
All right. From there, take care, Mr. Simonoff.
Thank you, Your Honor.
You, Ms. Potter.
Thanks, Judge.
Card. I'm not sure if we can get you a card either. I have to ask the lawyer how to get you set up.
Just gave me, just see my last final criminal procedure.
I withheld that one for a reason. I'll talk to you right after, because we'll get another break. But I thought about it, but
Are you ready, Mr. Kavanaugh? Okay. Why don't we just go back on the record now as we wait to see if the jury is ready to go, and I'll just check in with the parties to see if there's anything we need to take up before we bring in the jury, starting with the plaintiffs.
Plaintiff, Your Honor.
Okay, on behalf of the defendants?
There you go.
All right.
I can make sure 95 is indeed their report to me.
Not to you, but.
I mean,
Yes.
good. Thank you.
Did I copy?
One.
Agreement.
Okay.
Thank you, Deputy Scott. Please be seated, everyone. Plaintiff may resume their cross-examination.
Ready?
You may resume.
Thank you. Ladies and gentlemen, Joey, I believe you testified on direct that something about what Lynn had told you with regard to fulfilling the agreement.
I think what I said was nothing he said or did indicated he did to me, and I think to Chris, that he had any intention of not fulfilling the agreement.
But it's your opinion that he was not happy with it and he did not like the agreement. Is that correct?
Not at the time of settlement. My impression at the time of the settlement, based on what he said and did, was that he was happy with it and pleased to put it behind him. But over time, he did express that he was unsatisfied or unhappy with the agreement.
Now, if we look over at Exhibit 88 of the plaintiff's binder, which is also, I think, the first time record we saw, which I think was in the defendant's binder at 95. So whichever one is most convenient to you.
I have 88 in front of me.
All right. And
this-
it's mostly redacted, but does it show that on 515 there was research regarding fee splitting issues and then a couple entries right after that? So in mid to 15th to 18th of May, you guys were looking at this issue.
I see what you're referring to, and I agree with it references fee splitting. I don't know if that was the fee splitting research on the first project that I talked about or with respect to this case. I think the latter, but
Well, on the first stuff, it was April 17th when you were doing that research, right?
I think that's when it started. I don't know exactly when it ended, but.
And this was an issue that Lynn brought to you, not that you brought to him. Is that correct?
Yes, well, it began with the request for the research on the other project, and that was something Lynn asked of us. And then Lynn asked us to look at how that research might impact this agreement.
Okay, let's look over to Exhibit 83 in the plaintiff's binder. Okay. At the bottom of the page appears to be Lynn's email of Thursday, May 14th, 2020 at 10 a.m. And then the top of the page is your brief response in May 14th at 3:18. So about 5 hours later, you responded. Is that correct?
Yes.
Okay. And in Lynn's email to you, he says, as we develop the strategy, well, at this time, Your Honor, I would move Exhibit 83 into evidence. I do not believe it's in yet. It is Lynn's email to Joey and Joey's email back.
Any objection to P83?
1 second, Your Honor.
No objection, Your Honor.
83 is admitted.
Thank you, Your Honor. All right. So Lynn writes, Joey, as we develop the strategy for dealing with WGW on May 14th, did you understand you were developing a strategy by mid-May of dealing with the settlement agreement with WGW?
No, I mean, these are Lynn's words, but what I believe he's talking about is we had a call either that day or right before, we could probably tell from the time records, where I had shared with him the research on the other project. And that research had concluded that fee split in that situation was invalid and unenforceable. And Lynn had asked, well, I'm paraphrasing, I don't remember what words he used, but Lynn had asked about the impact on the settlement. and I think was already kind of moving ahead with the conclusion that it might be or would be invalid as well. We made it clear to him, I made it clear to him that we had a long way to go before reaching that conclusion, but he used that term, and I think he was addressing that I was surprised, or my initial reaction to the idea that we now focus on how this rule impacted this settlement agreement, I think I was uncomfortable with initially.
And he says, I just want you to be assured that it was only after the execution of the agreement that I realized the fee splits violate Georgia law and is unenforceable. Did it seem odd that he was telling you, hey, it was only after I signed the agreement I thought of this?
Again, I think
Did that ring any?
Well, I mean, I think what the best of my memory is when he, during the conversation, asked us to look at how this might impact the settlement agreement with the.
I'm responsive. I mean, I kind of need a yes or no, and he can explain if he needs to. It's just a background matter.
All right.
Just
So
said,
if you
did it set off any alarm bells or cause you any, hey, why is he saying that kind of thoughts?
okay, let's start with the question asked and then.
I guess no, because I know what precipitated it.
Okay. And then it says the next paragraph, oh, that issue first arose in my mind when we addressed it regarding Cherie. Just to be clear, that at no time are you aware that Lynn ever gave back any fees or asked to remit any payment back to anybody because a fee agreement was improper, right?
No, I think I've seen correspondence between Lynn and Cherie asking her to repay the referral fee that his firm had paid to her. I think I've seen that.
But to your knowledge, none of that ever happened.
I really don't know what happened.
Okay. The next paragraph says, at present, the only written statement by the Sandmans is that they will only authorize a fee split based on quantum merit. Where is that written statement?
I don't know what Lynn is referring to there. I had seen emails between Lynn and you and Mr. McMurtry and you where they made representations about what the Sandmans, meaning Nicholas's parents, would or would not authorize, but I had not seen anything in writing from them, so I don't know what he's talking about.
And you've never seen anything in writing from the Sandmans regarding quantum merit?
Not from the parents of Nicholas, no.
I had planned to discuss the agreement with them before distribution, but now will likely forego doing so until we finalize a plan. So at this stage, you were finalizing a plan by May 14th.
I was not finalizing a plan.
Okay. But you think Lynn was based upon his words here in Exhibit 83?
I mean, that's what he wrote.
All right.
But it was not what we discussed at that point in time.
All right. The next paragraph says, I think we should stay quiet until the settlement is consummated, then disclose our position, whatever it turns out to be. Did that give you any concern? The idea, let's stay quiet and later decide when you're talking about how to fulfill the terms and conditions of a promise or a contract?
So I don't recall my reaction to this when he wrote it in May of 2020, but we had discussions beyond this, he and I and Chris and he and I, about the timing of whether to just, notify you of this issue or not. And there were pros and cons that we discussed, and Lynn ultimately made the decision not to notify you. I can be glad to explain to you my understanding of why that decision was made if you want.
And one of the pros would have been if you had said, hey, I better call Drew and tell him that we've got an issue. We could have all collaborated at that time with the Sandmans, and we wouldn't be here today 5 years later. Is that fair?
I don't remember that being one of the pros that we discussed.
Okay. Last paragraph. I just wanted you to know that I believe we're on the right side of this issue and have acted in good faith at all times. Did that give you any concern that You know, the old Shakespearean phrase, methinks he doth protest too much. Why is he saying, hey, hey, I'm not a crook like Richard Nixon, if there wasn't an issue?
I don't,
Overruled.
I don't recall my reaction to reading this email. Again, I've told you kind of the circumstances of the call that preceded it, and I think this was him following up on that discussion.
Okay, so at the top of the page, we have your response. Hey, Lynn, thanks for sending this, but it was unnecessary. I have zero concerns and know the issue with the fee splits only came out recently. Did I read that correctly?
Came up recently, but yes.
Came up recently, sorry.
Sorry.
So you had zero concerns at this time. Was that based upon your due diligence, checking that out to make sure that this issue hadn't been brewing previously?
No, my zero concerns were based on my own recollection that we had not discussed this issue in connection with the settlement. It had never come up, and it had only come up with regard to this settlement after this initial project was done. So I was basing this comment, meaning my zero concerns, on what I had experienced and what I knew in terms of my interactions with Lynn.
Right. But follow me on this. Isn't it fair to say that your conversations with Lynn are not important? It's what Lynn had with Todd McMurtry or with Nick Sandman that would be key, right?
Well, I would agree with you. I to be clear, I was not aware of any conversations Lynn had had like what you're suggesting. And so those didn't factor into my feelings at this point.
Did you call Todd and say, hey, this has just come up in a written format. I need to run this down with you?
No, I did not call Todd until July. I didn't see a need to. Lynn had assured us that this was something that had just come up, that he didn't have any familiarity with the issue at the time of the settlement agreement. I knew I didn't have any familiarity with the issue at the time of the settlement agreement, so it just wasn't a concern.
Okay, so it's fair to say you took him at his word.
Yes, and the fact that I wasn't aware of any evidence to the contrary.
Okay. Let's look over at Exhibit 85. And does this appear to be another series of email exchanges between you and Lynn dated about 10 days later, 5/27/2020?
Yes, these are back and forth emails with Lynn between May 26th and May 27th.
Okay, at this time, Your Honor, plaintiffs would offer Exhibit 85 into evidence. Yeah, it's right here. That's volume 2. Michael, can you, oh, Michael's already up there. Can somebody? See,
I'll just take a quick.
Or do you have it, Drew?
Okay.
I do, but I can't
Oh,
read
yeah.
this with you forever.
Excuse me.
Oh, he's got there. White one's good.
No objection, Your Honor.
All right, P85 admitted.
All right, Mr. Burby, let's look over at page 2. And like a lot of these email chains, the newest one is in the back and they come forward, right?
Yes.
So let's look at Lynn's email to you dated May 26, about 10 days after Exhibit 83 at 8:35 p.m. It starts with great minds think alike.
I see that.
Okay. And he says, great minds think alike. Ha. Obviously referring to some prior communication you all had. Then he says, I'm pulling together all the emails regarding the WGW matter in advance of our call tomorrow. The next paragraph says, one question that we have not really discussed is the law in Kentucky and Georgia says that the client must agree to any division of fees at the time of distribution. I recall checking on this some time ago and finding that is required in Georgia. I have some recollection that Todd told me this was the same law. The law was the same in Kentucky. Sorry, I read that backwards. This could be a major problem and deficiency in the agreement. When you got this, what did Lynn tell you about when he talked about it with Todd and what they said?
I don't recall.
Is it possible that you didn't say anything to him?
I just don't recall. I don't know if we talked about these emails or the subject matter on May 26th of 2020, but I certainly don't recall at this point.
But it would be material whether Lynn had conversations with Todd about the enforceability of the agreement before he entered into the agreement, wouldn't it?
Objection, argumentative.
Material to what, I guess? I'm not.
To your analysis of good faith?
Well, I don't think this is material to the question of whether Rule 1.5 applied to the fee splits in the settlement agreement. If your question is whether it would be material to whether Lynn entered into the agreement in good faith, I suppose, but we really weren't looking at that at this point. That really only came up in connection with our assessment that Lynn had an obligation to seek consent as part of his obligation to fulfill his obligations under the settlement agreement. We weren't, at this point, we had no reason to believe Lynn wasn't acting in good faith with respect to the settlement agreement.
The third paragraph says the Sandmans informed Todd McMurtry before the agreement was made that they would not agree to any fee payment of fees to associated counsel in excess of quantum merit. Did I read that correctly?
You did.
Well, now that must have prompted you to call Lynn and say, y'all talked about this with the Sandmans and agreed that something other than what we put in the settlement agreement would control?
I mean, this statement was consistent with the emails that I had seen before we were engaged. They were exchanged between Lynn and you and Todd McMurtry and you about what the Sandmans would and wouldn't do. So this was nothing new. This was consistent with what was in those emails. So it didn't cause me to do anything. I'd seen the emails. This is what I understood to be the Sandmans' position, but I hadn't spoken to them and didn't feel a need to.
Did you ever ask Lynn, why on earth would the Sandmans care what Lynn did with his portion of the fee?
I don't recall doing that.
And we are talking about Lynn's portion of the fee, not that the Sandmans would pay any more. Is that right?
Talking about in the fee split provisions in the settlement agreement?
Yes, I am. I'm sorry, I didn't ask that question very well. The fee split provisions of the settlement agreement only required Lynn to pay more, not the Sandmans, right?
He and his firm, I think that's correct.
Yes.
They were receiving a fee from that case, and then the settlement agreement called for he and his firm to pay, or his firm to pay a portion to the plaintiffs.
And Todd wouldn't pay any more. He got his portion, and his portion's not controlled by the settlement agreement, right?
Todd and his law firm were not a party to the settlement agreement, so I don't think whatever he was being paid was affected by that.
Okay, but let's look at the next paragraph. Candidly, if we explain the fee dispute and resolution to Nicholas, I do not think he will agree to the payments to WGW. Hold on one second. We good? Everything all right? Do you need a break? Oh, sorry. All right. Next paragraph. Candidly, if we explain the fee dispute and resolution to Nicholas, I do not think he will agree to the payments to WGW in excess of quantum merit. He is a very principled young man. Ever have any question in your mind. Why on earth would a 17-year-old newly minted millionaire care how a 70-something-year-old trial lawyer spent his money?
Let me answer it this way. I don't know at this point in time, but certainly when we ultimately were recommending that Lynn seek consent, I thought there would not be a problem getting consent because I figured Nicholas or his family wouldn't care necessarily how Lynn spent his portion of the fee.
Sure. And as you look back and look at this now, does it sort of indicate to you that maybe you were never going to get consent because that bridge had already been burned in prior conversations as you sit here today?
I don't so much. I cannot go back in time and put myself, at that moment to be. Or you're asking me as I sit here today, how do I feel? I haven't thought about this. There's so many documents and emails.
You are lucky.
Well, I'm just saying, I really don't think it's a fair question. I don't. There's so many emails and documents, and I don't have any reason as I sit here to question whether Lynn knew more, had already gotten or spoken to the Sandmans about this. I don't know is the answer. Maybe he did, maybe he didn't.
Let's look over at the first page of Plaintiff's Exhibit 85. Third paragraph, you say, note that our plan for tomorrow is to discuss your general relationship with WGW and then discuss each of the cases identified, etc. So your plan on May 26th was to get into the facts of the relationship between WGW and Lynn.
That's right. That's what's a little frustrating about Lynn's email on the 26th is he was talking about a lot of things when we had not, at this point, even gathered the facts that we would need to then analyze and look at the law and see whether, in our opinion, the rule applied. So we were at the beginning of this project. And the purpose of this email was to set up a call with him to get the facts, which we had, I think, the next day.
Okay. So if we look at the top of the page, your email, Lynn's email back, the third email, second paragraph, he says, I think the requirement that the clients approve at the time of settlement distribution may be in the case law, if not in the rules. I recall Todd and I looking at this issue at some point and concluding it was applicable in both states. Did you immediately, I guess we know the answer to this, but did you call Lynn and say, when did you discuss this with Todd in detail and determine its applicability?
I don't recall doing that.
As you sit here today, that kind of a conversation between Todd and Lynn could be very material to this claim, couldn't it?
To whether Lynn entered into the settlement agreement in good faith?
Yes.
I think if Lynn and Todd had conversations prior to the settlement agreement about taking steps to ensure consent would not be obtained as might be needed under the settlement agreement, I think that would be relevant. I don't know that this jumps out at me as referring to that. I knew there had been discussions prior to our engagement between the three of you about quantum merit and how that impacted things. So I think I probably assumed this was more of the same discussion that he was referencing, that he and Todd and you had on that subject.
Okay. So back to the idea of facts. Y'all were going to talk about the facts. Let's look at Exhibit 95. And does this appear to be your July 13th memo to Lynn from your firm?
I think we admitted that earlier.
You did, and it was Exhibit
The
90 something, wasn't it? In the 90s? No, here it is. It's D20. So you can go D20 or P95, dealer's choice.
I've got P95 in front of me.
All right. So you got to turn a couple pages in because it's got the transmittal emails and stuff.
Yeah.
And yeah. I'm looking at Bates number 2933. Facts.
Okay.
What was that number again?
2933. Facts.
Hold on. So, pardon me, what's the exhibit?
20.
20. You're 20.
Where are you there?
All right, I'm looking for the Bates number.
You don't have them on yours.
That's not gonna help me. What page is it?
Third page of the exhibit.
Third
Right
page
there.
of it.
Right
Under
there.
facts?
Yep.
Okay.
Now, I believe Mr. Exum read some of the facts into evidence with you. We started at the second paragraph. Nicole was never an employee or partner of L. Linwood PC, but she was occasionally held out to be. Nicole, her own law firm, et cetera, and the signing of the lease. Do you remember testifying to that?
Somewhat.
Okay. Is it fair to say that the only facts you had about the nature of their relationship, as you testified previously, was contained right here in this section entitled Facts on page 3 of your July 13th memo to Lynn about his relationship with WGW?
I think that's slicing it a little thin. I think we had certainly a lengthy discussion with Lynn about the facts, and he had provided us with certain documents. I think this was viewed as sort of a summary of the facts. Certainly the material, important facts that we had learned were intended to be here. If you're wanting me to say we had no other single fact other than those stated here, I can't say that. I don't remember that. But certainly the important facts that we were provided should be here.
Okay. Did Lynn ever tell you? It's fair to say Lynn never told you that the only cases they ever worked on from 2016 to ending their partnership in 2020 were worked on through L. Linwood PC.
That's correct. I agree with that.
You did not say that.
Yes.
And that's a material fact, right?
I think it'd be relevant to the analysis for sure.
And he didn't tell you that they had signed the lease as partners.
I don't know if we discussed that. We may have had a copy of the lease, so we may have seen that. I just don't remember. Sorry.
And when you looked them up on the website, what popped up in front of you when you Googled the firm?
I don't recall. I don't even know if the firm website was still up at that point. They were obviously no longer working together.
What did Lynn tell you about what was on the firm website?
I don't remember.
Business cards?
What did Lynn tell us about the business cards they used? I don't remember if he told us anything.
How about pleadings, the way they signed pleadings?
I don't recall a discussion about that fact. I mean, we knew that they held themselves out to be part of the same firm, including, I think, by pleadings, signing pleadings as if they were part of the same firm. But it was our understanding that was not always the case, and that they did have their own clients and operated as their own lawyers, as not part of his firm as well.
Let's turn over to page 9 of your analysis.
That was on page 5.
And at the top of the page, does it have an 8 in brackets?
It does.
Can you read that for us?
Yes, this is comment 8, I believe, to rule 1.5E. It says paragraph subsection E does not prohibit or regulate division of fees to be received in the future for work done when lawyers were previously associated in a law firm.
Let's look over at Plaintiff's Exhibit 18.
Okay.
Just 1 second, Your Honor. There. Does Exhibit 18 appear to be a pleading that was filed pro hoc vice admission of Jonathan Grunberg in the Salmon case?
Yes, it does.
And does that, as you look back into the memorandum attached there too, does that seem to indicate that Mr. McMurtry is representing to the federal court that Jonathan Grunberg is a partner at the law firm of L. Linwood PC?
I'm sorry, where do you want me to look? Oh,
At the memorandum attached to it?
Yes, it states under local rule 83.2A1, Mr. Grunberg is a partner with L. Linwood PC.
And let's, and you would agree that representations to the court, all lawyers have a duty of good faith and complete candor.
I agree.
And this requirement of representation of your relationship to the parties is important in a motion to be admitted in federal court outside your home jurisdiction where you're licensed.
Sorry, can you say that again? I'm not sure I've followed you.
And the purpose of this document, Exhibit 18, is to get Jonathan admitted to practice in a federal court other than the state of Georgia.
Agreed.
Right. And the law requires that you make these representations, that you're in good standing with your home court, that there's no problems with your bar license, and your relationship to the parties.
I'm not totally familiar with what the pro hoc vici rules are in this court, but generally speaking, you have to represent that you are in good standing in the court where you are licensed to practice. The rest of it, I'm not as sure of.
What page is it? Thanks. Let's go back to 95 and look at page 13 of that letter. Sorry.
Okay.
Turning those pages.
Should I keep that one open?
No. We're done with that guy.
Okay. 95?
Yeah. We're on page 13.
Oh. Okay.
And that's page number 2939.
Okay.
So we were right there a minute ago when we read paragraph 8. I shouldn't have taken you off that. I apologize. Comment 8. The next paragraph says Rule 1.5E is only implicated when a fee is to be divided between lawyers who are not in the same firm, end quote. In addressing this threshold question, courts seem to focus on where the participating lawyers were at the time the agreement to divide fees was made to determine whether they're in the same firm. And then you've got a cite to a treatise. And then it says, however, one commenter has cautioned. Can you read this section to us?
Yes, this is from an article, law review article. I'm not sure. Lawyers who are otherwise independent contractors may be deemed to be in the same firm if they hold themselves out to clients as having such a relationship or practice together as a single collective business entity. This is a fact-dependent inquiry. A lawyer who maintains a solo practice may also be in the same firm with other lawyers by virtue of an of-counsel relationship with that firm. On the other hand, lawyers who merely share office space are not in the same firm for fee-splitting purposes as long as they do not divulge or share client confidences to take advantage of the collective experience of their association. In short, determining whether lawyers are in the same firm in this context is not always the simple task that one might presume it to be.
So you guys cited that because you thought it was relevant and material to your analysis. Is that fair?
Relevant, for sure.
Okay. So let me hand you.
This is just a commentator's view of the issue. So it was relevant, but I don't know that I'd agree it was material.
And that commentator's view closely tracks the rules of the State Bar of Georgia, does it not?
I think what you're referring, Rule 1.5 does not discuss this. I think what you're referring to is a comment in an earlier rule, which does have language similar to this.
Okay, and let's talk about that. I'm handing you what's been marked Plaintiff's Exhibit 400. Does this appear to you to be a copy of State Bar of Georgia Rule 1.0?
It does.
And let's turn over to page 4 and look at comment 2 and see if that's the comment that you were referring to under the heading firm.
Yes. So the term firm is defined in the rule, and then this is a comment afterwards.
Okay. Whether two or more lawyers constitute a firm within paragraph E can depend on the specific facts. For example, two practitioners who share office space and occasionally consult or assist each other ordinarily would not be regarded as constituting a firm. However, if they present themselves to the public in a way that suggests they are a firm or conduct themselves as a firm, they should be regarded as a firm for purposes of the rules. A group of lawyers could be regarded as a firm for purposes of the rule that the same lawyer should not represent opposing parties in litigation, while it might not be so regarded for the purpose of the rule that information acquired by one lawyer is attributed to another. The terms of any formal agreement between the associated lawyers are relevant in determining whether they are a firm, as is the fact that they have mutual access to information concerning the clients they serve. Furthermore, it is relevant in a doubtful cases to consider the underlying purpose of the rule that is involved. I read that correctly?
Yes, you did.
And so did that inform your consideration of whether WGW was actually in the law firm of L. Lynn Wood PC?
Yes, we did consider this in our communications with Lynn about this issue.
Okay. So it talks about how they held themselves out to the public. Can you think of a way that a lawyer can hold himself out to the public any more publicly than a website?
That seems like certainly one way to do so.
And perhaps the broadest way to publicize your identity. Fair?
I think that's fair.
Okay. How about how you're listed on the State Bar of Georgia's official registry of lawyers?
That would seem relevant to the issue.
Controlling?
No.
Honor, objection. This is going way far afield of attorney-client advice.
It's, I think right now, still in the bounds of cross, but I don't think we want to dwell on this all day, so overruled for now.
Yeah, I don't agree that it's controlling.
But certainly a big factor.
A big factor is whether there's an agreement, a formal agreement between the lawyers, and here there wasn't. So there are a number of factors that are identified here that are relevant for consideration.
It also talks about client confidences. In your own words, can you explain what you think they're talking about there? Is that the need to keep client confidences confidential?
Conversations, communications between a lawyer and a client are considered privileged, confidential. And I think they're getting to the point of if you are working with another lawyer and representing a client and you're sharing client communications with each other, that's a relevant factor for sure.
Right. So if I were to hire Alston and Bird to represent me and I told you something private about myself, you would have a duty to keep that confidential. Is that right?
I would.
But you could walk down the hall and discuss it with Chris, your law partner, and say, we're representing Drew and I've got this thorny issue. What do you think of this?
I could do that and not violate the rule of confidentiality.
Right. But you couldn't walk across the public hallway and go into another law, the Bondurant firm, and say, hey, you guys, Drew told me X.
I could not do that without violating the rule of confidentiality.
So here it says looking at client confidences is important.
I agree.
And what did Lynn tell you about the way he stored and shared client confidences?
I don't recall it at this point specifically. My understanding was that on the cases they worked on together, they shared client confidences. But then I also understood there were cases they didn't work on together where they did not share client confidences.
And can you describe for us the name or just identify any one case that was in the office during that time period that some of them worked on that the others didn't have complete access to?
I don't know the names of the cases. Maybe we were told them, but I, at this point, don't remember.
And there was no segregation of the server. All the cases were up there. Everybody had access to them.
No, I don't recall.
But that's a key factor, right?
I don't know that the server is a key factor, but we've talked about it, and I agree that sharing client confidences is a relevant consideration.
Now, when we look at this comment, it doesn't say anything about ownership of a firm, does it? As one of the determining factors.
I believe that's in the definition of firm, or at least reference to the legal entity. But I don't know that it talks about that in this particular comment.
All right, so there's no mention of ownership. Is there any mention of W-2 pay versus 1099 pay?
I'm just looking back at the definition of firm and law firm, but which does reference the legal entities. Is there reference to payment terms? No, I don't see any reference to that. 1099 versus W-2.
Okay, let's look back at page 1 because you referenced the general definition of firm. And at the bottom of page 1 of Exhibit 400, subpart G defines firm, and it says firm or law firm denotes a lawyer or lawyers in a private firm, law partnership, professional corporation, sole proprietorship, or other association authorized to practice law pursuant to Bar Rule 1-203 subpart D, or lawyers employed in a legal service organization or the legal department of a corporation or other organization. Did I read that correctly?
Yes.
And it doesn't say anything there about ownership.
I disagree. It says firm or law firm denotes a lawyer or lawyers in a private firm, law partnership, professional corporation. To be in one of those legal entities is either to be an owner or an employee. I think that's a reasonable interpretation of that.
But you'd agree with me that none of your interpretation is in this word, in these words.
It says in a private firm, law partnership, professional corporation, sole proprietorship, etc.
Right. So you base your entire opinion about ownership based on the word in.
I mean, I think going back to 1.5, it talks about whether lawyers are in a firm or not. And I think most lawyers would say you're in a firm if you are a partner, you have a ownership interest via a partnership, a corporation, an LLC, whatever the legal entity is, you have an ownership in it, or you're an employee of it. And I think that's what we were basing it on from 1.5. And this, to me, is consistent with our interpretation of 1.5, where it says firm or law firm denotes a lawyer or lawyers in a private firm, law partnership, professional corporation, et cetera. That's how we interpreted it.
So are there
There may be-
partners
yeah.
at Alston and Bird who do not have an ownership interest in that firm?
Yes. And we are all partners in a partnership agreement. Whether you
And-
have an ownership interest or not, you sign the agreement and are bound by the terms of the agreement.
And do you know any case anywhere that requires a signed contract for a partnership?
You're talking about just in general? Any type of partnership? I guess I'm not sure I follow your question. You're talking about in the context of this rule?
Can move on. But we can only do that if I can find my notes. There you go. There we go. All right, let's turn over to page 14 of your memo. You read a great deal about the duty of good faith and fair dealing.
Sorry, do you mean
Yeah.
page 14 of the
Page
memo
14,
or?
it's page number 2944.
Okay, yes, I'm here.
And the duty of good faith and fair dealing is a sort of a general legal principle under Georgia law, and it is inherent in every contract under Georgia law. Is that right?
I agree with that.
And it requires that parties to a contract enter into the contract and attempt to execute or perform under the contract in good faith at all times. Is that right?
That's my general understanding. I haven't looked into that in probably since the time of this memo, so it's not something I'm very familiar with, but that's consistent with my general recollection.
All right, let's look over at Exhibit 48.
Okay.
Did Lynn ever discuss with you these late night emails with Todd McMurtry dated February 22nd and March 4th?
So just to be clear, in 48, it looks like there's 4 or 5 different email chains. You're asking about all of them?
Yeah, take a second look at them. I didn't give you much time because you looked at them in your deposition. I thought they would jump out at you, but take a second. The first page is February 22nd at 2:42 a.m. The second one is same date, 2:58 a.m. And it's much longer. It's 3 pages. And then the last one is March 4th at 1:16 a.m.
Okay, so just the first 3 emails, not
That's
the rest.
correct.
Yeah, because some of the other stuff looked familiar, but no, these initial emails between Lynn and Todd, I don't recall seeing. I think the first time I saw them was when you asked me about them in my deposition.
Do they seem to indicate that Lynn and Todd were discussing enforceability of any fee splits on Sandman close to a month before they executed the March 17th agreement?
I'd have to look at them a little closer if you want me to do
Okay.
that. but I don't remember the
Let's
content.
start with the first one. The second paragraph.
This is the February 22nd,
Yes.
2020. Okay.
In the first paragraph, he says, as you can easily see from the hour of this email, I'm spending entirely too much time dealing with the foolishness of Taylor, Jonathan, and Nicole. Then three sentences down, I know Andy Beal's law partner, Ed Buckley, talks about that. The next paragraph says, I can explain more to you tomorrow by phone, but I'd like to ask you to consider preparing a letter from you to Beal and a letter signed by Ted and Julie to you or Beal, making clear that there is express directive that no fees be paid to Taylor, Jonathan, and Nicole that exceed quantum merit basis, regardless of any agreement I made or attempted to make to get rid of their foolishness, to prevent it from harming my future efforts for Nicholas and others. So does that refresh your recollection that this was an attempt to get the Sandmans not to agree back in February?
I mean, I don't have any recollection to be refreshed. I'd never seen this document before. You've read it correctly.
Would it have been important for you to know that those kinds of communications happened a month before they entered into the settlement agreement?
It wouldn't have been important to the Rule 1.5 analysis. It would have been important as to whether Lynn was acting in good faith. I think I would have liked to have known this and talked to him about it and let him explain this to me. We never had that conversation because he never shared this with me.
Thank you. The last sentence of the first page, in short, Jonathan, Taylor, and Nicole are trying to claim 50% of my fee while attempting to stick me with 75% of the outstanding liability owed on the office lease. Their greed will not be honored by any court, but their efforts to be greedy could damage me, my family, my legacy, and my clients, which include your clients, the Sandmen, if the disputes become public. This needs to be nipped on the bud and quickly so. Does that indicate to you that Lynn was planning to destroy this deal before he got into it?
I'm not prepared to draw that conclusion from it. I don't know what to make of this. There obviously wasn't a settlement agreement on the table. We weren't involved at this point. I don't know what he was trying to do.
Are you aware of the February 17th settlement agreement that he had entered into and was confirmed in writing by Taylor Wilson?
I'm familiar with Taylor's email memorializing the terms they had agreed to. I don't remember how quickly Lynn changed his mind and rejected that settlement.
If we look at the middle of this paragraph, it says, if they realize that they're not going to receive $843,750 for the CNN case, they will have no, all caps, ability to finance their frivolous claims regarding the fees in CNN and the remaining office lease liability. Worst case scenario will be that I will be authorized by the clients to hold my PC's portion of the CNN fee in my escrow accounts pending resolution of the disputes between me and WGW. That alone will cut off their ability to finance and publicize their BS claims against me. Did I read that correctly?
You did.
So take a second, look over the second longer letter. Does it appear to be the exact same thing, Lynn urging Todd to find a way to back out of any deal he entered into?
It's going to take a minute to get through. I don't know that there was an agreement at this point that he was trying to back out of, and on February 22nd, hadn't he already?
February 17th agreement and any subsequent agreements?
If we approach the bench, Your Honor.
Good.
Oh, okay. I'm sorry. Yeah, that's good. I got it. We don't have to be. It's not.
All right, next question, or to the extent there was one still out there, you can answer it.
Okay, let's turn over to the third page of that exhibit, the March 4th email.
Okay.
Now, this is the same day that he reached out to your firm to hire Alston and Bird. Is that right? Wasn't it March 4th and you guys signed the contract on March 6th?
It was certainly close in time, may have been that day or within a day or two.
Okay, let's look at the first sentence. I am prepared to offer WGW fees on quantum merit basis only for Carboni and Lindsay. Their problem on those cases is that they did not keep up with their hours and can only reconstruct them after the fact of settlement. Did I read that correctly?
Yes.
Now, we saw all these notes in your billing records of April and May, where you first got into this issue of fee splits. And it was something other than Sandman, remember?
I do.
And it was actually Carboni and Lindsay that you guys were looking at, right?
As I recall, it was Lindsay, and it was not the Lindsay settlement that was part of the settlement agreement, but a different settlement is my recollection. With a different, and the referral fee was paid to a different lawyer, not to your clients.
When you look at this, does this indicate that he was thinking about quantum merit only on Carboni and Lindsay, even though the settlement agreement talks about a percentage?
I mean, it says I'm prepared to offer WGW fees on a quantum merit basis only for Carboni and Lindsay. That's what it says. That seems to be what he's thinking about on March 4th. There was no settlement agreement, formal settlement agreement at that time.
Okay. Second paragraph, the dollar amount that I'm willing to offer these foolish people in an effort to be kind and attempted to do God's will is only a portion of the Sandman versus CNN fee due and payable to LLWPC. After considering the absurdity of the demand they made upon me yesterday, I am now inclined only offer them between 100,000 and 200,000. Any monies I offer them shall be in excess of the monies they are fairly entitled to under the law and the statement of our clients, $0. Did I read that correctly?
You did.
Approach the bench, Your Honor.
And your
All right,
understanding.
he's asked to approach, Mr. Beal. So I'll read the first sentence of them, Mr. Beal, take a look.
You read my writing.
Maybe just. All right, I'll read the first sentence of getting across. All right.
Okay.
Yeah. It's all right.
It's a waste of time. All right, members of the jury, I'll just want to offer you the instruction, which is that there is plaintiff's
Objection, Your Honor. I'm sorry. I thought you had ruled against that.
Yeah. No. All right, members of the jury, I'll be charging you in more depth at the appropriate time, but instruct you at this point that the breach of contract claim in this case is premised on the March 17th settlement agreement. All right, you can continue, Mr. Beal.
Okay, let's go back to Exhibit 85.
Okay.
It says in the first paragraph, when Lynn is responding to you, so you know, the Sandmans were not informed of any fee split at the time of the engagement, but only authorized engagement of, quote, local counsel, as we thought there could possibly be cases filed outside of Georgia. Did I read that correctly?
Yes.
Was that your understanding of the contract, or did it refer to all other counsel hired in this case?
I don't know that I had the engagement agreement for the Sandman family at this time on May 26th of 2020. We certainly obtained that at some point, and I don't recall the exact language of the agreement.
Okay. Rather than, do we have 286 in evidence? Their contract, Ted and Julie. All right, Your Honor, at this time, why don't you turn over to Exhibit 286 in Volume 2? Do you have Volume 2?
We do. Oh, I don't know if he does it.
Step on it. Thank you.
I think I only have volume 1.
Okay, here's 2. 286.
Do y'all have an extra volume 1 by any chance? Drew, do you have an extra volume 1? So we can get ours back.
We should.
This is volume 2. No, this is ours. This is defendants.
Oh, that's right. Your Honor, this has been admitted into evidence under Todd's testimony. It was his deposition, Exhibit 17, Trial Exhibit 286. And it's in evidence. And so you don't need to pull it up, Joey. Let me just read it to you. Client also understands that the firms may associate joint and local counsel in the prosecution of this matter if necessary due to jurisdictional requirements, and the firms have the right to select and/or associate with additional attorneys as necessary with your prior approval. No additional attorney's fees shall be owed by client under this engagement agreement as a result of LN Wood PC and/or Hemmer DeFrank Wessels PLLC associating with local or other counsel in this matter, and LN Wood PC and Hemmer DeFrank Wessels PLLC agree to compensate such counsel out of the contingency fee earned by LN Wood PC and Hemmer DeFrank Wessels PLLC under the terms of this engagement agreement. Were you able to find it?
Yes.
That seemed like I read that right?
Yes.
Okay. So would it be fair to say he says local or other counsel, and that they may hire other counsel?
It says the firms may associate joint and local counsel. Is that?
And then
Sorry.
3 lines up from the bottom.
Let him finish.
Oh.
3 lines up from the bottom of that page, with local or other counsel in this matter. Is that correct?
Yes.
And 6 lines up from the bottom, and that the firms have the right to select and or associate with additional attorneys as necessary with your prior approval. Is that correct?
Yes.
Okay. when Lynn said that it was only lawyers in another jurisdiction, did you ask to see a copy of the contract? Take a look at that.
We did ask for the Sandman engagement agreement. I don't think in response to that email he wrote, but we did obtain it from him.
So at the bottom of this Exhibit 85, you talked about you guys were going to get the facts. We talked about what facts you did get and what facts you didn't get. Did you ever call Todd and ask him to verify any of the facts that Lynn represented to you?
I don't recall doing that.
All right. So do you have any opinion about how Todd characterized WGW? Did he call them their partners?
Do I have an opinion on how he, I don't know how he characterized them. So okay. I don't have an opinion on what I didn't know.
Okay. And that's because you didn't ask them, what do you think about these guys' relationship with Lynn?
I don't remember the discussions with Todd at this point. So many years later, if we talked about their relationship, it just doesn't stand out in my mind. I don't recall how he described it if he did.
Is it fair to say that it's virtually impossible to conduct a legal analysis of a situation if a client does not share the complete and honest portrayal of the facts?
Let me say it this way. I agree that that's critically important to giving good legal advice, is to have all the information.
Thank you. And you didn't have all the information here about the nature of their relationship, did you?
I would say that things that were alleged in the complaint factually as to their relationship, there were things that were different or new that we were not aware of based on our discussions with Lynn.
And that caused you to write a follow-up summary to, for lack of a better word, walk back some of your analysis and qualify it.
I would say change our analysis and our just our analysis based on the facts that we saw in the complaint and some of the additional research we had done after the memo was given to Lynn.
All right, let's turn over to Exhibit 86. Does this appear to be a legal, internal legal research memo from one of your associates, Sarah, to you that you forwarded to Lynn?
I wouldn't characterize it as a memo. I think Sarah, who was the associate assisting Chris and I on this project, sent me an email identifying the difference between the Kentucky Rule 1.5 and the Georgia Rule 1.5. And then I forwarded that to Lynn.
Okay. And they're virtually identical. In fact, I couldn't see any difference, but
they seem to have some different subsections, but
Others testifying.
Real? You want to rephrase?
Well, they're basically identical.
I'd have to do it line by line. They look similar. I mean, I was pointing out that I see some different, there's a subsection 1A, 1B in the Kentucky rule that's not in 1.5, but my recollection is that they were very similar, if not identical.
And neither of these rules would apply if the lawyers were formerly associated in a firm. Is that correct?
Well, they wouldn't, neither of them would apply if they were in the same firm at the time the fees are being split. And I think what you're getting to is the comment to 1.5, which I think is in both of the rules, which addresses what happens later when the lawyers are no longer in the same firm. Can they still split a fee for the work they did when they were in the same firm? And the comment says they can. I mean, obviously here, when the fee split was agreed to in the settlement agreement, the plaintiffs...
Going off the reservation a little bit. I think you've answered it.
Okay.
And in fact, when you say in the same firm, the phrase is associated, previously associated in a firm. Is that correct?
I don't have the comment in front of me, but that sounds correct or close to correct.
Okay, so look over the Georgia rule, subsection E, with parts 1, 2, 3, and see where it says consent, and point me to that.
I think you're talking about E2, which requires that the client is advised of the share that each lawyer is to receive and does not object.
Okay, so the word consent is not in the rule.
It is not.
It says does not object to the participation of all the lawyers involved. Is that correct?
That's what it says.
So it has nothing to do with consenting to the fee share. It has to do with object to the participation of all the lawyers involved in the representation, right?
I disagree. I think these are subsections under the discussion of when lawyers can divide a fee. And whether you use the word don't object or consent, I view those as the same thing. If you don't object, you consent. If you consent, you don't object.
But what is it that you gotta object or consent to? Is it the fee split or is it to the participation of the lawyers involved?
I mean, as I recall in our memo, what we wrote is what we believed at that time. And what I thought we wrote was that this was talking about the split. That's what the whole rule is about, splitting the fee, not the
Okay.
participation of the lawyers.
So read it with me. A division of a fee between lawyers who are not in the same firm may be made only if, number one, the division is in proportion to the services performed by each lawyer or by written agreement with the client. Each lawyer assumes joint responsibility for the representation. Then number two is the client is advised of the share that each lawyer is to receive and does not object to the participation of all lawyers involved. And three, the total fee is reasonable. Did I read that correctly?
You did.
Okay, so the phrase is consent does not object to the participation of the lawyers involved. Are you aware that Nicholas Sandman has testified that he did not object to the participation of WGW as lawyers for him in this representation against CNN?
Objection, Your Honor. Maybe we put some bench. John will come up with me, but
Maybe on this question, I think he can answer this question. I think I can anticipate the grounds of your objection here about.
he's left out subpart A.
All right.
A division of a fee.
Okay.
And then applies 1, 2, and 3 to the division of a fee.
All right. I think that's something you could bring up on cross, but really, I don't think we need to go down this road much further because he's expressed his opinion, and ultimately his opinion is irrelevant because I'm going to instruct the jury on the law, and they make the ultimate determination. So I don't know how much time we really need to keep spending on this.
So the last question was, are you aware that Nicholas Sandman did not object to the participation of the lawyers involved?
I was not aware of that. I don't know what Nicholas Salmon has testified to, other than in the affidavit that we prepared for him.
When the decision was made to push this off until Nick turned 18, was there discussion about signing a new fee contract with just Nicholas? There was, wasn't there?
I'm sorry, I'm trying to remember. I mean, I think as this issue of consent came to fruition in the June, July time period, and we were talking about asking Nicholas to consent or not object to the splitting of the fees. The settlement still had not been approved by the court. And there was also a probate court involved because it was his parents that technically were the client. He was turning 18 in mid-July, as I recall. And I believe the discussion with Lynn or with Todd McMurtry was they were going to be meeting with him for him to, or Todd would be meeting with him to sign a new engagement agreement now that he was an adult, and that he would be presented with the consent request at that time since they were already meeting.
And did you insist at that time that WGW be listed on the settlement agreement in order to fulfill insist that WGW be listed on the disbursement schedule in order to effectuate the terms of the settlement agreement.
I did not have any involvement with the disbursement agreement or document.
Okay, let's look over at Exhibit 103. And this is a many-page exhibit. Again, I'll represent to you that it's the emails, more emails back and forth with this Jeremy guy who represented the building.
Okay.
Okay, do you remember in general terms all these emails back and forth?
In general terms, yes.
All right, at this time, Your Honor, we would offer Exhibit 103 into evidence, all the emails contained therein.
Any objection to 103?
Find it, Your Honor. How many pages is this?
10 pages.
All right.
I have to take a break so I can look through this.
Well, while you're looking for 103, why don't you start looking for it? Let me inquire, Mr. Bill. We've got about an hour and 20. How much longer do you think you have?
20. I'm only going to be looking at the first 2 pages.
I started the other side. It's okay, just no objection.
All right, 103 is admitted.
Let's turn to page 2. Well, the bottom of page 1 and the top of page 2, does that appear to be your email to Jeremy Granello with a copy, subject line, LN Wood PC Regions Plaza?
Yes, it does.
Okay. And if we turn over the top of page 2, or the bottom of page 1, you say we'd like to revise the draft agreement as possible, as follows. Is this the edits to the lease? Now that WGW, we're no longer on the lease.
To the best of my memory, there was initially an amendment to the lease that was proposed. And then at this point in July of 2020, it was a buyout agreement where basically Linwood PC was going to pay an amount to be let out of the lease. And there was an agreement. I don't know if it was called I don't remember the name of the agreement, settlement agreement, but that's the agreement that we're talking about here.
How much was the buyout?
I don't recall.
Let's look at the top of page 2. You say add Lynn individually as a party and signatory and include mutually releases between him and the landlord. Second bullet point, drop the former partners from the agreement altogether. Paren, I know we requested that they be released, but have changed our minds about that. End paren. The third bullet point says add a confidentiality provision. So you remember writing that email, right?
I don't recall writing it, but I don't deny writing it. I see it.
So in July, you thought they were Lynn's partners.
No, what you read, drop the former partners, it's capital F and capital P. That was a defined term in the draft agreement. I was using the language of the agreement that said former partners that I think was drafted by the landlord. I wasn't expressing an opinion about whether they were partners or not.
So there was actually a defined term in the agreement that says former partners, identifying these three.
I think so. I haven't seen that agreement in a long time.
And so you're asking that they not be released from liability under the lease, right?
That was Lynn's direction to not have them as a party to the agreement at all, and therefore they would not be released.
But do you remember under the settlement agreement, Lynn promised to get them a release?
I think the language was a little more complicated than that. He also agreed to indemnify them if there was no release. And so he was still bound to indemnify them. If the landlord wanted to go after them for the rent, he would have to pay the plaintiffs. So
let's see how complicated it is. Let's look over at 102. And we're on page 3, office lease. Subpart B, WGW, which as noted above, includes its members in their individual capacities and their respective LLCs, end paren, shall have no further obligation or liability under the lease. LLWPC will take all necessary steps to remove the names of WGW members from the lease and or to ensure that they have no obligation for further lease payments, including, if possible, obtaining a release from PR2 Regions Plaza, LLC of WGW, or if such release cannot be obtained, LLWPC and LN Wood individually shall agree to indemnify WGW against any claims by PR2 Regions Plaza, LLC, or any affiliate, subsidiary, related party, or assignee related to the lease. Did I read that correctly?
You did.
Okay. So it says that Lynn will take all steps necessary to remove the names of WGW from the lease and or to ensure that they have no obligation for further lease payments, including, if possible, obtaining a release from, and then you said the full official name of the landlord. So I think your email says they had already agreed to release these folks from the lease, right?
Excuse me. That the landlord had? I'm not sure I understand.
Who else would be released?
I don't know what the form of that
Landlord.
objection is. I
Maybe
mean, if you don't,
No. He's got to follow.
Is he ruling or am I, or is it your honor?
yeah, Mr. Wood, just because you don't understand the question.
No, I do understand the question.
Okay.
Ms. Lee,
Okay,
want to come up?
just a second. Mr. Bill, I think you ready argument here? Not going to sustain it.
He's already testified that they had an agreement.
Excuse me. You just sustained my objection. He's trying to talk about it again. Do I need to come up here?
That's fine. I think we've heard it. Okay, objection is noted, it's overruled, and you can answer the question if you recall it.
I think I remember it. The draft of the agreement that preceded my email had a release from the landlord of your clients. It also was a term, I saw the name of the agreement now, it's a termination agreement. So the lease was being terminated. Nobody would be a party to the lease anymore. There was release language. Lynn asked us to take it out. We took it out. He still had the indemnification obligation in the settlement agreement.
And it was Lynn's decision to go back on July 21st and remove them from any release under the lease. Is that correct?
What I conveyed to the landlord's attorney came from Lynn, yes.
And I believe you've already testified that the landlord had agreed to release WGW from any lease obligations prior to this.
That language was in the draft agreement. The agreement had not been signed, but I believe they were amenable to that.
Yes. And then 103A is the edits where you took out the term former partners and took out all the reference to them. Is that correct?
I don't think these are my edits, but I see a number of edits to the former partners language.
And
I don't see where partner is defined. I'm looking to see.
And on the last page, the signature line for Taylor, Jonathan, and Nicole is all struck. Is that correct?
Yes, it is. It just has Linwood's name.
All right. Thank you very much. Let's move on. There we go. Okay. 106. Can't read my own handwriting. Sorry. Let's look at Exhibit 106, which is already in evidence. And is this the letter from Chris to me on July 24th saying that not going to pay? Deal's off.
I don't think that's a fair characterization of the letter, but it is a letter that Chris sent you on July 24th, 2020.
And this is something that you were part of, even though Chris actually signed it. These were your words as well, your position, the firm's position.
I don't recall that I wrote this letter. I think Chris wrote the letter. I would have seen it, I assume. But at this point, I don't remember what my involvement was in this letter.
Right. July 24th was the actual date of Nick's 18th birthday. Is that correct?
I don't remember.
And if it were, it certainly indicate that he turned 18 and he immediately, according to you, denied consent. You drafted a letter and emailed it to me all in one day. Was that a busy day?
What I remember was that Todd McMurtry met with Nicholas on his 18th birthday, which maybe was July 24th, to have him sign the new engagement agreement where he was the client now that he was an adult, and to also present him with Lynn's request that he consent to the fee split in the settlement agreement. They had that meeting that morning, I believe. Todd conveyed to us that Nicholas had not signed the document for the consent, and that Nicholas wanted to see proof of the work that your clients did on the cases before he would consent. We conveyed that to you in this letter. I think this was sent 4 o'clock in the afternoon. 3:30. Yeah, I think it's 4:30 actually. 4:03. Yes, that's what happened as I remember.
It talks about Nicholas demanding contemporaneous time records. When did Nick tell you that he demanded contemporaneous time records?
Nicholas never told us anything directly. Todd McMurtry conveyed to us after he met with Nicholas, to the best of my memory, that Nicholas wanted to see proof, documentation, something of the work that was performed by the plaintiffs on his case. I don't remember what terminology or phrasing Todd McMurtry used, but I believe Chris attempted to capture that here in this letter.
So the idea of the language, contemporaneous time records came from you and Chris, not from Nick and Todd.
I really don't remember. I've told you what I remember being conveyed by Todd, which is also reflected in the letter. And I don't remember whether the specification of contemporaneous time records was something that Todd said that Nicholas had asked for, or that we or Chris added to reflect, something that would actually show the work that was done, similar to my invoices that we've talked about.
Are you aware that Todd testified that there never was a request from him or Nicholas for contemporaneous time records?
Yeah, now we're going back. I don't think we need to litigate this case through his opinion. He's expressed his opinion on what he conveyed. I don't see the relevance.
Okay. In the second page, you talk about, well, did you guys ask for contemporaneous time records because you knew that WGW didn't have them?
This is the only time, we wrote to you a number of times asking for proof of the work that was done. This is the only time I remember the phrase contemporaneous time records, because we also eventually asked for an affidavit or any proof of what was done. There were discussions with Lynn about what evidence the plaintiffs would have to prove their work and whether they would still have access to it or still possessed time, whether they kept records, detailed time records like you saw in my invoices. I don't remember the timing of those discussions with Lynn, but we did have those discussions. He certainly told us that he thought they would have trouble identifying exactly what work they did. But to be clear, we weren't asking for something here we didn't think existed. We actually wanted this evidence because we understood that that's what Nicholas Sandman wanted to consent, and we wanted to get his consent.
But that evidence would have only been relevant in a quantum Merowit analysis, right? It wouldn't have any relevance to paying under the settlement agreement, the amount specifically stated in the settlement agreement, would it?
No, it's relevant to the Rule 1.5 requirement that the fee be proportional to the work that was performed and be reasonable. So that's why these records were being requested, I assume, so that Nicholas and Mr. McMurtry could look at the work that was done, confirm that the fee split in the settlement agreement was reasonable and proportional to the work that was done.
Okay.
That was my understanding of why it was requested and why we were requesting it.
So the law is that the overall fee be reasonable. Is that correct? It has nothing to do with their fee. It has to do with the overall fee is reasonable. We can go back to 1.5.
No, that's not my understanding, Mr.
All right, let's go back to 86 real quickly.
All right, that's not his understanding. And to the extent we need to get into jury instructions, we'll handle that at the end of trial. I don't see why his understanding is now relevant. All right.
Look back at 86, please. Subpart 3. Can you read that for us?
80s. The total fee is reasonable?
Yeah. The total fee is reasonable. What steps did you take to make sure that the probate court in Kentucky thought the total fee to Todd and Lynn was reasonable?
I think we're talking about two different things here. What I was talking about in terms of the time records or the proof of work done relates to the proportionality of the portion of the fee, the share that each lawyer is to receive. That's subsection 2.
Okay. So just so we're clear, we're not talking about the reasonableness. We're talking about proportionality. Okay. So what steps, if any, did you take to determine how much Lynn did on the case?
We were focused on what your clients did on the case and asking for them to provide evidence of that.
But proportionality, doesn't that mean the amount of work you did versus the amount of work this other guy did? And I'm going to see how they stack up against each other. Isn't that sort of what proportionality means?
What I understood is that the way the fee is going to be split between the lawyers has to be proportional to the work they did on the case. So I would agree that Lynn's work is relevant to the portion of the fee that he was getting. He was the lead lawyer. It was his client. We certainly had discussions about the work he did. I don't think we had any concerns that he had not done work on the case. What we were trying to get was information from your clients.
And so when you asked Lynn about his fee records, what did he tell you?
I don't remember at this point.
But you were asking for theirs, right?
We were asking for
measuring proportionality, right?
We couldn't measure it because your clients never provided any records.
Did Lynn?
I don't remember.
I mean, you would have produced them if they did, right? Because it would have been part of your work file.
I don't think Lynn provided timesheets or that type of record. I think we did discuss his work on the Sandman cases and involvement in the cases.
Did Lynn ever give you an affidavit or a chronology or timeline of all the work and the things that he did and the value that he added so you could measure proportionality?
I recall having a pretty good understanding from him of what work he had done on the cases.
Based on what he told you?
Yes.
Okay. But you didn't ask Todd or anything?
About the work.
That fast. You did not ask Todd or anything. It was based on what Lynn told you.
We didn't ask Todd about the work Lynn had done on the case?
Right.
I don't remember.
So let's look at page 2. When the $89,199 owed by Ellenwood PC for the Carbonian.
Page 2 of what?
I'm sorry, of 106.
Okay. Give me one
I
second.
should have said that first.
Okay.
I'm going to move on. Let's look over at Exhibit 121.
Oh, 120. Sorry.
I got the wrong number. Hold on one second.
Yeah, mine's blank.
Yeah, Dexter.
189.
That was blank.
How about 128?
That'll do it. Fine, 128.
Yes. Sorry. Are you on 128?
Yes, I am.
Okay. Does this appear to be a memo that you sent to Lynn, or excuse me, an email regarding his communications with Dexter, Dexter King, and our concerns that it was disparaging?
That was among the topics that.
Okay, so the first one says you analyze that whether or not it is defamation. Did you ever think that the email that Lynn sent to Dexter King was disparaging to these people?
I honestly don't remember the email. Is that in 128?
All right, let's look over at 104. Dexter, I hate to write you this email, but you need to call me at phone number ASAP. Nicole Wade and her law partners are preparing to sue me tomorrow for fraud in a frivolous lawsuit intended to extort money from Nicholas Sandman that they did not earn, as demonstrated by their refusal to document their time as requested by Nicholas. I tend to expose Nicole and her partners publicly. They are putting their greed and personal interests ahead of the interests of their clients, including you. I have patiently worked with you on your bill. Nicole's efforts to extort money from me will bring my patience to an abrupt halt. I will not be extorted, especially not by crooks. I've never cheated anybody out of a dime in my adult life as a person and as a lawyer. You know my reputation and you know my integrity. Did I read all that correctly?
I'm sorry, I wasn't following, but it sounds right.
Did you ever tell Lynn, hey, that sounds like it might be a breach of the non-disparagement agreement?
I don't recall having that discussion. I recall being angry that Lynn copied us on this email without discussing it with us.
And you guys weren't representing Dexter, right?
Austin and Bird?
Yes.
No.
You had, And so his privileged communication shouldn't include you. Is that what you're saying?
Assuming he represented Dexter King, which that seems to be the case, I would think you would not include other lawyers on that.
Did he ever tell you, did you ever tell him, hey, man, I think that's a breach of the non-disparagement?
I'm sorry, I don't remember at this point if we talked about that or not. We may have.
Next paragraph, on one, exhibit 128, back on 128. Your email to Lynn of 8/28/2020.
I see that. Yeah.
Regarding all your messages they threw in the complaint, I think they'll claim they're relevant because you say you'll destroy them and you will never pay them anything. Paren, you frequently use the phrase, you won't get one thin dime, end quote, end parenthesis, and that this shows your state of mind and fraudulent intent in entering into the settlement, i.e. that you never intended to pay them, end paren. It's a stretch, but maybe enough. Still, I think we should consider a motion to strike, though once they're seen in the light of day, the damage is done. Was that your analysis at the time?
Yes, we were talking about, I think the complaint had been filed, I believe, or we'd
About to be, yeah.
About to be, or we'd seen a draft, and we were talking about all the things that were in the complaint, the recordings, the emails where Lynn, that did not reflect well on Lynn, and whether we would have any ability to strike those from the complaint is not relevant. And I was telling him, here's what I think they'll say as to why they are relevant, but I think we could try to strike them.
All right, then the third bullet point says, agree about asking Drew again for the time records, knowing, of course, that there's no way he will provide them because they don't have any records and or they don't support anywhere near the fee amount. I read that correctly?
You did.
So you knew at the time you demanded the fee records, there was no way they could give fee records because they didn't have them.
No, I wouldn't agree with that. This is in August, it's August 28th. We asked for the records of the work done or an affidavit over a span of like 6 weeks. I think at this point, you had not produced anything. I think Lynn was telling us they probably didn't have any records. I'm simply parroting what I understood from Lynn to be the case. Plus, we were in litigation mode now. You were filing the complaint. We were talking about how to deal with this situation.
Okay, and then when you say and or they don't support anywhere near that amount, how did you know what they would support and what they wouldn't support if you didn't ask Lynn and you didn't get time records and you didn't review the file and you didn't call Todd?
This is what Lynn told us.
Okay.
So we did talk about it with Lynn, and this is what he shared with us.
All right, let's flip over to 156. Does this appear to be my, oh, wait a second. Did we put that last one in? Your Honor, at this time, I would move exhibit 128 into evidence.
Any objection to 128?
No, Your Honor.
128 is admitted.
Thank you. Let's look at 156. Does this appear to be my January 11th, 2021 letter to Todd McMurtry?
That is what it appears to be.
And I got a carbon copy to you and to Chris, right? By email?
Yes.
And this one's already in evidence. Do you see the description of work there at the bottom of page 1, that long paragraph?
Yes, I see where you describe the work your clients did.
And did you ever call Todd and say, is that reasonable and accurate, or is Drew inflating things?
I mean, I don't recall speaking with Todd about your January 11th, 2021 letter or this description. I do recall at some point, I believe back more in the summer, Todd expressing a belief that your clients did not deserve the amount of money they were getting through the fee, that their work did not justify that. That was his opinion, I think.
Okay, let's look over at exhibit 189.
Mine is blank.
Is that the Dropbox link, Michael? Can you look on the screen?
Mine has a message about unmute or stay muted. I don't.
Oh, sorry. I hate to do this, but Your Honor, can I ask you to turn around and look at it there? I apologize. For some reason, it's blank in our binder. Does this appear to be an email from me to you and Chris with a Dropbox link?
Yes, it does.
Okay, and this is purports to be a whole bunch of documents relevant to this case. I believe you've testified already that you and Chris did not review the contents of that Dropbox link.
Oh, I don't remember testifying to that. I remember you provided the Dropbox link. I recall myself reviewing some of the contents. I can't swear that I looked at everything. There was a lot. I won't say what Chris looked at or didn't look. I'm not sure. I also don't know what the associate working with us looked at, but my recollection is it was mainly recordings, phone calls, emails, where Lynn was speaking in a hostile, aggressive tone. That's kind of what I remember of the Dropbox.
Referring back to that letter from Lynn to Dexter King on 121. And it's just one question. I meant to ask it while we had it up, but I believe you've already testified. You didn't see any evidence of extortion by the plaintiffs in this case.
Not extortion in the legal sense. I certainly didn't think they were committing a crime or you were committing a crime by threatening to file a lawsuit with all this embarrassing information about Lynn if he did not pay the settlement amount. I don't think Lynn repeatedly expressed to us that he felt extorted by that action.
Let's look over at Exhibit 129. We're almost done. Does this appear to be my email to you with a copy to Chris explaining the 4 parts of our case?
It's an August 29th email, 2020 from you to me, copying Chris and Todd McMurtry. And then you explain the nature of the claim, I guess. I don't know if the lawsuit had been filed at this point or not. But
Okay, I'm sorry, I blew right past me. Okay, my response, it says all quick response to your letter. Number 1, our claim is based upon the contract. Our demand is based upon the contract and the attending torts. Quantum merit is not an issue here, as your client stated more than once in writing. Number 2, your client has cut off my client's access to the information you have requested. Number 3, as far as the description of the services performed, you can get that in discovery. On that issue, please make sure that your client has preserved all of his communications and documents related in any way to this matter. Number 4, you stated you wanted more time to propose a response to our demand. It's obvious that you're not doing that. Does this mean that you will have a response to our demand? Just let me know on that. We can talk on Monday, or if that's not necessary, just let me know. Thanks, Drew. Is this during the time when we extended the deadline for filing the complaint from Thursday around till Monday?
that sounds right.
Okay. On number 2, I say your client has cut off my client's access to the information recorded. Did you ever look on Lynn's Dropbox to see all of the exhibits of all of the pleadings drafted by WGW?
I'm sorry, which Dropbox are you talking about?
Lynn's.
I don't recall having access to Lynn's Dropbox.
Okay.
I'm sorry, not sure what you're referring to, really.
Are you aware of how Lynn maintained his server?
I think we had discussions maybe about that, but I don't recall at this point.
Okay. Earlier, I believe when we were talking about total fee being reasonable, you stated that you believe Todd felt that the total fee was, or that the fee was not reasonable.
No, what I recall Todd conveying was his belief that the split that was going to your clients was not proportional to the work they had performed. And I don't think he used those terms. I think he meant they were getting an unfair amount of money for what they did on the case. He shared that view at some point.
But if Todd testified under oath in this case to the contrary, or in any way, you would have no way to contradict that.
Oh. All right. Oh.
Strike that, Your Honor.
He's summarizing
Excuse me, Your Honor.
Todd's opinion.
Strike those comments.
All right. I'll overrule it. You can answer the question if you recall it.
Todd's testimony under oath in this case would be controlling. Is that correct?
Objection, Your Honor.
I mean,
yeah, actually, I like the original phrasing better. He shouldn't be commenting on the credibility of prior testimony, but if he knows something different than a hypothetical fact, you could go into that.
I mean, I've told you what Todd told me, and he did tell me that. I don't know what he's testified to in this case. I have no idea. And I don't have any comment on it, not knowing what it is.
Now, in this case, Todd McMurtry's affidavit, you drafted that, is that right?
I mean, Nicholas Sandman's affidavit?
Sorry. They're getting jumbled up. Nicholas Sandman's affidavit, you drafted it, right?
I was involved in drafting it. I think Chris also was involved. I don't remember if Todd McMurtry was involved or not.
But it was essentially an Alston and Bird project. Is that correct?
I think that's fair. Yeah, we were asked to prepare that by Lynn. Yeah.
But you guys didn't represent Nicholas, did you?
No.
And in fact, Todd represented Nicholas.
He did. Right? Yes.
But you guys prepared the affidavit. You sent it to Todd and requested that he get Nicholas's signature on it. Is that correct?
The only thing I would quibble with there is I thought Todd had involvement in drafting the affidavit, but ultimately the final version was shared with Todd, and the request was for him to present it to Nicholas, and if they could change it, edit it, but ultimately the idea was for him to sign the affidavit.
Let's look at Exhibit 164, and then I think we're about done.
Okay.
I don't know where those sticky. Todd, is this an email from you to Todd with a copy to Chris regarding the affidavit in this case?
Yes, January 28th, 2021.
Your Honor, I would move Exhibit 164 into evidence this time.
Any objection?
No objection, Your Honor.
164 is admitted.
Thank you. Todd, thanks for hopping on the phone just now with me and Chris to discuss the affidavit and confirming the facts are accurate. That kind of sounds like you drafted it, right? Your team drafted it.
I mean, I don't disagree that we were the original authors of it, but my point was simply Todd had input. I don't remember what his input was. We talked about it with him. We may have made changes on the phone. He was involved in it. That's what the point I was trying to make.
What did Lynn tell you when you asked where the money was at the time?
Sorry, I have no idea what you're talking about.
Did you ask Lynn what he had done with the funds at issue in this case?
Are you talking about in January of 2021 or back when the funds were dispersed as part of the settlement?
Well, let's start there.
Which one?
When the funds were dispersed.
So I don't recall when the settlement was finalized and the funds were paid to Lynn's firm. I believe it was in late July of 2020. I don't recall the discussions with Lynn about the funds and where they were going to be, how they were going to be handled. I assumed, well, I didn't really know. I mean, I assumed they would be handled pursuant to his agreement with Nicholas Sandman and Todd McMurtry.
Did you check to see if they were still in his escrow account?
I don't recall talking about that.
Let me hand you plaintiff's exhibit 401. And direct you to D at the bottom of the page. When in the course of representation, a lawyer is in possession of funds or other property in which both the lawyer and a client or third person claim interest, the property shall be kept separate by the lawyer until there is an accounting and severance of their interests. If a dispute arises concerning their respective interests, the portion in dispute shall be kept separate by the lawyer until the dispute is resolved. The lawyer shall promptly distribute all portion of the funds or property as to which the interests are not in dispute. Did I read that correctly?
You did.
Does that, Your Honor, at this time, we would move to admit State Bar Rule 400.
Your Honor, we object on the grounds that this should be a charge from the judge.
Yeah, I agree. Sustained. It's not admissible as an exhibit.
Are you aware? So is it your understanding that this bar rule, that there are bar rules that require lawyers holding disputed funds in escrow to keep the disputed funds in escrow until a court or somebody has resolved the issue?
I became aware of this rule when you raised it, I think by letter, which I thought was long after the lawsuit was filed, if I remember correctly. I think we shared your letter with Lynn. I don't remember if Lynn responded at that point. I think it was near the end of our representation. We were not communicating regularly. Our law firm was not in possession of any funds, so we didn't view this as having any applicability to us, but we did share it with Lynn.
And you, as you sit here today, don't have any understanding of whether he kept those funds in escrow or drained those accounts?
I have no knowledge.
Thank you. That's all I got for this witness. I'm sorry it went over, Your Honor.
Can you redirect?
Yes, Your Honor.
Your Honor. When Mr. Burby's done, would it be okay with the court if I simply shook his hand and said, hello, I hadn't speak to him? If I shook his hand and said, hello,
You can handle that outside the courtroom and once he's
do it
excused.
in the hallway? Yeah.
Sure,
Okay.
that's fine.
Hello again.
Hi.
So with all this dispute going on over 1.5, did you ever author or were you ever copied on any communication seeking to arbitrate or resolve the dispute through
Objection,
alternative
Your Honor.
means?
That's
All right, I think I already handled this at a bench conference, and so the objection's preserved, but it's overruled.
What I remember is that Mr. Beal sent us a letter, maybe with a copy of the draft complaint threatening to file the lawsuit, that part of our response was to propose that the parties arbitrate or attempt to negotiate some resolution outside of court.
And this was before they filed their first complaint?
That's right.
And that's all I have, Your Honor.
Okay, recross on that point only.
just 1 second, Your Honor. Mr. Burby, Joey, this arbitration, offer regarded a, part of the claim. Is that right? The breach of contract?
Oh, I don't remember it being limited to any one claim. I thought just the dispute was, we were proposing to be arbitrated, but I don't remember precisely. I think it was in an email, so we could look at it.
Okay. And, both sides would have paid arbitration fees. Is that correct?
I believe there are costs associated with holding an arbitration, paying the arbitrator. So yes, there would have been expenses. How those would have been handled obviously could have been discussed. Sometimes one party pays all, sometimes they both split it.
And there wouldn't have been any arbitration of the fraud claims. Is that right?
I'm sorry, I don't remember it being limited to the breach of contract claim. I thought it was, you served a draft complaint that I thought had a fraud claim, and I thought we were proposing that the entire dispute go to arbitration or some sort of mediation, what have you.
So if we had entered into an arbitration agreement with L. Linwood PC and gotten an award, and there was no money left in the PC, we would not have been able to recover anything if the claim was against the PC. Is that correct?
Well, it's relevant, but I think that now we're going down, I think, a little far afield of, there's too many hypotheticals or possibilities that question implicates. So I think on 403 grounds, I would overrule it, or sustain it rather.
And if Nicholas had entered into a separate fee agreement on his birthday, July 24th, and then 2 months later, in late August, early September, we arbitrate, the party that would be obligated, it could have been a very different set of circumstances, because there could have been an entirely new fee contract that WGW did not know about at that time.
Objection, relevance. And speculation.
This is the nature of the offer.
Yeah, that's fine. You can go into the details to the extent he knows it, but I don't think we need to go down every possible hypothetical if he has no idea. So I'll overrule it.
I mean, I guess I'll answer it this way. One, I thought by the time we offered or proposed arbitration, the funds had already been paid to Lynn's firm. So I thought the settlement funds had been dispersed, so they were available. And I think the arbitration, my belief was we were proposing for all the parties, Lynn himself personally, his firm, your clients would all arbitrate.
That's all I got. Thank you, Your Honor.
All right. Can this witness be excused on behalf of the defendants?
Behalf of the defendants, yes, Your Honor.
All right. On behalf of the plaintiffs, can this witness be excused? Can the witness be excused?
Yes, Your Honor.
All right, Mr. Berber, you can step down. Thanks for being here. And members of the jury, unless anyone needs a break, you can just stand in place. I'd say we keep forging ahead. All right. And so if we could go ahead and defense may call their next witness.
Got it. Speaking to the witness. And then I've got it.
I'm sorry, what? Oh, we do have someone wanting to. We have one wanting to step out. Okay. We'll take 5. We'll take 5. 3:30.
Not 10. Rod said 30.
I know.
You want me to go here?
We're taking 5, but you have counsel to cover you?
Cover me when I go to the back.
No, to keep this trial moving along. So do you need to, is your next witness?
Cover the next witness. I'm not going to start and have me come back in.
Okay, well, take your time. Let's get moving. We're in recess. Come on back when they're ready.
Trying to avoid embarrassing myself.
Understand, Mr. Lloyd.
You've ever had this problem?
I don't know if it's just me.
Good, we need that. We need that. Let's not read this minute, but tonight or tomorrow. Okay, we'll print it out or.
So we see what he's thinking.
Yeah.
You got two dents. Did you see the area? 104 Bridge, you know where about every day. In that area, there's that house. What's that area now? It's where, yeah, it's like the house around. It's full, if you look, you can, bedrooms are in the home. Lanes are right, but. And then the other one is by, off of Fontaine Home. You know, that's that, right? Yeah, before you get the formula, make it right, yeah, about this one now. So you like the other one? Okay, so that's the 104 one. The 104 one is the one. The one with the two backyard, two things, that's the one that's right there off of the road. Right there, off on saying. Okay, the other one is nice too. That's the one that's. It's two with red doors, right? It's two with red doors, they both 1753 year old together. The 104 one is the one that's my area that. That's off Dodge Road. It's off, right now. There you go, got her keys to the house. I think her girl, the house, she said, what they did like, said, girl, what the hell? Cause she just did exactly what you just did. She tried to get an apartment, said, but why you get an apartment? And we're just trying to get so quick.
You'll have to do, yeah, electronic, don't have to vote.
I see a 2-bedroom, 1 bath, with 1 room, but they should all, sit on the left hand.
Everything in it. I'm thinking, well, you didn't. That's it. Or, I don't know, it's from. How did that firm come from that? Yeah. MJ Bondurant, I know M. Bondurant well. Emmett Bondurant, the Bondurant firm. You got a big picture?
No.
You don't want to do a bunch.
So this is Kathleen Mark, it's 40 grand, my name's Kathleen.
Give me bad breath.
Well, give me good breath. It's 40 minutes caffeine.
I need it, let me have.
Oh, you want, okay, this will be a cup of coffee.
Give me three.
3?
Good boy. You chill?
I can give you a headache, so be careful.
Is this your notebook on Joy?
It's on both of them. And
You have an outline on Joy that you used?
I had a very rough one. It wasn't really,
Where's the? See, this starts at the 31st.
Mm-hmm.
Where's the stuff we haven't been engaged in all this? I need. Copy of the settlement statement. I mean, settlement agreement.
So.
Right, I got the settlement agreement.
Okay. So this is the engagement agreement right here. That's exhibit 15. It's already in evidence. Settlement agreements. It's already in D15, and you did. That is, I'm sorry about all the colors, but it might be. I know it's here.
15?
That's a different, that might be a different 15. Because these were depositions. That's trial exhibit 17. So I don't have the engagement agreement clear, but that's in the big document. That's in our.
Well, that's fine.
Yeah.
Did we just put it in with Joy?
We did, it's up there. But I've also got some.
I'll look up there and find.
Yeah, I will.
So we'll come to order.
All right, we're back on the record. And Mr. Wood, is there any reason we can't call your next witness at this time?
No, we're here. He's right outside.
Bring him in.
Y'all get him?
I'll just ask Mr. Exum because Deputy Scott's going to check on the jury.
I'll get him.
You sure?
Did you find the thing?
Are they ready? Okay. Come on up, sir. Have a seat. All right, and tell Deputy Scott, tell the jury's ready to go. I'll just let the parties know the clocks are coming back because both parties just seem completely incapable of giving an accurate time estimate. I mean, I think we're going to be lucky to, I'm just going to start the clock up on direct and it'll go down for cross to the extent. Whatever you use on direct is what they're going to get for cross.
Right, you're not gonna limit I don't think my direction will be long, but I'm not limited starting off the bat.
No.
Thank you.
No. My observation at this point, gaming everything out, is that, I mean, I think it would be optimistic to think we're closing first thing Wednesday morning. In which case, again, each party being under the uniform rules entitled to 2 hours. I don't know if I can do anything about that. I might have to explore that
Cuts to
further.
5 minutes.
What's that?
Cuts to 5 minutes each.
If I had that power, I might have to research that a little bit more. But regardless, that's an optimistic estimate, and that's not even taken into account that there may be a phase 2. So I'm going to go ahead and also let the jury know that if they have Thursday conflicts or Friday conflicts, they need to bring those to my attention, and we can see where we fall on that front. If anyone wants to weigh in, feel free.
Your Honor, we would renew our request for the financial records from Mr. Wood because
Well,
getting close to the end of it.
Yeah, you did promise them Monday morning.
well, I have them, but I have a motion. I want them, when I give them to the court, and I don't have theirs, but I want them filed under seal. They can be used if we get there and they're admitted in. I want to make sure it's done under order. of
You're asking
the
for a
city.
protective order.
I don't have their documents either. I can't even look at them to see if they're relevant to what I've asked. I think they are in part, but I don't have any of them. So it's goose gander.
Well, not exactly, because I think they're in different categories. They filed a motion to quash. You did not. But to the extent you want a protective order, I'm open to that, and we can talk about the particulars of that. But right now they haven't asked to file anything. All they wanted was for you to give them to them, and if there's anything required just to turn something over to another party,
Confidentiality order.
then I'm open to that, Mr. Beal.
I'm fine with confidentiality. I don't want to use them outside this case, but I want to be able to use them in a meaningful way. So
Right. And so we can discuss the particulars of that, but right now, Mr. Until you've presented me with a proposed order or told me exactly what it is you're asking for, I believe they would be entitled to them at this point.
Just that if they're introduced into evidence, they be sealed. It's
Okay.
my,
okay.
for example, I got a tax return, didn't make any money, but the return's about that thick. That's not something that needs to be distributed publicly.
I'm fine with that.
Okay. Well, then you're talking about the document itself. I mean, I don't know what questions get brought up or they're on the record. Those are public. But you're just saying the document itself should not be tendered as an exhibit, or if it is, should be sealed solely for appellate purposes?
Should be sealed from the public.
Right. Solely for appellate purposes is the only reason it would be
Well,
looked at.
If somebody comes down here, look at the file from the Fulton Daily Report, they shouldn't be able to get in there and look at my tax return.
Right.
Fair enough.
So I mean, it's not going to be, then very few documents. They only ask for a few. But I also asked for information from them, not about their finances, even though they're financial in some of them in subject matter. But I'm not asking for their finances in terms of damages or their financial wealth. I'm looking at how they represented themselves in their income, et cetera, that's relevant to the issues in the case. That's the point. And they haven't, that's the issue they've got a motion for quash on.
And we heard argument on that, and I think I was ready to rule on it. So we'll take that up when we have another break.
I don't recall having an argument on that.
We talked about that day two. We talked about a lot, but that was one of those things.
Judge.
And I hear you on that. I thought he was telling us they were ready, but maybe he was wrong. Okay, so just to make sure we're clear, to the extent their motion to produce, to the extent of their motion to produce, you have those documents, you're turning them over, but if any of those documents at this point are introduced in phase two, the documents themselves will be under seal. Is there anything else then we need to clarify? Or anything else you need to have?
Thank you. But do I have not on my part, Your Honor. I want to get Mr. Marquardt home, and then if there's some issue about that tomorrow, we can raise it.
I agree with you. I'm just waiting. I'm just trying to fill time until the jury tells us they're ready, which I guess they haven't yet.
Chris, you hadn't aged a bit.
Trying my best. Do I need these notebooks opened?
Yeah, let's collect all this stuff. Let's clear the stand form. I think a lot of those are plaintiff exhibits.
Now you got to be able to give me the plan.
Aren't you going to want to use them?
We might use a few. That's all right with me.
It's fine with us. if he
Okay.
uses.
Yeah, I do know. I have the number.
Don't say we never gave you anything.
I've never said that. And
He's talking to the witness,
and-
Mr.
oh,
Moore.
don't forget I brought
That
you
we gave
donuts
them.
and coffee one day.
We got plenty of binders for everybody. Everybody gets a binder.
Congratulations, Chris. You get a binder.
There are plenty of them.
Take your pick. So you have the one, yeah. So when I pull up a doc.
Right.
you're
We're
gonna-
ready? Okay, bring him in.
I'll just come up there with you if you want.
No, you're not gonna be able to stand by him.
Okay.
Come here. Yes. Pull that chair.
I'll do that.
Two people stand. Otherwise, I'd love to have you up here.
Thank you, Deputy Scott. Please be seated, everyone. Defense may call the next witness.
We call Chris Marquardt.
Swear the witness, please.
Yes, sir.
please state and spell your name for the court while speaking into the mic?
My name is Christopher Marquardt. My name is spelled CHRISTOPHER, MARQUARDT.
I don't know if it's me, Chris, and my hearing, but I've had trouble all court. Can you make sure that mic's closer and we can hear you okay?
Yes, sir.
Everybody else may be able to hear you. I'm struggling, but I would appreciate it. You're soft-spoken. Nothing wrong with that. So, Chris, you are a lawyer, right?
Yes, sir.
Would you give the jury the benefit of your college and law school experience, including the dates, that got you to the point where you made the mistake of becoming a lawyer?
Sure. So I was in college from 1988 to 1992, where I played a lot of basketball and studied to the best of my ability up in the state of New Jersey. After that, I went down to the state of North Carolina, where I spent 3 years from 1992 to 1995 watching better people play basketball than me and studying law. So that's my educational background.
Are you suggesting that you saw those people playing better than you, that you saw them from the bench?
Not in law school. I saw them from the stands after buying tickets to the game.
I don't want to get into too much personal stuff, but how old are you?
I am 54 years old.
And where do you reside?
In Decatur, unincorporated DeKalb County, actually.
And I understand you got your wife and 2 kids.
Marie and I are together still, God willing, and we have 4 kids.
I got you and Burby confused. He'll catch up soon.
Right.
So, Chris, when you got out of law school, what was your first employment?
So my first job out of law school was spent working as a law clerk to a federal district court judge. So within the federal court system, there are trial courts, just like here in the Superior Court. And I worked as a law clerk for 2 years for a judge in the Northern District of Florida. I was in courthouses primarily in Tallahassee, Florida, and Gainesville, Florida.
And what year did you leave your clerkship?
I left in the summer of 1997.
And where did you go from the clerkship?
My wife and I took a little vacation and then came up here to Atlanta where I joined my law firm. It's called Alston & Bird, and I've been a lawyer at Alston & Bird in a full-time capacity since September of 1997.
I was going to try to do the math. Since 1997 will be 28 years?
It'll be 28 years this September, I think.
28 years at the same law firm.
Yes, sir.
And you came to Atlanta in 1997.
Full-time. I had been a summer intern at a couple different law firms before that. So I had spent some summers here, but when I moved full-time to Atlanta with my wife, it was 97.
Were you here during the Olympics of 96?
No, I was clerking in Florida during the Olympics. I was here the summer of 94. I was here the summer of 95. Clerked, came back full-time in 97.
And what was your position when you started off with Alston & Bird?
So like all young lawyers, I started off as an associate at the law firm, and that's how I started, as an associate.
So salaried employee?
Yes.
Although they could give you a bonus if they wanted to.
God willing, yes.
Did you ever get one?
I'm sure I did, yes.
But they weren't obligated to give it to you.
I forget the terms of that, Mr. Wood, but I worked hard and tried to do my best.
I know that. Did you move from associate to partner?
Yes, sir.
Did you go straight from associate to equity partner?
No, sir.
Where did you go in between associate and equity partner?
So I was promoted from an associate law firm to a partner in, I think it was the fall of 2003. And a handful of years after that, I was made an equity partner of the law firm, which basically means you're a shareholder of the law firm.
As a non-equity partner, you have no ownership interest, right?
Correct.
Someone described it, it may have been Nicole. Let me see if I can go through it just very briefly. So an associate is an employee.
Correct.
A non-equity partner is in effect an employee, but not an owner, right?
I think different people have different views of that, but a non-equity partner is a partner of the law firm without an ownership stake in the law firm.
And would you agree with me, Chris, that it's to an individual such as that, like you were, that it's to your advantage in trying to generate business to get to the equity level for the public to see you as a partner by name and not an associate?
All partners of our law firm have the title partner, and they've all worked extremely hard to become a partner of the law firm. And so the partner name is with a partner regardless of status, income partner or equity partner.
I'm sorry, the last part you tailed off.
The partner name is affiliated with income partners and equity partners because they're all partners.
Right. But they're not, non-equity partners are not owners.
That is correct. They do not have an ownership interest in the partnership.
Their owners want to be. They hope to be successful enough and to be elevated to being given a portion of ownership in the business, in the law firm.
I mean, everyone, I'm sure, has his or her own desires, but generally speaking, income partner is a step on the way to equity partnership if everything works out well.
And generally, as you take the journey from associate to non-equity partner, you're developing skills and hopefully developing a book of business so that you would be, in the eyes of the owners, justified to become an equity partner. Is that a generally correct statement?
Leading them.
I'm just trying to move along for time purposes.
Overruled is still leading, but we have covered this ground through many other
not with this
witnesses.
witness.
I know, but that doesn't mean we get to come in and bring in 100 witnesses. So let's just
I'm not
get to
going
the
to do
point.
that.
All right.
I want to go home.
Could you repeat the question, please, Mr. Wood?
On the journey from associate to non-equity partner, the goal is to develop experience, to begin to have your skills recognized so that you will be able to generate your own clients and your own book of business, which is what the owners of the firm are looking for in terms of making you an equity or owner partner. Is that a generally correct statement?
Generally, I mean, the goal is to serve my clients' needs, right? That's the goal, is to work hard and to do the best work that I can do for my clients, and hope to be recognized for that along the way. Yes.
Right. Lawyer 101. The client comes first, right?
We are a professional services business that do work for our clients, and yes.
Client's interest comes first, even if it's financial for you, that comes second behind the best interest of the client, doesn't it?
When we're doing what we're supposed to be doing, we're serving our clients' needs first and foremost, yes.
Because you're a professional, not a businessman.
Again, we are part of a profession, all of us here in this courtroom, yes.
You and I, so the jury knows this and the judge knows this, I'm sure, while we don't see each other much anymore, and since I moved and kind of sort of retired, you and I are friends, aren't we, Chris?
We're definitely friendly, yes. We met for the first time while we were working on a case where we had clients that were sued by a group of plaintiffs. And so we got to know each other through that. And then after that, we would occasionally grab lunch or run into each other for a drink or something. So yes.
And you know that I have always had great respect for you as a lawyer and as a man.
I hope that everyone has great respect for me, and I appreciate you saying that.
Maybe your opponents in the courtroom may not, but The point is, you know that I've always held you in high regard.
Well, I appreciate that, Mr. Wood.
Well, there's a flip side coming. The truth is that you have known me for a number of years, and from a reputational standpoint and from an ethical standpoint, as a trial lawyer in this community, you have always held me in the highest esteem, haven't you?
Objection, Your Honor. I think he's bolstering. I'll withdraw it.
Yeah. All right. You can answer the question.
Lynn, you have a great reputation as a trial lawyer, and I've always respected that.
Thank you. There was some testimony from Joy about Austin Byrd ultimately withdrawing from the representation of me and my PC. You recall when that occurred roughly?
Yes, sir.
So that it's clear, big firms, and how big is Austin Byrd?
It's a large law firm. We have roughly,
Yeah.
Not relevant.
I can tie it together.
I think we've established they're a big firm. We don't need to go into the definition of what is a big
Well,
firm.
well, it matters in terms of the question. How many cities are you in?
I don't think we need to go down that road either, Mr. Wood. Let's go to the next
I
question.
don't think that, well, I'll move on.
All right.
Big law firms, because of the nature of many of your clients, like to fly what I would call under the radar. You don't really want controversial clients publicly. Wouldn't that be a fair statement?
you're asking me to answer about every big law firm in the United States?
No, I'm just asking you generally about what you know from Austin and Byrd, that it's the preference of a firm like Austin and Byrd to not get involved in high-profile, controversial clients. And I call that big firms like to fly under the radar. You've got a bunch of business. You don't need a troublemaker like me, high-profile troublemaker, I guess you could call me.
Objection, Your Honor. Relevance. You can ask him what he feels, but.
Let me
his
try it a
knowledge
different
of
way.
big firms-
I'll withdraw it. You have known that I, from probably when you first learned, that I advocate for my clients in the court of public opinion.
You have a strong reputation for that, yes.
Some people think that I actually was one of the first to develop advocacy in the court of public opinion, starting with the Richard Jewell case. Sound familiar?
Sure, yes.
Do you understand what advocating for a client in the court of public opinion means?
It's not the way that I practice law,
I understand that.
but I understand generally that it means not just advocating for your clients in a courtroom or in legal filings, but doing so publicly outside of that formal setting.
Because in the present world we live in,
Objection, Your Honor.
this is just not fair to
No,
interrupt
no.
me before I finish, Judge.
Agree.
Please ask
I
me not
agree.
to.
Overruled, but we do need to keep moving. But it's overruled. You can
After
keep
the
going.
last examination, I'm doing pretty good, not rambling. The simple point is, advocating for the court of public opinion, you recognize is where, in the era that we live in, your client can lose in a court of law or can win in a court of law, but has been so badly smeared in the media that he loses in the court of public opinion. They think he's guilty when in fact in a court of law he's innocent. Same thing with Richard Jewell, same thing with the Ramseys. You know what I'm talking about?
I've heard you discuss this topic previously, yes.
Yeah, I've given seminars and lectures on it, haven't I?
I don't remember that.
Now, it's a different style. That's not what you do.
It's very fair to say that you and I have different styles, and you have been enormously successful with your style.
As you have been with yours. And it's good for the prospective clients out there that there be lawyers like your style and lawyers like my style. Wouldn't you agree?
I appreciate the compliment on my style. I try to do my best for my clients, and I know you've always tried to do your best from your clients from what you've told me.
And what you've seen in my cases over decades of knowing me in Atlanta. I've been all over the country, haven't I?
You have had your share of media coverage for success. Yes,
I've had my share of extremely high-profile clients, haven't I?
you have. Yes.
God bless me, most people get one. It seemed like he gave me about 30. Nonetheless, I can you explain to the jury briefly what circumstances led to me hiring you and Joey Burby and Austin Bird to help me in March of 2020?
Yes. So my law partner, Joey Burby, who I saw walk out, so I think y'all have met Mr. Burby, had some initial conversations with Mr. Wood about Joey helping Mr. Wood with a disagreement Mr. Wood had with the plaintiffs in this case. And Joey came to me and asked me as his law partner, can I help him help Mr. Wood? And I said yes.
I believe Joey started off in the U.S. Attorney's Office, didn't he?
He was an assistant United States attorney. I don't know if he started there, but he had been a federal prosecutor for many years.
Then he went over to Powell Goldstein.
I recall that, yes.
Then Powell Goldstein was acquired or merged, whatever word you want to choose, with Brian Cave.
Yes.
And Joey had been a partner at Powell Goldstein. And then when the merger occurred with Brian Cave, he became a partner at Brian Cave, equity partner.
I don't remember any of those details. I'm not saying you're wrong. I just don't remember any of those details.
But you do know that Joey and I worked together at Powell Goldstein and for a period of time at Brian Cave.
I know that. And just as an aside, I had been a summer intern at Powell Goldstein back in 1994. So just, I also had worked at.
Move to strike that, Your Honor.
At Powell Goldstein.
Just kidding. So you agree, Joey agreed to represent me. Austin Bird agreed to represent me.
Correct.
And you agreed to help Joey in my representation.
I did. Yes, sir.
Did you? I think the date of the engagement, you have this number.
Yes.
If you'll look at exhibit, good luck finding this.
I'm right here.
What's the number? I need it for his engagement.
It was D15.
So if you look at defendant's exhibit 15, Chris, I know.
There's notebooks all around me, Mr. Wood. What?
May I approach, Your Honor?
You may.
See if one on the front of it says defendant's exhibit. That's his plans. That looks like ours. It's not as neat.
Defendants?
Yep. So if you look at defendant's exhibit 15,
Yes, sir.
which I believe is in evidence, but if not, I'll just quickly gender. All right, is that a true and correct copy of the engagement agreement between Austin Bird and me?
So this agreement was between my law firm, entered into by my law partner, Joey Burby. I assume it's a true and correct copy. But I didn't sign it. It was Mr. Burby who handled that.
Your Honor, we tender into evidence. What number is it again?
It's already in evidence.
Oh, it's already in evidence. Have you had a chance to review that recently?
No.
Scope of the engagement, paragraph 1. We understand the scope and nature of our engagement will be to assist with a dispute that has risen between you and Taylor Wilson, Nicole Wade, and Jonathan Grunberg, with whom you previously practiced law and shared office space. Have I read that correctly?
Yes, sir.
And then under paragraph 4, well, in paragraph 3, you set forth the hourly rates. Yours was $875 an hour back then, and Chris's was $870, right?
Well, Joey's was 875, mine was 870.
Wow. I didn't realize that, but I see it.
I was cheap.
Joy was more experienced.
It's his letter.
And then at paragraph 4, it said, before we begin work on your behalf, we will require a retainer in the amount of $100,000. Have I read that correctly?
Yes, sir.
Now, that wasn't my offer to you. That was your firm's request of a retainer from me in that amount. True?
So because I wasn't part of this negotiation and it's not my engagement letter, I don't know how that amount was reached.
Isn't it your general experience that the firm sets the amount of the retainer?
Every client relationship can be different, Mr. Wood. So I just don't know. I wasn't part of this negotiation. But there was a $100,000 retainer, which I understand that you forwarded to the law firm.
And a retainer works so that if, as I paid you $100,000, if you come in and you're able to get it resolved and my fees are only $50,000, then you return the $50,000 to me after taking the $50,000 for your fee, right?
Unless you as the client give a different direction. Yes.
When you were first retained, you understood, did you not, that this was a matter to try to resolve a business dispute? True?
I did. Yes, sir.
It wasn't a matter of knowing when you were retained or Joy was retained that you were going to be involved in a civil lawsuit, was it?
Not at all. And in fact, the whole purpose of us getting hired and being retained was to bring an end to a dispute that agreed between you, that existed between you and the plaintiffs, and to try and resolve that through an agreement so that no lawsuit would ever need to be filed by anybody.
Best legal work you can do for a client is keep them out of court, right?
I tried hard in this case, and that's what I try to do. I try and do what's in my client's best interest.
Well, here we are 5 years later. Did you ever think we'd be here 5 years later like this?
No, sir.
Neither did I. But nonetheless, here we are. And in an effort, fast forward slightly, when all of a sudden we knew this was going to, first time we strike that, I believe you would tell me the first time you began to realize this was going to be potentially a lawsuit is when you received a demand letter and a proposed lawsuit from Andrew Beal. Remember that in August of 2020?
I don't remember saying that to you today, but I remember that there was correspondence between Mr. Beal and me midsummer, July into August of 2020. Yes.
With a draft complaint.
Not the initial correspondence, but at some point later in August, one of the letters from Mr. Beal put together a draft complaint saying, we're prepared to file this if this case doesn't get resolved in the way that my clients want it resolved.
And in response to that, I made an offer to the plaintiffs to have the dispute resolved.
Objection, Your Honor.
May I finish, Your Honor?
That's fine.
May I finish?
Well, not necessarily. It just happens to be the party. I think I know where this is going.
It's already in evidence.
Overruled.
Thank you. So on my behalf, you and Joey Burby made an offer to Mr. Bill and the plaintiffs for an alternative dispute resolution mechanism instead of getting into a lawsuit in court, didn't you?
Yes. So what we did is we made a three-step, three-part offer on behalf of Mr. Wood. We said, Mr. Wood has directed us to tell you that he would sit down and have a face-to-face meeting with the plaintiffs to try and resolve the dispute. That was the first step. We then said, if that doesn't work, he would be willing to meet with a mediator. Mediator is usually a retired judge, but some neutral party that has a facilitated discussion where you try and resolve it without having to go to a court. So first was he would sit down and meet with your clients directly to try and resolve it. Second is if you didn't want to do that, he would go to a mediator, see if a mediator could help resolve it. The third step was Mr. Wood directed us to tell the plaintiffs that he would be willing to submit this to arbitration. So arbitration is like a trial, but it doesn't require taking jurors away from their lives to hear the evidence. A arbitrator, a professional, usually a former judge, is the one that hears the evidence and reaches a decision. And when you agree to arbitrate a case, you're agreeing to live with the decision that the arbitrator makes. And so Mr. Wood directed us to make that three-part offer to the plaintiffs.
To avoid getting involved in protracted.
That's testimony.
I just,
Well, no,
all
not
I
yet.
ask for, Your
Not
Honor,
yet.
is the courtesy
So-
of being able to finish my question.
I understand, Mr. Wood, but the problem is it's difficult when you're representing yourself because there have sometimes been comments. I didn't hear one at that point. I'd heard one a little earlier, but there was no objection to that one. So you can proceed.
I remember what I was asking.
I'm sorry.
No, that's okay. So on my behalf, you offered 3 ways to try to avoid civil litigation, right?
That's correct. And put this in a letter to Mr. Beal, and in the letter, I summarized what Mr. Wood, you had asked us to summarize, which was the point that you felt strongly about. If there's a dispute over money between lawyers that are having a fee dispute, you felt like it was in the best interest of the profession for that to be settled in some way other than going to court.
Right.
To do it with an arbitrator or mediator or some other mechanism.
You're exactly right. That was.
Okay, now, Mr. Wood, we are
I'm
crossing.
getting ready.
But when you
May I
confirm to
approach the
say,
bench? Judge, I don't have a
no, sir,
chance.
when you're saying that's right, you're affirming his testimony and that's you testifying. So,
Excuse me, I did not mean to do that.
okay.
Not only would you agree, Mr. Marquardt, that has been my position, but that is the recognized position of the State Bar of Georgia, where they strongly urge lawyers to mediate or arbitrate fee disputes between themselves. True?
I don't remember the position of the State Bar, but that makes sense. I mean, generally speaking, as professionals, the hope is that lawyers would be able to sit down, resolve something, and again, not bring members of the public into the jury box so that they have to do it for us.
And in the process of airing their public disputes, if they do it publicly, there's the risk that it demeans the legal profession, right?
I think that's yes. I mean, it's not the optimal way to resolve the dispute.
Especially between professionals, wouldn't you agree?
I would agree, yes.
So after you and Joy agreed to represent me, back now in March, did we have meetings
Of course.
in your office?
So March of 2020, as we all remember, the world shut down because of COVID. That's right when COVID started. So our in-person meetings were limited, Mr. Wood, but yeah, I think at some point that summer we had one, but we were generally on the phone or other things like all of us were in the world when COVID started.
What was the date of the engagement agreement?
March 6th.
So our engagement agreement was March the 6th. And,
Yes, sir.
sorry,
I was looking at the date. Yes, sir.
literally a short few days before a worldwide pandemic was instituted by the World Health Organization on March the 11th of 2020.
I don't remember the exact date, but yeah, it was right around that time.
And then the world as we knew it kind of came to a grinding halt. And I think you've mentioned that. So they weren't able to meet in person, but we conducted business on the phone.
Frequently, yes.
But we did have some in-person meetings.
I can remember at least one. Yes.
that I had on my straw hat, remember it?
I don't.
So did you find that when you met with me and asked for information, that I was a cooperative client?
Yes.
Did you ever have any suspicions about me as a client during the time period that you initially agreed to represent me up until we got into the lawsuit? Did you ever have any concerns about me in terms of whether I was being honest with you and Joy?
I did not.
You believe, contrary to some testimony in this case, do you believe that you and Joey Burby in your dealings with me and with the plaintiffs and Mr. Beal at all times acted in an honest and ethical fashion?
Objection, Your Honor.
Asking him to bolster.
No, I'm asking him to respond. The allegation was that he and Joey were dishonest.
Okay, I think he's talking about so the question is focusing on the attorney's conduct, not their opinion of Mr. Woods. So with that direction, you can proceed.
That accusation has been made against you and Joy that you were thought to be dishonest. I don't know if it was Nicole or Taylor.
Objection,
The
Your Honor.
point is, I'm
Other
asking you,
testimony.
Yeah.
is that accusation offensive to you?
Oh, come on.
Someone would accuse you
Offensive.
of being dishonest.
Yeah, I won't, I liked the original phrasing if you want to go down that road, but I also sustain that question.
I got thrown off when he
Did you do
objected.
anything dishonest in your representation?
That's perfect. Did you do anything dishonest in your representation of Lynn Wood and the PC?
No.
Did you in any way do anything dishonest in the negotiation and execution of the settlement agreement of March 17th of 2020?
No. And in fact, we were working hard to try to get people that were very emotional and involved in a dispute to lower the temperature, to calm down, to resolve their differences, and to sign an agreement so that they could move forward with their lives. And I think Mr. Beal, on behalf of the plaintiffs, and Joey and I, on behalf of Mr. Wood, tried really hard to reach that goal. And on March 17th, there was a settlement agreement that was signed that I thought did just that. It entered into a way to resolve an ongoing dispute between people that had worked together for many years.
And the temperature was hot, especially in February. You knew that. I was not happy with them. They were not happy with me. It was like a bad
Objection,
marriage.
Your Honor.
True?
Overruled.
So I wasn't involved in February, but both from things that Mr. Beal told me when we were talking to try and resolve the case on behalf of our clients and things that you told me, it seemed like everyone was upset with each other. Yes.
But then for whatever reason, maybe because you and Joy tried to turn the temperature down, when I met with you, did you find me very amenable to the idea of trying to find a amicable resolution with these people?
Yes, that was the whole point of why we had been hired, was to try and help you resolve a dispute with the plaintiffs.
I didn't come into your offices going, I want you guys to sue these people and destroy these people. I don't want to pay them one thin dime. That's not the attitude I had in March when I met with you, was it?
You didn't say that to me, no.
And my actions to you and my comments to you and Joy were totally consistent with a man that wanted to make peace and move on. Wouldn't you agree?
Yes, you wanted to get this case resolved. And so when I was talking to Mr. Beal, that was what I was trying to accomplish, was to get this case resolved.
And ultimately, plaintiffs 102
I have it here, sir.
I believe this is an evidence, Your Honor, it's plaintiff's exhibit 102.
Man, that's the settlement agreement. It's
that-
better be by now.
It is the settlement agreement.
Are
Your
you
Honor.
able to recognize that as a true and correct copy of the settlement agreement that was negotiated and signed by all the parties on March 17th, 2020?
Yes.
Now, I have waived attorney-client privilege, nothing to hide, in terms of your advice to me that led up to this agreement and advice that I got from you and Joy thereafter, particularly as it applied to the issue that came up on Rule 1.5. You understand, I'm asserting it, defense advice of counsel, knowingly knowing that that allows you to talk about your representation.
Objection, Your Honor. Multi-part.
But let me strike it and try to make it simpler. I got a little carried away. I'm tired.
All right.
You understand I'm asserting an advice of counsel defense.
So I understand that you've waived the attorney-client privilege. So generally speaking, as you all know, when a client talks to a lawyer,
Now he's teaching the witness that's not responsive to the answer.
I mean, if you just, I think we've heard a lot about it already. If you could just start with a yes or no, we'll see if we need more.
I'm sorry, Your Honor.
Okay.
Yes, I understand that you have waived the privilege.
Now, this agreement was the result of negotiations between your law firm and Andrew Beal. Is that true?
Yes, on behalf of our clients.
I gave you some input when asked.
Correct.
Suggestions. You don't know whether the plaintiffs did that or not, but usually it would be normal for the parties to look at agreements and talk to their lawyers about them before they're finalized. Wouldn't you agree?
Objection, Your Honor. It's leading and there's 3 questions in there. Let's just do them one at a time. And
I
can
can
we
do it.
approach?
It's just so simple.
issue?
Don't clients.
All right. Do you want to show that to opposing counsel before you?
No, it's just. Just.
What?
Oh, I thought you were handing me something.
No.
Oh, no, you're trying to address something?
That was something my clients.
Okay. All right. Yes to approach, Mr. Wood.
Oh, that's all really clean. It's not together. Well, I think we should already carry the construction.
I believe that we dealt with charges and would be premature and actually highlight something that he doesn't really want to highlight. We can do it now.
It'll be the same thing that you asked for. During his witness, I'll just tell the jury that what that means will be addressed. Charging.
Correct.
All right, members of the jury, the term advice of counsel defense, you'll be charged on what that means and how that law applies to this case at the conclusion of the case when I charge you on the law. Defense may proceed.
Thank you, Your Honor. It is commonplace for lawyers when they're negotiating contracts to consult with and get advice from the clients about the language and the meaning and what they want to agree to. True?
Absolutely, because it's the client's contract, not the lawyer's contract. The lawyer's just helping the client achieve whatever that client's objectives are.
And if the client says, I want this done, and you don't believe it should be done, you'd say, I'm not going to put that in there. But if the client says, I would like this in there, and it does not appear to be violative of any law or rule, or you'd look over and say, I'll include that in your contract, right?
Ultimately, I serve my clients. So if a client wants a provision in there, we talk to the client about it, and then we pass it on to the other side.
And as long as the client's request with respect to the agreement are in conformity with your ethical duties as a lawyer, you're going to consider and usually include what the client requests, right?
That's the typical approach. Yes.
Thank you. Now, this agreement, plaintiff's 102, this was signed and agreed to by Wade Grunberg and Wilson. I don't want to go through the list of the different corporate entities, but all of the individuals and their various legal firms, they are parties to this agreement. You see that in paragraph 1, right?
I do, and the signature page is page 7, and the signatures show, that each of the plaintiffs signed it on behalf of their own law firms and themselves, and you signed it on behalf of your law firm and yourself.
And you knew that Jonathan, Taylor, and Nicole were practicing lawyers.
I did, yes, sir.
Nicole for a long time. Don't mean too long. I mean, maybe 20 years. I mean, you knew these people were not lay individuals. They were lawyers, trained in the law.
Yeah, Nicole and I were summer associates together in 1994 at Powell Goldstein.
At Powell Goldstein.
I knew that she'd been a lawyer for quite some time.
And you recognized then, and probably since, and if you kept up with her, Nicole was a very smart lawyer, isn't she?
She's very, very smart.
I agree with you. You would expect a lawyer to understand how to read and interpret a contract, wouldn't you?
Yes.
And you would expect that if a lawyer read a contract and they had some problems with it, didn't understand it, they wouldn't sign it until they got those issues resolved. Wouldn't you agree?
Every situation is different, but sure. I think you should have seen my wife the first time we signed a mortgage look at me when I actually read every line of every provision in there. She looked at me like I was a crazy person, but I'm like, I went to school for 3 years. I'm going to read this document before I sign it.
How many days did that take?
It took a little bit of time, which is why my wife got flustered with me. She wanted a house.
Had you ever worked in the past with Andrew Bill?
So we had a matter together in the past. We were not on the same side of the matter, but I know Mr. Beal professionally, yes.
And did you find Andrew Bill to be a competent and skilled lawyer?
I sure did.
Tough opponent, wouldn't you say?
I'm not giving him that credit in public, but
all right, just say he was an opponent.
Mr. Beal and I know each other, and I have respect for Mr. Beal and his practice. So.
Andrew Bill's no dummy. He knows about contracts, doesn't he?
He is very intelligent. He's well-trained. He's very experienced. Absolutely.
And so this contract was negotiated not with just you and Joy, with input from your client, a lawyer, but with the input of Andrew Bill, a lawyer, and the input of 3 lawyers, Jonathan, Taylor, and Nicole. That's a lot of lawyers in one contract, isn't it?
We were not lacking for lawyers in these discussions. No, there were lawyers everywhere you looked.
Are you familiar with law firms that share office space?
I'm familiar that that is a thing, sure. I mean, as you said, as you noted at the beginning of the question, I've been at one law firm for almost 28 years. That's my experience of law firms personally. But I'm aware that there are all kinds of different makeups of law firms.
You could have a group of individuals that had agreed to partner up on individual cases on a case-by-case fee basis who are not all owners in a law firm. True?
I think that's possible.
You could have lawyers who are partners in an office sharing arrangement, but not all owners of the law firm that could engage in a partnership to sign an office lease. True?
I think that's possible.
In the recitals, if you'll follow with me. Whereas Nicole Wade, Jonathan Grunberg, and Taylor Wilson and Wood are lawyers who practice law and shared office space together for several years. Have I read that correctly?
You read that correctly.
Whereas WGW, Wade, Grunberg, and Wilson, never held any ownership interest in L. Linwood PC, hereinafter LLWPC, but have worked as lawyers of L. Linwood PC on cases since 2018. Have I read that correctly?
Yes, sir.
And they agreed to that language. True?
So all you on your law firm's behalf and they on their law firm's behalf signed this document that had the recitals in it. Yes.
And I've read that recital correctly.
Yes, sir.
You see in paragraph 2 that, let me cut to the chase, see if it's quicker. This agreement dealt with issues, more issues than just a division of fee in cases, right?
There were several issues covered by this agreement.
One of the issues was how to deal with the office lease. That's in paragraph 2.
Yes, sir.
And it was resolved by the terms of paragraph 2, where they would pay me a certain amount, I believe $285,000 to my PC, which was their share of the remaining office lease.
Correct. The structure of this is,
Your Honor, assumes facts not in evidence, and the document speaks for itself, and having them characterize it or mischaracterize it is improper.
All right, this has been, an ongoing concern of mine for both sides. Generally, Mr. Wood, if it's just going through all the exhibits and getting his opinion on them, I don't see that really as being the best use of our time. If he's got some new issues or some new matter to weigh into, let's go that route.
Well, the lease has not really been discussed that much, but I'll quickly move through it. There was a dispute about what was going to happen with the remaining obligations under the lease, right?
there was a dispute about a lot of things. The purpose of this agreement was to try and resolve everything. And so to your point about the lease, it talked about some money. It was all going to net out based on the various components of this agreement.
And I don't know if it was you or Joey, but y'all dealt with the lawyers for the building. Did you not?
Joey did.
And you were aware, were you not, that the lawyers for the building concluded?
Objection, Your Honor.
Okay, yeah.
Say.
Yeah, if he's, it's just for him to echo another lawyer's opinion unless that's.
Let's go state of mind.
Relevant to
Were you
you.
aware that in negotiating this contract?
And before you say it, since I think he's making a hearsay objection, do you believe that this opinion was then conveyed to you in some way?
You want me to ask him that?
Oh, no, I'm just saying, but before you proceed with the opinion, is it something that you think he knows was conveyed to you at some point?
Oh, absolutely. They told me what the landlord.
Okay, I didn't need more than that. Just a yes or no works. Mr. Beal,
First of all, Your Honor, we have all the exhibits for the landlord's communication. And he, I don't think he can summarize somebody else's legal opinion and feed it up to him in a leading. He needs to ask him.
Yeah, you can ask if he's aware of the lawyer's opinion and we'll go from there.
Were you aware of the landlord's opinion about the liability under the lease that existed at the time this agreement was being negotiated in March of 2020?
So Joey handled virtually everything having to do with the lease and the landlord. I have very little recollection at all about any of those details. That wasn't what I was doing.
Were you aware that there was the issue in March and then subsequently an issue as late as July where I then tried to buy out of the
Objection, Your Honor.
I'm trying to move it along, and this is just delaying it. If you don't want me to try to summarize a question like that and go through it through 50 documents like he's doing, we'd be here until Christmas. Let me just finish my question, Judge. I think you'll find I'm trying to be fairly
Okay, I think we're avoiding the hearsay that I think you were concerned about, and so I didn't hear the issue with that question.
But these are just bad questions. He's testifying and asking Chris to agree. He needs to ask Chris what he knew. And then Chris can tell us what he knew,
Okay,
what he told him.
all right.
I mean, what Lynn believes now.
Understood. I mean, look, it's a recurring line of when he's drifting into self-testimony, when he's not. And at this point, I'll overrule that objection. Mr. Wood, you can ask the question.
Thank you, Your Honor. While Joy was handling that issue with Jeremy Granello, does that same name sound familiar, of Mayor Brown?
Now that you say it, I believe, I mean, I heard the name in that context, but again, I wasn't talking to that person. I wasn't dealing with that issue. Joey was handling that.
So in paragraph 2, the parties entered into an agreement on how to deal with their respective obligations under the lease. True?
True.
And paragraph 4B, that's a mutual general release, right?
It is, yes.
Look at paragraph B, released by WGW.
I'm there.
Nicole Wade, Jonathan Grunberg, and Taylor Wilson, and Wade, Grunberg, and Wilson LLC for themselves and itself hereby irrevocably and unconditionally forever release and discharge LLWPC and L. Lynn Wood individually and their heirs, executors, administrators, and assigns, and their attorneys and representatives, and waive any and all rights with respect to all manner of actual or potential claims, actions, causes of actions, suits, judgments, rights, demands, debts, damages, or accountings of whatever nature, legal, equitable, or administrative, whether the same are now known or unknown, which WGW and its members ever had, now have, or may claim to have, upon or by reason of any acts or omissions of LLWPC and L. Lynn Wood individually up to the effective date of this agreement. Have I read that correctly?
Yes, sir.
Including but not limited to all claims and liabilities arising from acts, omissions, cases,
Objection, Your Honor.
or bits.
This is cumulative. It's been in 3 times. I just don't know
Yeah,
that it's going to change anything.
Mr. Wood, I think we've read through these portions of the agreement repeatedly. Let's go to the next point.
Obviously, I take exception to the ruling, but I understand the court's right to make it. This is what you do when you settle a case, isn't it, Chris? And do you mind if I call you Chris?
That's fine, Mr. Wood.
You settle, you release everything. Up to the time you sign the agreement, everything in the past is released. Your disputes are resolved. You've made your deal, right?
Correct. The whole point of entering into an agreement like this, and you can
Yes, Your
ignore the
Honor.
legalese.
It's a narrative.
Right.
It's a yes or no question. And I don't want to get into this, but this tends to violate one of your motions in limine.
That shouldn't be said in front of the jury because I don't think he's right.
Okay, I'll overrule the objection. I think he's just given some basic issue or basic response, which I gave on the leeway on in the plaintiff's case in chief. You can respond.
I'll try to quickly move this. Look at paragraph 6.
Do you want me to finish my answer?
Yeah, please. I'm sorry. I get confused late in the day.
The whole point of a settlement agreement is parties have disagreed on something. They sign a document and they say, okay, we're going to put the terms in the agreement. Everything else is history now, right? I mean, there's a lot of legalese that you just heard, but the point is we are settling, we're going to move forward, and anything that happened in the past is done. It's all part of this agreement.
And then in paragraph 6 of the agreement, under entire agreement, and I'll try to cut some of this out by skipping. This agreement contains the entire agreement, and then move down, and supersedes all prior negotiations or writings. Have I got that right? Well, let me do it.
Yes, those
This
words are
agreement
in this
contains the
document.
entire agreement between the parties relating to the subject matter hereof, integrates all the terms and conditions mentioned or incidental to this agreement, and supersedes all prior negotiations or writings. Have I read that correctly?
Yes, sir.
Can you give the jury just a quick thumbnail of what that means in terms of why you would have a client enter into that type of agreement?
Yes, Your Honor, and we'd like to approach on this. I'm sorry.
John, hand me my cane. You don't mind. My cane.
Okay.
Hang on, Judge. I don't want. Fine. Great. All right.
Somebody that you represent. Game make hay.
Now, with me. That they made with you.
But it's still a good day.
And also, you make full. That's the master system. Let me see if I can just move forward. I'm more concerned with getting him back. Thank you, Your Honor. Not moving as quick as I used to, have you noticed?
None of us are getting any younger, Mr. Wood.
We can't get younger, can we? When you came away from the March 17th, 2020 deal, that was the deal, right?
There was a settlement agreement. It was signed on St. Patrick's Day, 2020. That was the deal.
And you had negotiated the deal to resolve all the issues between me and Wade and Grunberg and Wilson, right?
Absolutely. And I was proud that Mr. Beal and I were able to work together to get resolution.
I was happy. Strike that. So at the time that the March 17th agreement was executed, were you aware that Nicholas Sandman was a minor?
I don't remember if I knew it at that point, but I'm sure that someone told me that.
And as a minor, you're aware from your litigation experiences that if you settle a case for a minor, there has to be probate court approval in the appointment of a guardian ad litem to represent the interests of the minor.
I've actually never represented a minor, so I don't know. What you say doesn't surprise me, but I don't have personal experience in that.
You were aware that there was an anticipated probate hearing in the Salmon case, weren't you?
I was told that there was going to be a hearing in the spring, and that got postponed for a couple of reasons, as it was told to me. I think due to COVID, due to the fact that he was a minor, were explanations mentioned, but I wasn't involved in that case.
Did you ever hear anything that would suggest that I was involved in the delay of the case because of COVID, the probate court, and the date they set to finally consummate it on July the 24th?
No, I heard nothing to suggest that you were the driving factor in the date.
Now, I'd hired you and Joy to negotiate an agreement to share fees, right?
You hired us to resolve a dispute on your behalf with the plaintiffs.
Included fee splitting of some cases.
One of the provisions, yes, in section 1 of that agreement, as I recall.
At the time that the agreement was finalized, Rule 1.5 of the Georgia ethical rules was never discussed with me, was it?
Well, it was never discussed with me. And my understanding, that rule was never discussed with me. There was no conversation about Rule 1.5 in the March timeframe.
Mr. Beal didn't raise it with you, did he?
Mr. Beal never raised that with me in the March timeframe.
I had asked you and Joy to look into another matter that did also involve some issues about a fee with a lawyer named Cherie Fazell. Do you remember that?
You didn't ask me to be that was something that you talked about, as I understand it, with Joey. I wasn't a part of that.
And did you become aware that in the process of looking into that case, that issues were raised about Rule 1.5?
I became aware of that, yes.
And those issues were first raised in either late April or early May of 2020, right?
I don't remember the exact time frame. I do remember it was after this settlement agreement was signed in March.
And it then raised for the first time the question of whether.
Objection, Your Honor. We're
I mean,
still
let me
leading
withdraw
the
it.
witness. I've tried.
Right, but.
These are all leading questions. It's his witness.
Understood.
I'm trying to move it quickly.
I agree, and that's why I'm overruling the objection.
Thank you, Your Honor. So it was over a month after the March 17th agreement, or a little over a month, when the issue of whether 1.5 applied to this contract or not, that issue had never been raised before, had it?
Correct. Neither the plaintiffs nor you raised that issue before the signing of the settlement agreement.
And then with respect to the Cherie Fazell case, when it was realized that it was an issue that needed to be researched, your firm went in and spent time doing legal research on Rule 1.5.
That is correct.
And concluded that, well, strike that. Let me see if I've got it right, short fashion. That the question of whether the plaintiffs were in my firm was to be decided on the status of the plaintiffs as of the date of the fee sharing agreement. Do I have that
Objection,
right?
Your Honor. Now he's both testifying and leading. And
I'm not hearing him testifying. Essentially, if you want to, but on this minute point, this is kind of the core of the case. If you want to ask him more open-ended on this one, of the basis. Even then, we have already covered both of he and Mr. Burby's opinion,
And-
right?
I didn't cover with Joey. I don't know if John did. I don't think so. I'm just trying to, and it's in writing. I can pull the documents out.
Yeah, well, I think Mr. Exum read it to him, almost verbatim.
That you determine the status of whether someone is in the firm at the time of the agreement being executed, right?
So, is that, I mean, is that in the document?
It is.
I don't think it is, Your Honor.
Okay, all right.
Wood's theory.
Okay, to that point, if the witness can testify whether that was in fact the opinion he provided.
So our law firm created a memo. The memo was dated July 13th. And in the memo, there was a point made that some courts look at the date of the agreement as the time when you point to say, were these lawyers at the same firm on that date, the date of the agreement? And as I recall, that was included within the long memo that we prepared.
So lawyer A could associate lawyer B to assist in the handling of a contingency fee case and reach an agreement on how that fee was going to be divided, even if lawyer A and B are not in the same firm.
Objection, Your Honor. He's asking him to testify as an expert, ruled specifically
Yeah.
on this.
All right, you can talk about his opinion that he provided, but not just more generally to speak authoritatively or hypothetically on how at 1.35 might apply.
Do you handle any contingency fee cases?
I have never handled a contingency fee case to my recollection.
Do members of your firm handle contingency fee cases?
Maybe. It's a big law firm, as we've established. That's not generally the nature of our practice, although I do think in some business litigation disputes, there are agreements that call for a percentage of the award being paid as a contingency. It's not what I do. It's not my practice. And actually, now that I think about that, yes, lawyers at my firm handle contingency fee cases from time to time, but I don't.
And do they keep up with their time even though it's a contingency in case there's a problem and they get fired or there's a fee dispute?
Because I've never handled them, Mr. Wood, I don't know.
It would make good business sense to keep up with.
Objection, Your Honor. I was asking him to.
I must,
speculate.
excuse me, Your Honor, I'll move on.
All right,
I've done my best to avoid these constant interruptions.
all right, next question.
Were you aware that an agreement was reached between Todd McMurtry and CNN that would allow CNN to pay the money to Nicholas after he turned age 18 and was no longer a minor?
Not specifically, but my recollection is that the approval date for the settlement of that case got moved on the calendar to a date after Mr. Salmon had turned 18.
Did you have any involvement in that decision?
Zero. No, I didn't.
As my attorneys, are you aware of the fact that I had no involvement in that decision?
Yeah, well, to the extent that he has knowledge.
I don't know.
That's fine.
Do you know of anything that you do know of that said that had anything to do with the agreement between Todd McMurtry and CNN on when they were going to pay this for the money?
Same objection, Your Honor.
All right, overruled.
Mr. Wood, I have no understanding of how that happened. That wasn't part of what we were doing for you.
When did you even first begin to have to deal with Todd McMurtry?
What do you mean begin to have to
Well,
deal?
when did you first, you or Joey, when did you first begin to have conversations with Todd McMurtry? about the settlement agreement that had been reached between me and Jonathan Taylor and Nicole?
My recollection is late July of 2020.
Late July of 2020. So if you would, Chris, take a look at, is this trial exhibit 7?
They already have it in, I think it's.
I just need to know. The July 24th letter, y'all have it already in evidence? Under what number?
106.
So
Plaintiffs or defendant?
plaintiff's number 7, but it's admitted into evidence as defendant 106.
Other way around. Plaintiff's
Plaintiff's
106,
106.
defendant 7.
Plaintiff's version is unredacted.
Okay, I have plaintiff's 106 in front of me. It looks like an email from me to Mr. Beal, July 24th, with a letter attached.
Would you take a moment and look at the letter?
I see it. Yes, sir.
You've reviewed it before.
I have. Yeah. Yes.
And did that letter reflect your opinion and the advice that you gave me about the question of the fee split requiring client consent from Nicholas?
The second paragraph of this letter set forth the conclusion that we had reached as to Rule 1.5 and the need to go ask the client, Mr. Sandman, for permission to split the fee.
Did you understand that on the face of it, if you didn't get the agreement of the client at the outset, that the fee sharing agreement was void?
What we wrote in the memo?
It's 3 questions, Your Honor, and it's in the memo, but I don't want to dig it all out.
Well, what's the basis for the objection, Mr. Beal?
He's asking him to testify as an expert. It's only what's in the memo.
This is the
memo
advice he
doesn't say
gave
it.
me. I can.
Yeah, if it's, as long as it relates to the advice you conveyed.
Yeah.
That's fine.
So in the memo, what we did was we looked at the rule and then we looked at law that interpreted the rule. And this was a rule that exists in Georgia, but most states have a similar rule. Case was in Kentucky, they're in Georgia. So we looked both at Georgia and Kentucky to see if either state had a clear pronouncement of what the rule means. And neither state had a clear answer. So the Supreme Court of Georgia nor the Supreme Court of Kentucky had said this is exactly what it means. And so what we did is we did our best to read articles by lawyers that say, here's what we think this means. We tried to read cases that were similar but not exactly on point and come up with the best advice that we could give to Mr. Wood, explaining what we thought he should do. And what we told him in this memo dated July 13th is we thought you should go to the client, Mr. Sandman, seek his consent to split the fee, but not just say, hey, Mr. Sandman, do you want to split the fee? Say, I am recommending to you that you agree to let me split the fee. And we gave him that advice based on what we wrote in the memo, because when you enter into a contract, as we said in the memo, there's this duty of good faith and fair dealing. You should try to do your best to act in good faith. And so we said, Mr. Wood, we recommend that you go to this young man and say, I'm asking your permission to split the fee, and I am recommending to you that you say yes. That was our advice to Mr. Wood.
As opposed to taking the position without client consent, the fee splits pertaining to the blank cases in the settlement agreement are void. So given that there was no client consent at the time.
Objection, Your Honor.
Judge, this is so many times I've been rudely interrupted. It doesn't help you or me.
All right, setting aside whether, it depends if there's a meritorious objection. He has a right to make them. And so I think the way your question is currently phrased is, calling for a legal conclusion. Ultimately, I'll remind the jury again, you're the ones that are going to determine whether any contract was void or enforceable in this case. You can proceed, Mr. Wood.
Under your advice to me, I had 2 choices. One, I could take the position that the agreement to split fees was void, or I could seek to obtain client consent. True?
In the memo, we tried to lay out the law as best we could interpret it, given the fact that there wasn't a clear answer from the Supreme Court. And we advised you, as I just said, to go ask permission from the client. The risk, if you didn't do that, is that you would be violating a rule of ethics, which is not a good thing for a lawyer to violate an ethical rule. And as we put forth in the memo, and as I understood it at the time, the point is the client should have a say in what happens with this. It shouldn't just be the lawyer making a decision. Hence, we said, we recommend that you go talk to Mr. Sandman, tell him he should consent, and see what he says.
Would you agree that was the prudent thing to do?
That was what we conveyed. Yes, that was what we conveyed to you in the memo. That's the prudent thing to do. It's an uncertain thing. Be conservative. That's what we suggested.
If I don't do that, I walked myself right into a lawsuit, haven't I?
You've potentially walked yourself into a bar complaint, a lawsuit, or some bad situation. Yes.
And I followed your advice, did I not?
You did. And what specifically, you directed Mr. Burby and me to talk to the lawyer for Mr. Sandman and present a document that we had prepared on your behalf that was consent. And it made clear as we drafted it that this was something that Mr. Wood was asking him to consent to.
And in evidence now is the complete affidavit of Nicholas Sandman, which I read earlier today. I won't reread it now to save time. Am I right that you and/or Joy spoke with Nicholas Sandman in Todd McMurtry and drafted the affidavit of Nicholas Sandman that subsequently was signed on February the 8th of 2021?
So you're right that our law firm drafted an affidavit after talking to Mr. McMurtry. The part that was wrong is I never spoke to Mr. Sandman. Mr. Sandman had his lawyer, that's Mr. McMurtry, and my practice and my understanding of the rules of ethics say that when someone has a lawyer and I'm a lawyer representing a client, I don't just go talk to that guy without his lawyer present. Instead, I talk to his lawyer, and then his lawyer talks to his client. So we spoke to Mr. McMurtry, who, as we understood it, spoke to the client in order to make sure that we were following what we thought was the right ethical approach.
And at the time that the settlement was consummated, July the 24th, had you and/or Joy supplied Mr. McMurtry with a consent, a form that says that I asked Nicholas to consent to the settlement?
So the settlement was consummated on March 17th. You just said July 24th, so you
Well,
just misspoke.
our agreement was, but I'm talking about now the settlement disbursement to Nicholas Sandman. That was on July the 24th. And had you provided Todd McMurtry with a statement that said, and this is in the record, I have reviewed the settlement agreement and mutual release between L. Linwood PC and Linwood on the one hand, and then the various Wade, Grunberg, and Wilson parties on the
Objection,
other.
Your Honor. I think he needs to identify whether he did anything before we read it into evidence.
It's already been read into
According to
evidence.
the memo, I think that's already in evidence though, right?
So we prepared, that's the statement that you're reading from, and
Yeah.
gave it to Mr. McMurtry so that he could give it to his client. Yes.
And one statement again says, Nicholas could have agreed. It says, Todd V. McMurtry, my legal counsel, has indicated that L. Linwood request that I consent to this agreement. Accordingly, I hereby consent to this agreement. That was the language prepared for him to consent if he chose to, right?
Correct. And my understanding is he didn't.
He did
So he
not.
never signed that, but that's how we drafted the document to be presented to him.
And that led to your letter of
July 24th.
July 24th to Mr. Beal.
Correct. I sent the letter to Mr. Beal dated July 24th. That's Exhibit 106 at your request.
But I didn't tell you what to say in it, did I? It was done on my behalf by you, right?
Yes, but in fairness, you're not shy about letting us know what you're asking us to do, right?
And I wasn't shy about telling you that I wanted this matter settled with these people, was I?
Correct, and that's why the settlement agreement was signed by you and the plaintiffs on March 17th.
And I wasn't shy about telling you when the issue of client consent came up, I wanted the client to consent. I wasn't shy about it at all, was I?
That's fine. Yeah, we're getting close, if not already over that line, Mr. Wood. Let's move on or rephrase.
I wasn't shy in telling you and conveying to you that I wanted us to take the steps to get the client.
That's the exact same question, Mr. Wood.
Did I not? So let me try. I told you to do what you could to get into consent, didn't I?
Correct. We did the research that you requested. We gave you the memo. You reviewed the memo. We spoke to it, and you followed our advice when we advised you that we should go to Todd McMurtry to ask Nicholas Sandman to consent.
So was it clear to you that I was asking you to take the steps to make the agreement valid to resolve the dispute?
Yes.
I wasn't on July the 24th saying anything to you that would have led you to believe that I wanted to blow up the agreement. That didn't happen, did it?
It is correct that you didn't say something to me that led me to believe that you wanted to blow up the agreement by the position that we were taking on Rule 1.5.
Right. In fact, it was consistent with someone that wanted to get the agreement done. True?
I mean, at this point, I think we covered this at the very beginning of the direct. We've covered it again. I think we've covered this ground. So I'm going to ask you to move on as cumulative.
Yes, Your Honor. Do you recall when you next had occasion to write? Well, did you get a response from Mr. Bill?
As
to
I
your
recall,
July 24th letter?
I apologize for cutting you off.
Fine.
As I recall, I sent that letter on July 24th. It took a couple of weeks, but Mr. Beal wrote me back, as I recall, on August 7th. And then I responded a couple days later, maybe the 10th of August.
And Mr. Bill wrote you back. I've got a letter here by email, August 7th, 2020. You have the number?
That sounds right.
Yeah. I think it's Defense Exhibit 8.
And it may already be in evidence. I don't want to put it in twice. Did you have it as a plaintiff's exhibit? And Mr. Bill,
I have Defendant's Exhibit 8, which is Mr. Beal's August 7th letter.
thank you. So was it clear from the first couple of paragraphs that Mr. Bill disagreed with the opinion regarding 1.5?
Yes.
And then on the first paragraph, the last paragraph of the first page, he says, in light of the clear inapplicability of Rule 1.5E, and it wasn't clearly inapplicable at all, was it? In fact, you thought it was applicable.
It was not at all clear that it was inapplicable.
But then he goes on to say, in light of the clear inapplicability of 1.5, it appears that your client is simply declining to make payment in bad faith and in keeping with the repeated statements he would never pay my clients one thin dime and would destroy their careers. Have I read that correctly?
Yes, sir.
Were you aware of when those types of statements were made when I was upset with these folks in February of 2020?
My recollection from talking to Mr. Beal in March of 2020 is at that point he mentioned statements like that. And so it was before March. So I think February-ish. But again, I wasn't there for those statements if they were made. But I do remember Mr. Beal pointing them out.
Did you think that I was trying to get you and Mr. Burby to assert Rule 1.5 because I was acting in any way in bad faith?
No, my recollection is that it came up in the context of another lawsuit, and it was then an issue that you asked us to look into in the context of this lawsuit, and which led to the July 13 memo and all the other documents that y'all have seen.
Yeah, the next letter.
Okay. August 10th. It's right there.
You have August 10th.
It's
Drew?
it's exhibit 9.
Yeah, but and do you have the August 10th letter in your plans exhibits? So it's our exhibit what?
9.
9.
Nine has been admitted.
Can you turn, I'm sorry.
I believe D9 has been admitted.
Yeah, that's right. We did.
So can we agree that defendant's 9 is admitted?
It's already been admitted.
You have defendant's 9 in front of you?
I do, yes, sir.
Would you briefly describe for the jury what defendant's 9 is?
This is a letter that I wrote on August 10th of 2020 in response to the August 7th, 2020 letter from Mr. Beal. It was my letter to Mr. Beal responding to his letter to me.
Would you read what you stated in paragraph 2 of that letter to Drew Bill?
Turning to your letter, the position that your clients are taking is surprising, to say the least. The allegation of fraud is completely baseless, of course, but it's more than just that. Making an accusation of fraud against Lynn is yet another in a long line of bad faith threats that your clients have made in an effort to shake Lynn down for money. The problem they face is twofold. First, Lynn.
We approach on this. I think it's 403.
It's in evidence.
I mean, it's already been admitted, I guess, to the extent I think that would have been a time to make the objection. So I'll let him finish reading the paragraph.
May I continue, Your Honor?
You can continue.
The problem that they face is twofold. First, Lynn will not be extorted. Second, the rules of professional conduct prohibit the payment they are demanding in the absence of client consent. Lynn will not violate the ethics rules of our profession. For that reason, even if Lynn wanted to give in to WGW's demand just to make this go away and to protect his own clients to whom he is so devoted, he could not split his fee in the blank cases without blank consent. The names were taken out of this version. Okay. Lynn acted in complete good faith and sought that consent. Blank declined to give it. And whether we like it or not, blank has the absolute right to withhold his consent.
Thank you very much, Chris. Hold on. Without going back and reading it again, here you also again reiterated your request that Mr. Bill and his clients provide documentation about their work. True?
Yes, sir.
Did you ever receive anything from Mr. that would have been documentation as to their work, despite the repeated requests that you and Joy made?
We did not, no.
And then if you look at page 2, would you read the first paragraph in your letter of August 10th? And I believe it's defendant's 9, right?
Yes, yes, sir.
Would you read that?
Yes.
Read that first paragraph.
Your client's allegation of fraud and malicious intent are legally wrong, but more than that, they are also offensive. Lynn is steadfastly devoted to his clients and to the truth. Contrary to your argument, Lynn is not, quote, simply declining to make payment in bad faith, close quote, or in an attempt to, quote, destroy your client's careers, close quote. As your clients know, the opposite is true. Through an extended period of mentorship and co-counseling on cases that came into Lynn's firm solely because of Lynn and his reputation, Lynn has helped to build the careers of your clients. The mentorship and support from Lynn have continued during 2020, despite the false accusations your clients have made against Lynn, and despite the dispute that arose and that we settled. As just two examples, Lynn offered to provide your clients with a line of credit in the amount of $500,000 to support their legal practice. And he has also referred a number of defamation cases to them. Those and other actions reveal that Lynn wishes to support your clients' careers, not destroy them.
Thank you, Mr. Marquardt. Your Honor, would it be okay if we adjourn for the day? It's 5:15. It'll give me an opportunity, and I need to get off my feet, candidly, Judge.
Well, you can question him sitting down. Honestly, I think we need to get through this direct.
Well, if I get the opportunity, he's going to have to, we're going to take a break before the cross. And I'm asking the court if you would consider doing it now. That'll give me time to hone down and try to be more precise on the remaining questions that I have. So it benefits by being able to limit my direct, shorten it, and then it gives Mr. Beal time, hopefully, to think about what he said today and hone his cross-examination down. And as much as we hate to have Mr. Marquardt come back tomorrow, I'm asking for the court's consideration to go ahead and adjourn for the day. And I'm not going to bellyache about my legs, but they're hurting, and I would like to. I can sit down. It's not going to change the pain.
Okay, well, Mr. Wood, let's do this. You can take a moment, but he's been on your witness. This is the direct. I need to know what other ground you want to cover and how much that time that's going to take.
And that's what I'd be able to hone down overnight if
Yeah.
we break now. If you ask me to do it now, I'm going to have to err on the outside time limit. I'd like to be more accurate and make it shorter. I'd like to tell you it's going to be 30 minutes instead of an hour. If I have the time overnight to look at it, I think we're going to find it's going to be a lot shorter, but I need to be able to look and see what he said, what he needs to say, and hopefully cut it to the chase. And I think I can do that more effectively if you give us a adjourn now and let me have time to work on it. He's got to come back anyway. Sorry, Chris. And so I would ask Your Honor to let us adjourn and go home and get busy and come back here tomorrow and hopefully be more concise and get this thing moving. Thank you.
Your Honor, we would oppose it. We've got to move things along, and we would stick with Your Honor's plan. My cross-examination of him is going to be brief. I'm not going to go over all the stuff I went over with Joey. That's been done.
I mean,
It's been an hour and 30 and haven't hit.
I think we need to go at least another 15. Mr. Wood, we're so behind at this point that I think we need to keep going. And I'm going to have to start getting a little more, it's sort of if we're covering the same topic twice. So just if there's another topic that comes to mind, we need to use the time.
All right, we'll mush on. Your Honor said for 15 minutes?
Yep.
Is that right?
That's right.
Thank you. Do you have the letter of February 3rd, 2021?
Yes,
And what is that marked as? Defendant's Exhibit 22?
that's
It's Defendant's Exhibit 22 in evidence, Your Honor.
It is.
Right. Chris, would you turn, if you got it in front of you?
Yes, sir.
Now, you familiar with this letter?
Yes, sir.
You didn't write it, but it was copied to you by Joey Burby, right?
That is correct.
So you would have read it, true?
Absolutely. Yes.
And if I might ask, who is Stephen M. Collins?
So Steve Collins is a retired partner of our law firm. He was our internal general counsel at the time. So he's the lawyer for the law firm at the time.
Would you turn to page 2 of that letter?
Yes, sir.
And this was, again, February the 3rd of 2021.
Yes, sir.
And at this time, you had received the original complaint that Wade, Grunberg, and Wilson filed against me.
Yes, that was months before.
The details in that complaint, you were familiar with them, what they claimed,
Sure, I read the complaint that they filed against you.
and filed a motion to strike what you consider to be heinous, salacious, redundant, immaterial.
Yeah, I don't know why that is
I'm
relevant.
sorry.
A motion to strike and pleading practice and that,
They've been talking about it. The plaintiffs.
well, I'll hear the question first. Feel free to ask a question.
You filed a motion to strike portions of that complaint, didn't you?
That one I don't remember, but I mean, if there's a court document on file that we filed, sure, we filed it.
Do you recall the judge's order not striking?
No, I don't think
All
we
right,
go down that road.
that's why I wanted overnight. I'll just bring the order and we'll address it tomorrow.
Well, I don't think we should be going into court orders and legal rulings that don't.
It would be relevant. The findings about that complaint.
No, I don't think that it would be, Mr. Wood.
Well, we'd have to be able to argue that at the right time. We haven't had a chance to argue it yet.
All right, next question.
We'll come back to that. So look again at page 2. And you'll see in the second full paragraph down, you make reference to, I posted some information on Telegram about your conversation with the General Counsel of the State Bar of Georgia, right?
But when you say you mean Joey, who wrote this letter.
I'm sorry.
But, yeah.
Well, it says we learned, so it's referring to you and Joey.
That is true.
And so it's right. You and Joey learned that I had posted something on Telegram about a conversation I'd had with you regarding the General Counsel's comments from the State Bar of Georgia.
Correct. So this is the letter that terminated the relationship between our law firm and you, and it went through various reasons why we decided to terminate the relationship, and that was one of the points that we raised.
And you said, we do not practice law by social media, and it greatly concerns us that you would post about a confidential conversation with counsel. And that was referring to your conversation with me about your conversation with the State Bar of Georgia's General Counsel.
Correct.
State Bar of Georgia had contacted you to see if you would cooperate with them.
Objection.
I just am going to quit asking questions because I can't even get a record to finish my question when I'm repeatedly interrupted. It's not right, Judge.
Well, some of them I've sustained, some of them overruled, and I think that's just how these work.
Well, you got to ask the question to make a record. How is the appellate court going to know whether you ruled correctly or incorrectly if he objects halfway through my question and I don't have the right to get the full question on the record?
If to the extent we need to do that, that's where we would approach not to inject.
I'm sorry?
If there's something in the premise of the question that's going to reveal the facts that might be excluded, we would approach and lay that. If you need to make a proffer at any point that I've overruled them without you getting the question out, you can make a proffer by approaching. At this point, though, the objection is to something the State Bar communicated to him, and I guess the objection is to hearsay. And so, if you want to respond to why that is not hearsay or how that still weighs into this. We did address a lot of this with Mr. Burby.
Well, I have a right to put up a defense, whether it's Mr. Burby and Mr. Marquardt. They were both involved. I can't be cut off because I've got two witnesses. Look how long they've taken. They took 4 days last.
I understand. So
So I'm not trying to do anything, but remember me, I'm the guy that wants to get back home to my dogs in South Carolina. So I'm not here to prolong this trial. So I can't make a record when the question that I'm asking is interrupted. Now I don't even remember what it is.
Okay.
Let me go
Just
back. It doesn't matter,
Going
Judge.
forward, if I cut a question off that you feel like you want to make a record for, you can proffer it by approaching and asking the question then, just FYI.
Thank you very much,
All right,
Judge.
next question.
That's very fair. So look down the part where I was reading and it gets to, "We want you." Do you see that?
I do.
Would you read that sentence starting with "We want you"? Would you read that sentence from your letter or Joey's letter? That one sentence, would you read it?
So the sentence after we told you we did want the case tried in social media.
Yes.
We want you to win your case against the plaintiffs because we have believed and still believe that your position in this case is true and right. But we also believe that you deserve to have lawyers representing you whose loyalties you do not question and whose philosophy of litigation you share.
And that was going to the question of court of public opinion versus not philosophy of litigation, right?
That's the philosophy of litigation. That's not the loyalties that you question. That was a different point earlier in the letter.
The bottom line is, as of February the 3rd of 2021, based on everything that you had learned from the time you first began to represent me in early March of 2020, you stated that we want you to win this case against the plaintiffs because we have believed and we still believe that your position in the case is true and right. Have I read that correctly?
You did. And our point was on the substance of the claims.
Overruled.
On the substance of the claims, we believe that your position was right. Stylistically, we had stark differences.
Styles as lawyers.
Correct. The trying a case in social media, et cetera. That stylistically, we felt very differently about that.
Although you will admit that I had great success for clients by trying their cases in the court of public opinion. You know that, don't you?
We covered that, Mr. Wood. Next question.
Simple yes or no. You know that, don't you, Chris?
Well, I said we already covered it, so I'm trying to keep things moving. Next question.
Were you familiar with the press release that you helped me prepare that I issued after their lawsuit was filed? I believe it was filed on August the 5th of 2020. They had sent the draft. They didn't want them, they refused to arbitrate, and then they filed the lawsuit.
I remember your press release.
And you assisted me in preparing.
You drafted it, we looked at it, you sent it out.
Right. I drafted it. You looked at it, said, okay. I mean, it may not have been your words, it were my words, but you didn't look over and say, don't say that, did you?
I don't remember what we said.
Do you remember the massive publicity that went out in Atlanta and the state of Georgia and literally around the nation when that lawsuit was filed? I'm sorry, I'm frustrated. This is
I understand.
so rude.
I understand. All right. At this point, members of the jury, I think we're close enough to 5:30. We're going to break for the day, and I'll ask you not to discuss the case, including amongst yourselves, and don't do any research about this case. I think there is, I'll just give you a note on sketching out the rest of the week. I think there are still decent odds that the case will have closing arguments on Wednesday, and the case will be submitted for your consideration on Wednesday. At what point that happens on Wednesday, I don't know. And when it's in your hands, it's up to you. It can be 5 minutes, 5 hours, 5 days. We're on your time. But because it may go into Thursday, because of that, I would ask when you come back tomorrow, if any of you have, because I didn't ask you about any scheduling conflicts on Thursday, if there are any of those that you want to raise with me, we'll do that tomorrow morning. So if you could be back here, everyone can be back here ready to go at 9:15. If anyone has any conflicts they think they want to bring up on for Thursday of this week, be here at 9 and we'll take them up then, okay? All right, your excuse for the day.
All right.
All right, sir. You can step down. I'd ask that you be back here ready to resume at 9 o'clock tomorrow morning, okay? Thank you.